Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Good morning, my friends. Today is Friday, June 6th, 2025. And we are back for whatever fresh hell awaits us today. Day 28 of the re-persecution of Karen Read in the Upside Down, Inside Out Hunger Games, Narnia. That is Norfolk Superior Court in good old Massachusetts, where your constitutional rights go to die. How is everyone this morning? I was so fakakta yesterday with I thought, because we had the day off and I had to do a bunch of stuff. So I'm sorry I couldn't find something to entertain you guys with, but my cat had to go to the vet last minute. It was a whole thing. She's doing well. She's doing well. So that's good. After a little infusion, she needed some hydration. It was hot yesterday, but not as hot as I think it was in Norfolk County. And that is why there was no court yesterday. But the whole day, because of that day off, I was thinking it was Sunday and today was Monday. I don't know. I'm losing the days. The days are blending together. Anybody else? Anybody else planning their whole entire life around this trial? I'm not sure what awaits us today, but it might be a good surprise. I'm not really sure, but I think we're going to see some expert witnesses today. Let's put the fan up so everybody doesn't get all freaked out and we're missing something. We're supposed to start at 9, but you know how it is. Time drifts, clocks are off. And so who knows what time it is, really? Does anybody really know what time it is? Does anybody really care? That's on the playlist. We have a mixtape, Karen Read Retrial mixtape playlist on Spotify. You can find it in the show notes below. Oh, Larry's there today. Larry DUI guy. I don't know. I heard it could be Crash Daddy Friday. I heard there might be a Crash Daddy on. I don't know. And I heard maybe Dr. La Posada. I'm not sure. So we'll see. We will see. What are you waiting for today? Oh, I think she may threaten to shut off the air conditioners today if everyone doesn't. Yes, I know Larry Foreman is in court today. Larry Foreman is in court today. Larry Foreman is in court today. The DUI guy, Larry Foreman is in court today. Yes, 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 yes. Yes, the thumbnail picture. So here's the thing. So you know that when I was on Peter Tragos, and I've said this other times too, it wasn't just when I was on with Lawyer, he said, do you think she could have got back to One Meadows after if the collision, the alleged motor vehicle accident was at 12:32, we know she connects the Wi-Fi at 12:36. And I said, yeah, if she was driving chitty chitty bang bang, maybe, because Jennifer McCabe testified in season 2, this particular trial, that it's a 10-minute ride from One Meadows to 34 Fairview. And so unless she's driving Chitty Chitty Bang Bang, which was my favorite movie as a kid, and that was back in the day where you had to wait for it to come to the movie theater, and every year it would come. I forget if it was around Thanksgiving or Christmas. But that child catcher in Chitty Chitty Bang Bang really freaked me out. And somebody sent me, I don't know if they commented on the video or if they sent me an email and said, Hank Brennan really reminds me of that child catcher from THC Bang Bang. And now I can't unsee it. So I put his picture on the thumbnail for you as a little tongue-in-cheek humor for this Friday before we head into the weekend. And so I like if some of you liked that, or you got it. If you got it, you got it. We think in song lyrics here, a lot of movie quotes going on here, a lot of pop culture, and it's not just legal analysis, as we like to say, but it's also some comedy, some humor, because if we don't keep laughing, we're just gonna cry all the time. The chat is called the Snark Tank for a reason. They keep me laughing, and I'm so grateful for that. I know you have so many places that you can watch your Karen Read Retrial coverage, and I'm so honored and truly grateful that you choose to spend your 8-hour days with me. Dan 1, can the defense offer immunity to a witness? No, the defense does not have that power. None whatsoever. That is a great, I see you're from outside the US, so that is a great question. No, the defense cannot offer immunity to any witnesses. Lynn, thanks for becoming a member, as did 2 Lynn's. Look at this, 2 in a row. Lynn Banyas and then Lynn Clark. 2 Lynn's in a row. Good morning, Julie. Hope you had a good day off. Mel in chat reporters, the crash daddies are in the courthouse. LFG. I don't know, but I would like it if they didn't, look, they can do whatever they want. And I'm never, ever going to second guess the defense team. And I'm never going to ever say, I would have done it this way or I would have done it that way. I'm just going to give you my thoughts on what I think and how I think the witnesses are coming across. And, I'm going to explain the procedure to you and what goes on and what should perhaps go on in a different courtroom. I'm a New York lawyer, have been so for over 3 decades. And so New York is a lot different than Massachusetts. And we watch a lot of trials. Florida is also a lot different than Massachusetts. Florida allows the jury to ask the witnesses questions, which I find fascinating and scary at the same time. There is a little known rule in Massachusetts, because somebody sent it to me, that says it's within the judge's discretion for the jury to be able to ask questions of witnesses. And so could you imagine if the jury was allowed to ask witnesses questions of these witnesses here? Usually in jurisdictions that allow that, the question is written down and it's sent up to the bench, and then all the lawyers come up at sidebar and discuss with the judge which ones are allowable and which ones are not. Julie, I hope you're right, because that would make a nice Friday before we go into the weekend. Margaret, good afternoon. Larry, DUI guys in court today? Yes. And Slinky says that too. Pumped. Larry's at the courthouse. That's fantastic. Wonderful for him. Irish Mima. Yes, every day my daughter asks if it's over because you're planning your life around the trial. That's amazing. Okay, Welcher's Blue Man Group. That is a fantastic username. You guys are getting really creative with your usernames, and I love it. Richard Green and Crash Daddies in the building today. Saw them walk in. There had been some rumblings, I don't know, over the past couple of days that perhaps the defense was not calling Richard Green. I don't know who started those rumors. But if it's being said that he's spotted in the courthouse, that's good, because we need somebody to confirm that 227 search. Because if the jury believes the 227 search made by Jennifer McCabe at Hostelong to Dying Cold, it could be game over. Could be game over. I mean, it should be game over, because there's no evidence that there was an actual car accident. There's no evidence that an actual vehicle, a 6,000-pound Lexus, struck the body of John O'Keefe. Just doesn't exist. We heard Dr. Russell say the other day, and I went back and I listened to Irene Scorti-Bello's testimony, the medical examiner. She did say that she examined the legs and she found no fractures. What Dr. Russell told us is that not only did she examine the legs, she opened up the legs. So when all those people on the other side were squawking, they didn't x-ray his whole body, we don't know if there was fractures. No, she actually opened up his legs. All right. Live court is on a short break. It just started, literally. But, here's David Yannetti on why do they have David Yannetti's Chiron up? Are they testing the Chirons? Little Trucker, thanks for becoming a member. Oh, thank you, Excited Utterance. Be a compliment. I'll take it. I'll allow it. Thank you, Leanne, says Richard Green is there today. Make sure everyone sees Auntie Deb's Dever video. Is that the one from this morning? Because I was just listening before I came on.
Hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in dedum within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
God save us from the Commonwealth.
Good morning, Council. Good morning, Ms. Reed. And good morning, jurists.
What the jurors in here?
So happy Friday. I do have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday, day before? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into the case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left the other day? No. Everyone said no or she. Okay, I understand we have a witness this morning.
We do, Your Honor.
Okay. Yes.
Dr. Dan Wolfe.
Okay.
Crush Daddy with the dimples, Dr. Daniel Wolfe from, he's the wolf with an E, right? From ARCCA.
But we'll see how.
Somebody has the username Dr. Wolfe's Dimples. And it's, if you haven't seen him, you're in for a treat. He built a cannon and it was awesome.
Yes.
Good morning.
Good morning.
And so, sir, we're going to try and keep the keep the air conditioning on this morning. So I'm going to ask you to speak really loudly into that microphone. And Mr. Jackson, you do so as well, please. Okay.
Oh, glory
Your
day.
Honor. Dr. Wolfe, could you please state your entire name and spell your last name for the jurors, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
May I inquire, Your Honor?
Yes.
Dr. Wolfe, what do you do for a living, sir?
I am the director of accident reconstruction at a company known as ARCCA, A-R-C-C-A.
And I'm going to start right off the bat. Get really comfortable with that microphone. It's adjustable. Pull it right close to the area of your chin. It's really loud in here.
Okay.
Dr. Wolfe, you said you work for ARCCA, A-R-C-C-A. What is ARCCA?
ARCCA is a forensic engineering consulting firm. We have a variety of disciplines: accident reconstruction, which is the group I'm a part of, biomechanics, failure analysis, and crashworthiness.
And you said that your title again, one more time?
The director of the accident reconstruction team.
And what sort of contracts does ARCCA normally engage in routinely?
So in addition to our forensic consulting work, we have, going back in time, we've dealt with doing contracts with the Department of Defense, where we designed energy-absorbing seats for MRAP vehicles, mine-resistant armored protective vehicles, where these vehicles were going over explosive devices, and the energy from those explosions was going through the vehicle into the occupant. So ARCCA designed energy-absorbing seats to help mitigate the injuries in that type of in those types of incidents. We also do work for the National Hockey League. I myself am part of that work. It has to do with scanning and analyzing player pads, but we certainly do impact testing and help set guidelines for player safety.
With regard to those MRAP vehicles, was that contract for the Department of Defense for the United States government?
Yes, sir.
For the military?
Correct.
Is ARCCA both nationally and internationally recognized as a leader in accident reconstruction?
Objection. Sustained.
Does ARCCA have a reputation, or let me ask it this way, does ARCCA entertain or engage both domestic and international contracts and clientele?
Yes.
As the director of accident reconstruction, do you specialize in anything other than just accident reconstruction, anything having to do with human factors?
Yes, so my other specialties in addition to accident reconstruction are lighting and human factors.
What is, give us a 25-word overview of human factors. What is that?
So to give you a good example of that is, and again, this is a case that I commonly see, but let's say you're driving down the road at night. It's an unlit roadway. You're relying on your vehicle headlights to see the roadway ahead, right? And you've got a pedestrian that is entering the roadway. And you want to have an understanding based upon the lighting conditions, how much sky illumination there is, their clothing, right? When would a driver recognize that individual on the roadway? So that's where it starts from the vision aspect of human factors. Then we get into driver response, right? So the driver is presented with a hazard. So how do drivers typically respond to that? What are their actions and how long does that take to avoid and initiate a reaction?
That's human factors. Can you do the same thing and give us an explanation for accident reconstruction just in the broadest sense? What is that discipline?
I think a very simple definition of accident reconstruction is the application of physics and engineering science to collision events.
What role do you take as the director of accident reconstruction for ARCCA as contracts come in or engagements come in?
Well, my scope and cases can vary greatly. As I just mentioned, I could have a case where I'm assessing the conspicuity of a pedestrian and a driver's response time. It could be a 50-car pileup on a highway, and I'm trying to figure out a sequence of events. It could be a rear-end collision where a seat back has failed in the vehicle and the occupant has sustained injuries, and we want to have an understanding of the crush, the damage, the forces. So again, it can vary case to case.
Do you engage in reconstruction or attempt to engage in reconstruction of all sorts of passenger vehicles and commercial vehicles?
Yes.
What about motorcycles?
Yes.
Bicycles?
Yes.
Involving pedestrians and sometimes involving no pedestrians?
Yes, I see all types of collisions.
How many cases, if you have a number in mind, have you been a part of in terms of engaging in accident reconstruction broadly?
That's something that I don't track, but I've been with the company now for over 8 years. So at this point, if I had to estimate, it's well over 1,000 at this point.
What education, training, and background do you have that allows you to perform the duties that you've described for these jurors in terms of accident reconstruction and human factors analyses?
In terms of, are you looking at additional training?
No, let's start with your education. I want
Absolutely,
education, training, and background, but we can do them in order.
Okay, yeah. So,
The captions aren't blocking his face, but I'm not a cupcake. Can't make everybody happy. I do my best.
So we'll go back to 2012. I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses included physics, statics, dynamics, thermodynamics, fluid mechanics, your engineering sciences. Subsequent to that, I then went on to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics. Some of my coursework while doing my PhD included optoelectronics, semiconductor physics, basically how to guide light on semiconductor devices.
Did you write a dissertation to get your PhD?
Yes.
What was the subject matter broadly of the dissertation that you drafted?
So my dissertation focused on a technology called smart glass. So you may have seen this technology where if you've seen a pane of glass that is transparent, somebody flips a switch and it goes opaque. That's a type of smart glass technology. So my PhD involved developing a new type of novel, what we coined optofluidic smart glass. So we are using geometric structures that we've optically designed to create a very reflective surface or medium, if you will. And then through the introduction of various fluids, we can then modulate the amount of visible light and electromagnetic energy that is passing through or being reflected. So not just visible light, but also energy that you can't see. As part of that process, I ended up prototyping these structures with a 3D printer that was capable of printing 3D printable polymers. And as we kind of got towards the end of my work, we looked at how we could scale this up on a larger scale. And we ultimately ended up researching and doing tests with a material known as polymethyl methacrylate, which is PMMA or acrylic.
What relevance does PMMA play in terms of this case?
So with respect to this case, the outer lens and the clear plastic diffusers of the taillights on the Lexus are comprised entirely of polymethyl methacrylate, or that PMMA material.
The same material that was the subject of your dissertation?
Correct.
How coincidental is it that he wrote his dissertation on the exact material that makes up the taillight of Karen Read's Lexus? I mean, it's like that it was meant to be.
What additional training and experience do you have as it relates to accident reconstruction beyond your BS and your PhD?
So certainly the 8 years of work that I've had at ARCCA has certainly trained and taught me a lot over the last 8 years. Like I said, I've seen hundreds of collisions, all different types of accidents. But in addition to that, I've continued to take courses through Northwestern University in crash reconstruction, human factors and lighting, heavy vehicle forensics, heavy vehicle EDR downloads, Bosch data retrieval and black box downloads, photogrammetry, so a number of continuing education.
Are you accredited as a traffic accident reconstructionist?
Yes.
By whom?
An organization known as ACTAR.
Is that a nationally recognized organization?
Yes, sir.
What does that stand for, ACTAR?
The Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry?
Yes.
What is photogrammetry generally?
So photogrammetry is the science of extracting and measuring information in a photograph. So you don't actually have to physically inspect something to be able to get information about its measurements or where things are spatially. You can do that from a photograph alone.
Is that an accepted methodology in the field of accident reconstruction to use photographs and or videos without actually having been at the scene during the course of the crash?
Absolutely. It's very common.
You mentioned Bosch. What is the Bosch crash data retrieval analysis? What is that generally?
So generally, most modern vehicles on the roadway now have what's called an airbag control module, or more commonly known as a black box, which can contain crash-specific data in a collision.
Are you a member of any professional societies?
Yes.
Can you describe those for us, please?
So I'm a member of the Society of Automotive Engineers, the National Association for Professional Accident Reconstruction Specialists, the Illuminating Engineering Society, and the Optical Society of America.
Is it fair to say that you've authored a number of peer-reviewed papers in the field of physics and or accident reconstruction?
Yes.
Can you describe that for us?
I'm sorry, Judge. Are we boring you? The judge is flipping through papers right now. She's flipping through papers like she could. Maybe she's just trying to keep her eyes off of Dr. Wolfe because of the memes that came out last year, season 1. You think?
For us.
So my most recent publication in the field of accident reconstruction deals with vehicle control history records. Publications prior to that were focused primarily on my dissertation PhD work.
I think you testified that you have dealt with probably over 1,000 different types of cases. Are you able to estimate of those 1,000 different types of cases dealing with accident reconstruction, how many of those or what percentage of those have involved pedestrians?
I don't know if I can give a percentage. I would certainly say it's the majority of my casework. As I mentioned earlier, given one of my specialties being in human factors and lighting, there's a direct correlation between time of day and pedestrian collisions. We certainly see a rise as sky illumination drops and the illumination levels go down. We're having to rely on artificial light sources. So given that occurrence happens in nighttime hours and low illumination, like I said, I certainly see many pedestrian accidents.
What types of pedestrian impacts have you been involved with in terms of your analysis or evaluations?
All different types, everything from pedestrians being run over, running into the side of vehicles, being hit by the front of a vehicle backing up in a parking lot into a pedestrian. So I've seen it from all sides of a vehicle. What is
kinematics? Can you describe that or explain that phrase or term?
I think a simple definition would just be the motion of an object or a body.
Have you done any testing as it relates to kinematics and the interaction between pedestrians and motor vehicles?
Yes.
How many times have you engaged in such an analysis?
Numerous times. We frequently and routinely do testing at ARCCA.
You mentioned ARCCA has several different disciplines within it. What are some of those different disciplines in addition to accident reconstruction?
So, as I mentioned, we have biomechanics and crashworthiness, and there's a few others. And I will note that it's very common in our casework that we will work together as a team. So to give you an example of that, I mentioned earlier about, that rear end collision, right? So let's just say we have a rear end crash and there's crush and there's damage to the rear of the vehicle and the seat back failed, which caused the driver to ramp up in the seat and ultimately hit their head on something and sustain an injury. So I myself, as a reconstructionist, will analyze the forces, the speeds, and the severity of the crash. The biomechanist will evaluate the mechanism for the injury based upon those crash forces. And the crashworthiness expert may analyze, okay, is there a better or stronger seat that may have held up in this crash?
Is it normal for you as the Director of Accident Reconstruction at ARCCA to work with others in the other disciplines that are housed under the umbrella of ARCCA?
Absolutely, yes.
Is that a normal process for you?
Okay, camera person, I dig that you have a hard job, but we really want to see the witness today. Like, happy Crash Daddy Day to those of you who celebrate. We don't need to be focused on Karen right now, and he's been focused on her for an awfully long shot. Can we please get back to the witness? Thank you.
Very common, yes.
As a matter of fact, it probably would be uncommon if you didn't do that, correct?
Depending on the kind of case, but yes, certainly wouldn't be uncommon.
Tell me about the testing that you've undertaken to determine forces that are at play in a given accident or an impact.
Okay. So to give you a simple example of it is, let's just say we have a sideswipe type collision where two vehicles sideswipe each other and a front bumper gets torn off or deflected essentially, and there's some deformation to it, right? We can do testing at ARCCA to determine how much force does it take to bend that material so that we get the deformation that we have. That would be a good example.
Is there a specific type of testing, or is there varied types of testing that you've done and undertaken to determine the forces that would be, for instance, in your example, in that the forces at play in that sideswipe collision?
Yeah, absolutely. It would have been, again, as part of the test, we would be measuring the forces, we'd be measuring the displacement, we'd be able to calculate acceleration and things of that nature from that test data.
The tests that you undertake, are they generally accepted methodologies in the field of accident reconstruction?
Yes.
What are quasi-static tests?
So a quasi-static test would be like the example I just gave you, where we have basically the bumper would be stationary, right? And now we're pulling on it to determine how much force it takes to bend it. So that'd be an example of a quasi-static test.
So that test specifically is determining or attempting to determine the amount of force necessary to deform a bumper, for instance, in the way that it's seen after an impact.
Yes.
Or any other body panel, correct?
Correct.
And on the human side, also there are forces at play, I'm assuming, in terms of injuries that are sustained by pedestrians in the accident reconstructions that you've done involving pedestrians.
Yes.
Do you have experience in evaluating whether damage to a vehicle is consistent with a proposed scenario or set of facts?
Yes.
Describe those circumstances for us. What are the circumstances in which you're trying to determine whether or not the damage fits a proposed scenario?
So a case that commonly comes across my desk is we have two very different versions of how an accident unfolded according to party A and party B, right? And we have a set of evidence in terms of the damage to the vehicles, maybe some roadway evidence, right? So we can look at that objective evidence, utilize physics, maybe some calculations, determine whose version is most consistent based upon the damage and the roadway evidence.
Is that an accepted methodology in the field of accident reconstruction?
Yes.
In other cases in which you've undertaken such an engagement to determine whether or not the physics or the physical evidence matches a particular scenario or is inconsistent with that scenario, have you been able to ultimately reach conclusions and opinions to a reasonable degree of scientific certainty in those cases?
Yes.
Is that normally what you're seeking, to ultimately come to an opinion or a conclusion about those scenarios or circumstances?
Yes.
Are your opinions and conclusions based on your education, your training, the background and experience that you've explained to the jurors?
Yes.
Is it also in furtherance of the scientific methodologies that you employ in order to come to those opinions and conclusions?
Yes.
And are those generally accepted in the scientific and accident reconstruction community as a proper methodology to come to opinions and conclusions of that nature?
Yes, sir.
Have you been qualified in other courts to testify in the area of accident reconstruction?
Yes.
Let's talk about how you began your work in this particular case. When you were initially retained in connection with this case, were you hired by the defense?
No.
Did you know who we were?
Sustained.
Your Honor, may we approach?
Do you know who we
You can
were?
ask it differently, Mr. Jackson.
Sure. Were you hired by anybody affiliated with the defense?
No.
At that time, did you know any of the names of the defense?
No.
At the time that you were hired to or engaged in this case, did you even know the name Karen Read?
Sustained.
Did you know any of the names or of any of the parties?
Sustained. I'll see it.
Sure.
Now let's just see them at sidebar. He needs to get it out to the jury that they were not hired by Karen's Auto Insurance Company, Turtle Boy, or some other, side piece, for lack of a better term, than that had nothing to do with this case. Because that is what happened last time when the jurors spoke out, or at least Ronnie, the juror, spoke out. They said that they just discounted the ARCCA witness's testimony because they didn't know who hired them, and they thought it was probably Karen's insurance company for her car or Turtle Boy. And so they didn't give it much weight. And she has ruled that they cannot mention the FBI. They cannot speak about the FBI. They cannot bring it out. But listen, I don't have a problem with that, because with all due respect to all of you who think that he should be able to say that they were hired by the FBI, that could also work against Karen. What if the jury thinks, oh, so the FBI was investigating Karen too? Like, that's not great. But what I think needs to be brought out here is that they were unbiased. They were not for one side or another. They were investigating this for some other reason. So don't get all upset that they're not allowed to mention the FBI, because that can work against Karen as well. Right? Think about it. There is no crash report. That is correct. There's no motor vehicle. Well, that's not true. There's no motor vehicle accident report. The analysis that Trooper Paul did is somewhat, it's called a CARS report. It is not a motor vehicle accident report that's filed with the Department of Motor Vehicles, the RMV, or whatever they call it in Massachusetts, which is required by law. Anytime there is an accident, a motor vehicle accident involving injuries, death, or property damage, I think over $1,000. So you see what her ruling is here. His line of questioning was basically, he didn't know who we were. He didn't know who anybody was here to get it out. Kind of.
When you were initially hired to look at the facts and circumstances of this case, did you do so independently? In other words, were you given a series of facts and a series of data and asked, just look at these facts and look at these data and make a few determinations about accident reconstruction in this case?
Yes.
What were you asked to do specifically?
It was to look at that evidence that we were provided and determine whether or not the damage to the vehicle was consistent with the injuries to Mr. John O'Keefe.
At the time that you
vice versa.
were asked to engage in this independent analysis, were you provided information or data?
Yes.
Who at ARCCA was assigned to the team that would ultimately engage in this particular analysis?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
Describe what the materials were that you were provided in your initial assessment of this case.
Could I refer to my report?
With the court's permission.
Would you like me to just go in order from the materials reviewed?
That would be fine.
The Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus LX 570, report of autopsy photographs, and there was a few other items there, but those were generated internally.
There were about 14 things that were listed in terms of categories of information that you were provided, or ARCCA was provided, is that right?
A little less than that, because some of those, like I said, were internally generated, but yes.
Why were you provided that data? What's the reason why it's important for you to get certain data as you begin your analysis?
Well, we wanted to have an understanding of or ultimately the entity that retained us, wanted to have an understanding of what, I guess, the evidence that we would need to reconstruct this.
The entity that hired us, he's very careful. Many witnesses have slipped and said FBI and first trial, including Hank Brennan.
Did you get enough information to engage in a fulsome analysis, an accident reconstruction, in terms of the initial request by the entity that hired you?
Yes, in terms of our scope, yes, we had sufficient information.
Were you able to review photographs of not only the Lexus involved, but John O'Keefe's body?
Yes.
Did you use those photographs in furtherance of your analysis?
Yes.
Did you use the reports detailing scenarios or possible scenarios in furtherance of your analysis?
From what I recall, I don't believe any of the reports indicated any type of theory or understanding of how the accident occurred.
Were you asked to determine whether or not certain scenarios could be possible?
I don't recall them giving us any scenarios to evaluate. They essentially left it in our hands. Here's the evidence. What do you think happened?
That was an open question, correct?
Correct.
All right. Did you engage in an analysis that basically allowed you to think of any scenario?
I think that's fair, yes.
In your initial analysis, did you note damage to the vehicle?
Yes.
Describe the damage. Let's start with the vehicle. Describe the damage that you noted in furtherance of your analysis.
The primary damage was to the right rear taillight on the quarter panel section. The majority of the outer red lens was broken and shattered, as well as some of the underlying components and diffusers that are underneath that outer layer, as well as some damage to the back portion of the taillight.
Can I stop you right there? Describe when you say the outer lens material and some interior material as well was damaged. Describe that in detail for us.
So the outer lens is red, and it's about 5 millimeters in thickness, and it basically encompasses the majority of that quarter panel taillight. And then there's a small segment that is clear, that is for the turn signal indicator, which is yellow. Underneath that 5 millimeter thick red lens, there are additional diffusers that run along the bottom. There's two rows of those, I believe, and then they also go up vertically on the side, and those are clear. And I think the thicknesses of those are about 3 millimeters.
Is 5 millimeters of PMMC, have I got that right? PMMA?
You'd call it acrylic. That's the more common name.
Easier for me. Is 5 millimeters of that acrylic, that outer lens material, is that considered thick or thin in terms of just sort of what we'd see on a taillight?
I would describe that as a pretty thick piece of plastic. It's certainly by no means, you can't, if you had a segment of it and you try to bend it, it's not going to bend.
Okay. In addition to that outer taillight material, that acrylic, in terms of the information that you received, did the interior acrylic also have damage to it?
Yes, those clear diffusers that, again, there's 2 rows of those, and they also went up vertically. Those were shattered and broken as well.
Was that important to you in your ultimate analysis?
Yes.
A human arm.
Did you note any superficial scratches or dents anywhere on the tailgate area or the liftgate area?
Yes, there was a dent and some paint chips, if you will, above the liftgate taillight assembly. So again, that next to that quarter panel taillight, there's another assembly that is on the liftgate, and there was a small dent and some paint chips at that area. There was also on the wraparound section of the bumper cover, as it's going from the rear to the right side, there were some superficial scrapes in that area.
Did you note any other damage or deformation to the Lexus? Deformation in the the liftgate, the bumper, anything like that?
No.
Is it common in a vehicle-pedestrian collision that there is some sort of bumper deformation that's associated with a vehicle-pedestrian incident?
That can certainly occur if a pedestrian is in an normal upright position. You can certainly get displacement of the bumper.
Did you see any displacement or panel deformation on the Lexus?
No.
Is it common is it more common that there's panel displacement or deformation if the collision is above, say, 10 or 15 miles an hour?
Yes.
No damage to the bumper.
During your review of all the investigative materials, did you note any items of evidence that were recovered or claimed to have been recovered on the bumper itself?
I recall there were 2 or 3 apparent glass fragments.
What's the significance of that? Let me ask it differently. Is there any glass in the taillight assembly?
For those of you not present during season 1, the theory was 24 miles an hour in reverse. Notice how Welcher.
May I ask that again?
Yes.
Nobody ever told me 24 miles an hour in reverse. This witness is telling you, and he's quite the expert, by the way, that at over 10 miles an hour, there would be bumper damage. And notice how all of a sudden they're walking it back to 8 miles an hour. Are you picking up what they're laying down? They know what's in the ARCCA report. They had to address that in their testimony, and that's what Welcher said. Around 8 miles an hour, it would shatter a taillight. So pay attention to the numbers.
Is there any glass in the taillight assembly?
No.
Was there any shattered glass anywhere on the Lexus? Meaning panes of glass, the back window, quarter panel windows, anything like that?
No.
Did you have any understanding at that time of what the Commonwealth's theory of the case was when you began your initial analysis?
Sustained.
Did you have any indication of what the Massachusetts State Police theory of the case was based on the investigative reports that you had received?
Sustained.
Did you perform an accident reconstruction analysis to determine whether or not the damage to the Lexus, that taillight housing material, was consistent with an interaction with a pedestrian?
Yes.
Specifically, did you perform an accident reconstruction to determine whether the damage to the Lexus was consistent with an interaction with John O'Keefe based on the injuries that you were aware of?
Yes.
Did you evaluate whether the investigative theories regarding, let me ask it a different way. Did you consider the possibility of Mr. O'Keefe's head striking the taillight?
Yes.
Did you consider the possibility of Mr. O'Keefe's arm striking the taillight?
Yes.
Did you entertain the possibility that Mr. O'Keefe's center of mass, his body, struck the taillight?
Yes.
Before we get into the initial testing, were you able to come to opinions and conclusions concerning those things that I've just mentioned?
Yes.
Did you also entertain the possibility that a drinking glass could have damaged the taillight?
Yes.
Were these some of the things that you were sort of, was left open to you to decide yourself?
Yes.
Did you later provide all of those opinions and conclusions in a report to the entity that hired you?
Yes.
Is it your understanding that those reports were then later supplied to both sides here in this case?
That was my understanding, yes.
Did you testify about those initial testing opinions and conclusions at a proceeding last year?
Yes.
Let's talk for a second about that initial testing that you conducted in connection with this case. When approximately did you begin your testing? And I'm going to phrase it as your initial testing, the testing that you testified to about last year. When did you start that initial testing?
From what I recall, it would have been late 2023 into early 2024.
I want to talk about the drinking glass first. Did you become aware that there was a drinking glass that was found at the scene?
Yes.
And what was the testing that you sought to determine as it relates to the drinking glass and the taillight?
So looking at the evidence, as I mentioned earlier, when we're looking at that quarter panel taillight, we have an isolated region of damage. And looking at the additional evidence in terms of a broken drinking glass at the scene, we wanted to do testing to determine if a small object or projectile such as the drinking glass could induce damage that was consistent with that we saw on the subject Lexus.
Were you able to reach an opinion and or conclusion as it relates to whether or not there is a possibility that the drinking glass or a drinking glass could cause the type of damage that you saw on the Lexus?
Yes.
Given everything else in your investigation, are you concluding that the glass was responsible for the taillight damage?
No.
However, you did seek to determine whether it was possible, correct? Okay.
Sustained.
I'll ask it a different way, Your Honor. What testing did you undertake in furtherance of answering that specific question? Could the glass damage the taillight?
Right. So we designed a pressurized cannon that was capable of firing the drinking glass into the taillight at various speeds. We aimed for speeds of 30 and 40 miles an hour. Our achieved speeds were at 31 and 37 miles per hour. And we found that in the 37 mile an hour impact, and again, this is to emulate or simulate an individual throwing a drinking glass. The purpose of the cannon, if you will, was to be able to hone in on a speed precisely and obviously aim for that target. So it would just serve as a means of getting that projectile to the taillight in a means that we could measure it. And what we observed in the 37 mile an hour test is that we got damage that was generally consistent with that of the subject taillight, and that there was a large portion of the outer lens that was shattered and fractured, as well as the underlying clear plastic diffusers and chrome piece.
Tell me a little bit about the methodology that you undertook, the scientific methodology in building that pneumatic cannon and aiming that glass directly at the taillight. Absolutely.
So, as I mentioned, it was a customized cannon, if you will. It had a barrel that was capable of fitting a rocks or an old-fashioned drinking glass in it, and that's a glass that has a thinner sidewall, if you will. I think the glass was about 3 inches in height or so, maybe 3.5 inches, with the bottom portion being solid glass or just a thick piece of glass. So we were able to design a kind of a holder for it, if you will. Almost, you could really think of it as stuffing an actual cannon with a cannonball. So we literally would put the drinking glass in the cannon. There was a pressurized vessel behind that we would open up a valve rapidly, and when it was set to a certain pressure, that would determine the exit velocity that it would leave the barrel at. And we were able to aim that device into the taillight at those specified speeds to be able to determine what would the damage pattern be when we fired that glass.
Were you able
He gets very excited when he talks about the cannon. Last year he said, and it was awesome.
in this scientific experiment to control for aim and trajectory?
Yes.
Were you able to control for velocity or exit speed of the glass?
Yes.
Were you able to control for damage patterns as it pertained to both the glass as well as the taillight at which it was aimed?
I don't know that we have had control over that. Ultimately, physics takes over after that interaction occurs. I can't influence how that material is going to perform or how the glass will break, per se.
It's a poor question on my part. Were you able to, or did you undertake to memorialize the damage pattern that you saw on the taillight and the glass as the glass was projected into the taillight?
Yes.
All right. Did you do that through photographs?
Yes.
High-speed video?
Yes.
And all of that was memorialized in your report?
Correct.
Your Honor, may I approach?
Yes.
I'm handing you 2 photographs, or 2 8.5 by 11 documents that contain 2 photographs each. Can you take a look at those 2 documents and tell me if you recognize those?
Lacey Ann, he's got to build a foundation. It's the way it has
Does
to be
one
done.
represent, you mentioned that one of the tests that you performed was at 37 miles an hour, correct?
Correct.
Did you mention the speed at which, or the velocity at which the other test was done?
If I didn't, it was 31 miles per hour.
All right, so 31 and 37. Do you see those 2 documents in front of you?
Yes.
Does one of them represent the 31 mile an hour test and the photographs associated with that?
And an extracted frame from the high speed, yes.
Okay, and does the other one represent the other test, the 37 mile an hour test?
Yes.
If we could take those one at a time. May I approach one more time?
Is it clear to you that this is throwing speed, not vehicle speed? Because they may need to clarify that. So if somebody was throwing a glass at 37 miles an hour, it would create that damage. What if the vehicle was also backing up at a certain speed? Is he assuming that the car was stationary or moving? I'm not sure. Oh,
If I could ask that these be marked as next in order, one at a time, 31-mile-an-hour test, and handing to the...
Jess Machado tweeted that the jurors' mouths were open when discussing the canon. Thanks, Nona Robin.
Okay.
I'm sorry.
213?
And the second document represents the 37-mile-an-hour test.
214.
Nobody ever went inside the house to see if they had those kind of cocktail glasses in the house. Go figure.
Course permission, I'd like to exhibit 213. I'm sorry, present exhibit 213.
Okay.
Is this the photograph that was just marked as exhibit 213 that's in front of you?
Yes.
Can you explain to the jurors what they're looking at?
So on the left part, you are looking at a frame from the high-speed video just after the contact with the taillight. On the right, you're looking at the post-damage to the taillight after the glass had been fired into it.
And if we could look at the next exhibit with the court's permission.
Okay.
And what are we looking at here?
Same thing on the left. Again, this is the 37-mile-an-hour test. The glass striking just in the area where the bottom of the turn signal indicator is, so the right where it meets the red portion of the lens and the clear portion of the lens. That's about where the impact point was. You could see that a large portion of the outer red assembly, lens cover is missing and fractured. The clear portion of the part of the outer lens to the turn signal indicator is also fractured, as well as the underlying clear diffusers in that assembly.
Would your testing in both of these scenarios, the 31-mile-an-hour test and the 37-mile-an-hour test, represent an accepted methodology for controlling for aim, velocity, impact site, and those issues, if you will, as it relates to testing of this sort?
Yes, we were able to control those variables.
And is that an accepted methodology in the area or the field of accident reconstruction?
Absolutely, yes.
When you finished your testing, were you able to make a determination as to whether or not either one of these velocities, the 31-mile-an-hour velocity or the 37-mile-an-hour velocity, were consistent with the damage that you saw on the subject Lexus, which is the 2021 Lexus belonging to Ms. Read?
Yes, from the 37-mile-per-hour test, we are getting damage that's generally consistent, and that I mentioned we have portions of the outer lens missing, the underlying diffuser. There was also some fracturing on the backside of the assembly. So again, we observed damage that was generally consistent with that of the subject taillight.
And that was the 31 or the 37?
The 37.
The 37. What about the 31?
Didn't have enough energy to create that damage.
So were you able to conclude, in your opinion, whether or not the velocity of that glass hitting the taillight would have to be somewhere in the vicinity of 37 miles an hour, well above 30 miles an hour?
Well above, and it certainly could have been above 40 miles per hour per se. I mean, we may have actually blown out more of the outer lens had the speed increased.
Did you have any information in the data or documents that you reviewed associated with this case, for instance, that John O'Keefe had a pneumatic cannon with him out there?
No.
Okay. So obviously, well, let me ask a different way. Based on this series of tests, were you concluding that the damage on the taillight conclusively was the product of a glass being hurled into the taillight? Objection.
Sustained.
Were you concluding, or did you opine, that the damage to the taillight came from a drinking glass?
No, I gave an opinion that the damage was generally consistent with that in the test, compared to the subject taillight.
but only in the circumstance where the glass is being hurled at 37 miles an hour, correct?
Sustained. Can I ask it differently?
Under
Mr.
what circumstance did you determine that it was consistent with a drinking glass?
If that drinking glass, again, the purpose of the test was to do a test to evaluate or simulating somebody throwing a drinking glass at the taillight. So that's what that test was to demonstrate.
Understood. Let's turn to another test that you undertook regarding the head injuries that you became aware of. Did you become aware of in the day?
It's also never been the Commonwealth's theory that John threw the cocktail glass at the Lexus, right? They've never used that as a theory, despite the fact that they had this report prior to the first trial. And they've changed their theory a number of times. They've never used that as their theory. Their theory is that his arm broke that taillight.
Data that you received that Mr. O'Keefe had suffered head injuries to the back of his skull.
Yes.
What sort of testing did you do to determine whether or not and under what circumstances that head injury may be connected or associated with the damage to the taillight?
We performed a drop test with a hybrid 3. So that's an instrumented anthropomorphic test device to be able to measure the accelerations on a head form and observe the damage to an impact to the taillight.
What is an ATD, anthropomorphic test device?
So it's a device that's commonly used in our field, and it's certainly approved by the federal government to evaluate crash forces and occupant kinematics, or I should say occupant crash forces. So it's a device that reconstructionists and biomechanists typically use or commonly use to be able to evaluate, like I said, whether it's forces in a motor vehicle, or let's say you have something being dropped on somebody's head or an impact to somebody's body part, right? We can use that instrumented dummy to evaluate and measure the acceleration and the forces.
Another word or another phrase often used in association
crash test
with
dummy?
ATD devices are crash test dummies, correct?
Correct, yes.
Why was it important to do a drop test?
So we wanted to have an understanding based upon the fact that Mr. John O'Keefe had a skull fracture to the back of his head, whether or not an impact, a direct impact between the taillight and the back of his head could have caused that skull fracture.
What did your testing indicate?
When we did the test, the impact to the taillight was at 15 miles per hour, and we observed that the damage to that taillight was significantly more than the subject taillight at the 15-mile-an-hour speed. Furthermore, it did not generate, according to my colleague, Dr. Rentschler, enough forces to cause a skull fracture.
So ultimately, what was your conclusion related to the taillight potentially striking John O'Keefe in the head at above 15 miles an hour?
From a damage perspective, it was inconsistent.
Inconsistent.
Correct, inconsistent.
Did you consider temperature and control for temperature in any of your testing?
Yes.
Why is that important?
Well, that will affect how that, we've talked a lot about that acrylic material of the lens. That will certainly affect how it fractures. So we absolutely controlled the temperature during these tests.
How did you control for temperature?
So we had them sit overnight in chest freezers to get them to the desired temperature, which for our original set of testing was at 28 degrees Fahrenheit. We then rapidly moved them to our test fixture, and then they were fired almost immediately after that.
And when you're talking about them, you're talking about exemplar taillights.
Correct, yes.
Are those exact replica taillights that you would find on the 2021 Lexus SUV?
Yes.
After your testimony in the first proceeding last year in the spring of 2024, were you ultimately contacted by the defense in this case?
Yes.
When were you contacted by the defense?
I know that I had reached out to you, I believe it was in February of this year, because I think I saw some things in the media and was just wondering what was going on.
Sustained. Just when? Just a date, Dr. Wolfe?
I don't know if I could give a specific date. If I had to estimate, sometime in February or March, probably.
Were you still under contract with the other entity that hired you?
There you go.
Sustained.
Oh,
At some point, you and I spoke, correct?
Correct.
And that was, you believe it was February of 2025?
Yes.
Had we spoken at all between the end of your testimony at the proceeding last year and February of 2025?
No, that was the first time.
oh,
Did
Brennan's
I
gonna-
ask you anything about retaining you?
Not at that time, no.
He's getting ahead of it because this is all Hank has got.
At some point, subsequent to that initial discussion in February of 2025, did we have another discussion about the potential of retaining you?
Yes.
Tell me about that. When was that?
From what I recall, it was sometime in March, and we were trying to figure out.
Sustained. Next question, please.
Oh, she's
Did I
not having
ask
it.
you if you were available to be retained by the defense?
Sustained.
May we approach?
Okay.
Yeah, because you know this is all that Hank has to cross on is that they were using the Signal app and it's encrypted and therefore they were in collusion to try and make up some theory about John O'Keefe not being hit by a car when they were hired by the federal government way before the first trial, because there was a parallel there and there still may be a parallel investigation into this investigation. And some people said, Jen Shep said, I could assume the FBI was hired because Officer John O'Keefe was law enforcement. Nope, I don't believe so. And then someone else said here, Catherine, I'm sure it's been addressed, but why did the feds get involved initially and decide to hire ARCCA? Something must have triggered them to do so. I missed the first trial. We don't know. The feds don't talk about why they're investigating or what they're investigating. It has been surmised that whatever the FBI was investigating goes far, far deeper than the John O'Keefe murder. There is also the Sandra Birchmore murder that was being investigated by the feds. Sandra Birchmore is a young woman who died in Canton, 23 years old, pregnant with a married Stoughton police officer's baby. He had met her when she was something like 12 or 13 at a police explorers program. She always wanted to be a police officer, and she joined that program. He took her virginity when she was 15. He was married. She was impregnated with his baby at 23. She was found dead in her apartment in Canton 1 year prior to this. So I think it was February of 2021. It was investigated by, guess who? Canton PD and many MSP troopers who were also involved in the investigation of the John O'Keefe murder. Quickly ruled a suicide. Fast forward to today, and that, despite all the evidence to the contrary, that it was not a suicide, Matthew Farwell is sitting in federal prison awaiting trial on murder charges because the feds brought those charges at the same time as this case is going on. So there's a lot more to that, and we just don't know. But we will find out one day, I believe. Not a suicide.
May I inquire?
Yes.
Thank you. Okay, Dr. Wolfe. So ultimately in March of 2025, were you hired by the defense?
Yes.
Okay. Were you asked to do anything or to review anything from the Commonwealth and any of their experts in relation to testing that was undertaken by them regarding the Lexus and Mr. O'Keefe?
Yes.
What were you asked to do?
My understanding is that we were asked to review and evaluate the report and analysis conducted by Dr. Welcher.
Did you receive Dr. Welcher's reports?
Yes.
Did you receive his raw data?
Yes.
Did you receive his 140 plus page PowerPoint?
Yes.
And did you undertake a review of that, all of that data, in order to evaluate that data?
Yes.
What methodology did you undertake at that juncture before you began any testing? Just your review process. What methodology did you undertake in terms of your review of his evaluations and his opinions and conclusions?
Well, I think when reviewing his report and his analysis, I look to his opinions, and then I look to what's the basis and the foundation to those opinions, right? How did he ultimately arrive at those final conclusions? So I'm looking for the methodologies that he followed, what testing did he do, what type of experiments, what type of data analysis, ultimately to provide that opinion.
Ultimately, did you prepare a PowerPoint presentation in furtherance of memorializing your review and opinions and conclusions of his evaluation and testing?
Yes.
Did you bring that with you today?
Yes.
Do you have that with you on your computer, or are we going to run the PowerPoint?
It's on this computer up here with me.
With the court's permission, could Dr. Wolfe present his PowerPoint presentation?
Does have a laptop with him.
Your Honor, I have a thumb drive that I believe represents the PowerPoint. Do we have this marked?
Yes, is this coming into evidence?
I'm agreeing it's launched the name.
All right, so we'll mark it for identification.
We can mark it for identification for the time being and discuss it later. Thank you.
Should it BBB for identification?
BBB. Little room to
Dr.
scooch.
Wolfe, do you see what's displayed or presented up on the TV screen?
Yes.
All right. Do you have with you, by the way, just a matter of housekeeping, something called a spotlight?
Yes.
Something that can do whatever spotlight does that?
Yep.
Okay.
Yes.
I may ask you to employ that, or I may take it from you at some point as we're discussing this. Do you recognize what's on the screen?
Yes.
What is this?
This is my
laughing.
PowerPoint with just the first page, the title.
If we could move to the next slide, please. Describe what we're looking at in this slide.
This is from Dr. Welcher's PowerPoint presentation, slide 121, in which he's indicating that there are lacerations on John O'Keefe's right arm and forearm. And he's indicating in this slide that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right rear taillight of the Read 2021 Lexus LX 570.
In coming to your opinions and conclusions, and I know this is a mouthful, did you consider the opinions and conclusions of Dr. Welcher in conducting your analysis and your ultimate testing?
Yes.
Did you rely on Dr. Welcher's report and his PowerPoint in reaching your conclusions and opinions ultimately in this case?
I don't know that I relied on it. Certainly, I utilized them to have an understanding of what his basis was for his opinion and what his opinion was. Ultimately, at ARCCA, we did our own independent testing to evaluate that.
So just to be clear, I'm not asking Dr. Wolfe if you agreed with his opinions and conclusions. I'm simply asking, did you rely on those in order to come to your opinions and conclusions? Did you incorporate them?
Sustained is to the
The picture comes up.
Did you agree ultimately with Dr. Welcher's opinions and conclusions?
sustained.
Why can't he ask him if he agreed with Dr. Welcher's
You're aware
conclusions?
of what his opinions and conclusions were, correct?
Inform Mr. Jackson on that one.
Were you aware of Dr. Welcher's opinions and conclusions?
Yes.
Are some of those opinions and conclusions represented in your PowerPoint?
Yes.
Are some of them represented on this slide in your PowerPoint?
Yes.
You indicated that this slide indicates that the location and orientation of the lacerations on John O'Keefe's right forearm and arms are consistent with the geometry and orientation of the right rear taillight, correct?
Correct.
Are the injuries to John O'Keefe's arm lacerations?
That would be an opinion from my colleague, Dr. Rentra.
Have you ever heard the phrase abrasion?
Yes.
In your opinion, are the injuries to John O'Keefe's right arm better described as lacerations or abrasions?
I don't have an opinion on that.
He's not the injury guy.
Slide number 2, please. Based on your review of Dr. Welcher's reports and his data,
Take that down.
what testing did Dr. Welcher undertake or conduct?
So he did, initially it appeared that he did a static test, if you will, just demonstrating holding his right arm out adjacent to the rear taillights on the right side of an exemplar Lexus to demonstrate his theory of how the arm contacted the taillight.
What is a static test?
So I'm sustaining that. Ask it differently, Mr. Jackson.
What?
And I'm going to strike that.
I'm sorry.
What testing did you note that Dr. Welcher did with regard to this particular photograph? What is a static test?
Well, in a static test, that neither the arm or the vehicle is moving. It's just he's aligning his right arm adjacent to show how his arm aligns to the geometry and the dimensions of the Lexus.
Did Dr. Welcher appear to be wearing similar clothing as
Yeah.
John O'Keefe was wearing on January 29, 2022?
Yes.
Was there any significance or purpose for that, in your opinion?
In this test, no.
No reason for it.
Did you identify any limitations with regard to this sort of testing undertaken by Dr. Welcher?
Well, it's very basic in that the only thing that this demonstrates is that you can get your right arm to align with the taillight. Beyond that, it doesn't tell you anything with respect to what happens to the arm when it makes contact with the taillight, right? What's the motion of the arm? What's the damage to the taillight? What's the acceleration of the arm? What's the forces of the arm? So it doesn't answer any of those other questions. The only question it answers is, does the arm align with the taillight?
Right.
You're
Right.
aware that John O'Keefe was 6'1", correct?
Correct.
Is the only person, let me ask it a different way. Can only a 6'1" person align their arm with the taillight?
No, the arm is adjustable, so certainly people of different heights could also meet that alignment as well.
Yeah.
Like pivoting your arm a little bit, right?
Sustain.
How would you describe the ability of somebody 5'7" or 6'3" being able to align their arm with the taillight?
Just changing the orientation and the posture of your arm.
Was there any scientific significance, in your opinion, of this particular test?
Again, other than just demonstrating that it aligns with it, no, nothing beyond that.
Next slide, please.
It's what you call a waste of 300, close to 400 grand is what you would call it.
What are we looking at here?
So this is an extracted frame from one of his dynamic tests in which the vehicle is moving at about 2 miles per hour into his arm, making contact with his hand, his forearm, and his elbow.
What is a dynamic test as it relates to a static test?
So that's when something's in motion, and in this instance, it's the Lexus moving at about 2 miles per hour into his arm.
Did Dr. Welcher explain what the purpose of this test was?
From what I recall, I think it was to demonstrate that when his arm makes contact with the taillight, he observed paint transfer in the general location that there were the abrasions or the lacerations on his arm.
Did he appear to paint the taillight?
He did, yes.
Do you see that Dr. Welcher appears to be wearing an orange T-shirt?
Sustain.
What is he wearing?
Appears to be an orange T-shirt.
Is that similar to what was described as John O'Keefe having worn that night on January 29th, 2022?
Yes.
Is there any significance to wearing that T-shirt?
Not that I can think of, no.
Did you note any or identify any shortcomings with this particular test?
Well, much like the static test, again, it leaves the door open to all those questions, right? About, again, doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20, right? In terms of what are the collision forces? What's the damage? How does the arm move? What would the expected injuries be, right? This dynamic test, as well as the static test, doesn't answer any of those questions for us.
Is this test from Dr. Welcher considered a force calculation?
I'm not aware of him making any type of force calculations or measuring accelerations or anything of that nature, no.
Did Dr. Welcher conduct any testing to determine whether the damage to Ms. Read's Lexus was consistent with the striking of an arm of a pedestrian?
I'm not aware of any impact testing that he did, no.
No impact testing.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the damage to the taillight of Miss Read's vehicle?
Not that I'm aware of, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the injuries to John O'Keefe's arm?
No, not that I'm aware of.
Did Dr. Welcher provide any opinions as it relates to the speed of the subject Lexus at the time of the alleged incident?
No, from reviewing his report and his PowerPoint and analysis, I could not find anywhere in it a specified speed or even a range of speeds.
I understood 24 miles an hour.
Did Dr. Welcher provide any opinion as it relates to the forces experienced by the taillight in such an impact?
Not that I'm aware of, no.
Did Dr. Welcher provide any opinion at all as it relates to the post-impact trajectory or movement, if you will, of John O'Keefe's mass or his body subsequent to the alleged conduct?
No, not that I'm aware of.
Did you?
Next slide, please. Do you recognize this photograph?
Yes.
What is this?
So this is something that you probably have heard and certainly I've discussed already, but this is looking at the right rear corner of the subject Lexus, specifically in the area of the damaged right taillight.
Did you consider this photograph in coming to your opinions and conclusions?
Yes.
What, if anything, of significance did you note about this taillight other than the fact that it's damaged?
Well, I'm going to jump to the next slide, if you will. So this is now the taillight obviously has been removed from the vehicle. So obviously what's important here is looking at what is the damage that we have to this taillight. What components were damaged in this alleged interaction. So we're looking at the clear diffuser at the bottom is fractured and missing. Same with the ones on the vertical side. The majority of the outer red lens is also missing and fractured. And then on the back side, we also have some damage in terms of some fracturing to that black plastic. And there's also a chunk of plastic missing on the top portion of the taillight as well.
Yeah.
I want to ask you a couple of questions about that diffuser. If you could focus your attention on this area. Describe for the jurors what they're looking at in terms of the diffuser. What is the diffuser?
Right, let me see if this. So the
Yes,
diffusers,
spotlight.
right where my mouse is, there's a clear diffuser that runs along the bottom, and then there's another diffuser that runs along here, and then it also goes up vertically. Same here on the bottom one, that also goes up vertically. So this piece was missing and fractured on the bottom, along with the vertical portion. The chrome piece here you can see is also fractured and damaged. And then the kind of the second tier, if you will, that clear diffuser was also fractured and broken on the upper section as well.
Was that of significance to you in your review of the damage to the taillight?
Yes.
Why?
Well, because that tells me that we have to have enough force and energy to break, we talked about earlier that 5 millimeter thick red outer lens. We have to have enough force to be able to get beyond that to now start penetrating into the interior components of the taillight to get to, again, those clear diffusers and certainly cause damage to get induced out the back end of the taillight as well.
Both layers of the taillight. You picking up what he's laying down? The red outer portion, and then also the inner portion was also fractured and broken. And there's that broken off piece of chrome that Carrie Roberts wanted to talk about. She talked about it twice, that she was really worried that this piece of metal was going to snag on someone's sweater, remember? Somebody had these photos here in this left-hand photograph. Come to your screen if you can, do it so safely. This is the piece right here. I don't know if you can see my cursor. Don't send me a bill for your television. Don't smash your television. But I believe that this piece right here, furthest right on the corner, about the size of a dollar bill, is what Dighton police officer Nicholas Barrows said is the only piece that was missing when he saw the tail light. And look at how the taillight is completely shattered, gone, when it was finally photographed by the Massachusetts State Police.
Yes.
Higgins with the hammer and the Sallyport, says Elizabeth.
Dr. Wolfe, did you bring with you an undamaged taillight exemplar?
Oh, he brought
Yes.
the taillight.
It's up here with me.
It's up there. Oh, I was just looking for it.
Shout out to Be in Trouble
Thanks for nothing.
31.
Uh,
Shout out to Be in Trouble 31 on YouTube. He's usually in the chat here. He's done a lot of experiments on his own. He bought a taillight too, and he's been explaining this for months.
describe what it is that you brought with you.
So I brought a two-part assembly. So what I did is I 3D printed a bracket so that I could mount the lift gate taillight assembly as well as the quarter panel taillight assembly.
And these are undamaged in sort of manufacturing specs, correct?
Correct,
Love a
yes.
live
May I have just a moment,
presentation.
Your Honor?
Okay.
I love a live presentation. I think he's going to try and smash the taillight. There are also tool marks, as we've pointed out several times, and Ed Wallace has pointed out. Ed Wallace did this on his show too.
You have it with you up there at the witness stand?
Yes.
3D
you-
printer.
Retrieve that with the court's permission?
Okay.
Oh, look, watch her, watch him. Watch her, watch him. Yeah, somebody's going to make a meme of that. Hold on, let me get out of the way. Oh, yes, oh, yes, oh, yes, oh, yes. Yes, we both, oh, yes, we both.
If you could remain standing for just a quick second. Do you recognize what that is?
Yes.
Is that what you just described?
Correct, yes.
Describe it one more time for the court and the jury. What is it that we're looking at right here?
So this is an exemplar set of taillights from a 2021 Lexus LX570. On my left side here, this is the lift gate taillight assembly, and it's attached to the quarter panel taillight assembly. And I will note, it's not normally like that. Obviously, you can't have a connector, else you wouldn't be able to open the lift gate, but I've printed a bracket back here so that these can remain as one unit.
He printed a bracket.
Your Honor, with the court's permission, I'd like to have that marked as next in order.
Brilliant.
Is that coming into evidence?
Yes, if possible.
Is that okay?
Is that okay with you, Mr. Brennan?
So
Who makes the
how-
legal rulings
May I
here?
approach?
Yes.
Who makes the legal rulings here, Judge? You, or are you deferring to Mr. Brennan?
Thank you. If you just have the tag,
Getting
perhaps
maxed.
put it somewhere on the maybe the lift gate side.
And is Dr. Wolfe going to use it for his testimony now?
Yes.
Okay.
Very
so-
briefly.
Gonna smash it.
Please, Chrissy.
Is it gonna be like Gallagher smashing a watermelon all over the audience?
Give it to him.
Is that who that was? That comedian Gallagher? People used to have to wear those disposable ponchos when they went to see his comedy shows because he would smash watermelons. Wouldn't it be great if, like Shark Tank, they called up the jury members and they said,
Thank you. Dr. Wolfe, you
you like to
indicated
come
that there's a 5mm area of acrylic covering the diffusers, correct?
Correct.
What I'm knocking on, is that the 5mm acrylic?
Yes, both on the quarter panel part that you just pointed to as well as the lift gate part.
Mr.
Those are-
Jackson, why don't we give that back to the witness and let him do it instead of you?
Sure. Is there, can you see through that loose material into the diffuser that you've just been describing?
Yes, so as I mentioned earlier, in this area here, there's a diffuser that's running along the bottom.
So, Dr. Wolfe, I'm going to ask you to not have that so close to
Oh,
the court reporters.
My apologies.
Use the other side of the witness stand.
Yes, Your Honor.
smack the court reporter in the
So
head?
along the bottom is the clear diffuser that runs along and then goes up vertically. And then on the second tier, there's also a clear diffuser that runs along here and then goes up vertically. And you might be able to see it through, it kind of looks like there's little dots on it. So that's what I'm referring to in terms of the diffuser that's underneath. And that, again, so you have that outer material that's 5mm roughly in thickness. And then those diffusers are about 3mm in thickness underneath this.
Could you make a determination, and you can go ahead and have a seat. Well, actually, you may not want to. Could you make a determination of the space, the gap between the outer plasticine area, the outer acrylic area, and the internal diffusers? If you could just estimate that gap.
If I had to estimate, I'd probably estimate around an inch, maybe inch and a half.
Okay. You indicated that something was of significance to you in this photograph about the diffusers on the subject taillight, correct?
Correct.
Describe, now that you're holding that, what was it that was of note to you, Dr. Wolfe?
So as I mentioned,
Time out. Somebody said she just passed a sticky note. I got to go back to that. We're going to have to rewind that. The judge passed a sticky note. Okay, hold on. Let's take a better look. Okay. Keep your eyes on the judge. If you can come to the screen, do so safely.
Here, there's a diffuser that's running along the bottom.
So Dr. Wolfe, I'm going to ask you to not have that so close to
Oh,
court reporters.
My apologies.
Use the other side of the witness stand.
Yes, Your
please.
Honor. So along the bottom is the clear diffuser that runs along and then goes up vertically. And then on the second tier, there's also a clear diffuser that runs along here and then goes up vertically. And you might be able to see it through, it kind of looks like there's little dots on it. So that's what I'm
Grabs a
referring
pad.
to in terms of the diffuser that's underneath.
Writing on
And
the
that,
sticky note?
again, so you have that outer material that's 5 millimeters roughly in thickness. And then those diffusers are about 3 millimeters in thickness underneath this.
Could you make a determination, and you can go ahead and have a seat. Well, actually,
Who did she
you
just
may not
pass
want
that to? Who's sitting to the right of the court reporter? We'll have to take a look, but is it her lunch order? Because unless it's her lunch order, that's highly improper. I'm not accusing anybody of anything, just making observations that you are all picking up in chat.
Could you make a determination of the space, the gap between the outer plasticine area, the outer acrylic area, and the internal diffusers? If you could just estimate that gap.
If I had to estimate, I'd probably estimate around an inch, maybe inch and a half.
Okay. You indicated that something was of significance to you in this photograph about the diffusers on the subject taillight, correct?
Correct.
Describe, now that you're holding that, what was it that was of note to you, Dr. Wolfe?
So as I mentioned, we have damage not only to this outer thick portion, but it was enough force and energy to then penetrate deep enough to fracture the underlying diffusers that sit below this outer surface, and certainly enough force then to work its way back through inducement into the backside, and ultimately there was a top portion of the taillight that was also fractured up here.
Was all that significant to you in your review of the subject taillight material?
Yes.
Okay, you can go ahead and put that away.
All right, so that can't go back there because it's in evidence. So why don't we take it and
I was just going to store it there until he's finished with his testimony, and then we can give it to the clerk magistrate.
Okay.
However you want to do it, Your Honor.
All right.
I have
Do you
no
wanna take
preference.
it? Is he using it still for his testimony?
Not right now.
All right, so, thanks, Jim.
Thank you, Your Honor.
Okay,
May I continue?
yes.
Can we go to the next slide?
That's Ms. Gilman.
What are we looking at here?
This is a collection of photographs that depict various fragments from the right rear tail lamp assembly of the Lexus. And I will note that, and I'll try to spotlight it, there are a few fragments in this photograph that are glass fragments, which, as I discussed earlier, there's no glass in the taillight, so these did not originate from the assembly. But altogether, from what I recall, there's about 50 fragments, I believe, that were counted or so, maybe a little less than that from the right taillight.
If we could go to the next slide, please. What are we looking at here?
So these are photographs depicting the sweatshirt or hoodie that Mr. John O'Keefe was wearing on the night of the alleged incident.
And what was the role that this played in your analysis ultimately?
Well, so one of the things that I noted, and I can go to the next slide, is there were a series of small punctures or holes in the sleeve, on the right sleeve of the sweatshirt in varying sizes. I think some as small as just a few millimeters. Again, I think there was maybe 10 or 12, I think I recall, on the right sleeve of that sweatshirt.
If we could go back to the larger photo, the previous slide, do you see the right sleeve denoted on the photograph to the right?
Yes.
Does it, your review of these photographs, what was the significance of the triangular sort of arrows or markers?
I believe those were to annotate or draw attention to those holes.
Okay, the defects in the right sleeve?
Correct.
Can you count those for us, please?
This is what we call connecting the dots.
On the photograph on the right, I believe I see a total of 9.
And what about the photograph on the left, just the right sleeve area?
9 as well.
If we can go to the next slide. What are the arrows pointing to in these photographs?
So this is basically the previous shot, but what appears to be close-ups of some of those evidence markers.
You indicated some of the sizes. What were some of the smaller sizes of those defects of holes?
From what I recall, like I said, I think it was around 3 to 5 millimeters, maybe some of the smaller ones.
Just like a tooth mark from a dog, maybe.
How big is 3 millimeters in inches?
It'd be probably around like an eighth of an inch or so.
Can we go to the next slide, please? What are you describing when you say the word fundamental, or do you write the word fundamentals?
So I want to discuss some very basic concepts that I hope will kind of resonate as we go through the PowerPoint so that you have an understanding of the underlying physics and what I'm talking about.
Physics.
Can you go ahead and describe the role of an accident reconstructionist and the fundamentals that an accident reconstructionist undertakes when performing the kind of testing that you performed?
So as I mentioned earlier, when I was describing what a simple definition of accident reconstruction is, it's the application of physics and engineering to collision events. So I want to go through some very basic elements of that so that you have an understanding of the physics.
Can we go to the next slide, please?
He's going to teach us about physics.
What are we looking at here?
So this might be something you all remember back from high school physics, but even though it's been around since the late 1600s, we still use these laws today. So what we're looking at here is what I've done is just describe Newton's laws very simply. So, and again, you might be familiar with these. So for instance, if we're talking about Newton's first law, an object at rest tends to stay at rest and at a constant speed unless it's acted on by an outside force, right? So if my arm is just here, right, it's just going to stay there until I give it a push or a pull, right? When I do that, that's going to induce an acceleration, right? So that's when we get into Newton's law, where if I apply a force to a mass, I'm going to cause it to change its speed. It's going to accelerate. And then Newton's third law, basically the law of reaction, indicates that when I push on my arm, there's also an equal and opposite force going back to my hand that I'm pushing with.
What role did these three very fundamental laws of physics play in your reconstruction or your ultimate opinions and conclusions following your accident reconstruction in this case?
So when we're talking about the concept of acceleration, what you will see in the dynamic test that we did and conducted, we measured the acceleration of an arm when it's impacted by a taillight. If we know the mass of the arm and we've measured the acceleration, we can use Newton's second law, which is force is equal to mass times the acceleration, to calculate what that force is applied on the arm, which ultimately you will hear from my colleague, Dr. Rentschler, to talk about that.
Is that broadly considered a force analysis?
Yes.
What role did force analysis, your force analysis, play in the accident reconstruction that you did or you undertook in this case?
Well, there's certainly going to be a correlation between the impact speed and the damage that we see. The higher the impact speed, the greater the force. So from my perspective, I was interested in the speed and the force to look at what's the observed damage to the test taillights that we did.
Do you think that's fundamental to an accident reconstruction?
Yes.
Did Dr. Welcher engage in any force analysis with regard to John O'Keefe's arm and the taillight?
Not that I'm aware of, no.
He just didn't.
Let's move to the next slide, please. What are we looking at here?
So don't be too afraid. This is some really simple equations that I want to show you. So that first one, delta V. So what do I mean by that? That simply just means you could think of delta, change in. So change in velocity. So if you look at that equation, the change in velocity, really simple. If I've got an object that's, let's say it's initially, for what V naught is, initially at 0 miles per hour, I hit it, and it's now moving 10 miles per hour. That means it underwent a change in speed of 10 miles an hour and is moving at that velocity. Acceleration is essentially how quickly did that velocity change occur, right? Did it go from 10 miles an hour in a split second, or did it go to 10 miles an hour over a few seconds? So depending on the timing of how quickly that change in velocity occurred will determine what the acceleration is. And as I've already mentioned on the previous slide with Newton's second law, we can then take that information about acceleration and apply it to, if we have a known mass, to calculate what the force on that object is.
How did these math equations, delta V, acceleration, force, how did these play into, what role did they play in terms of the accident reconstruction here, in this case?
Well, they're extremely fundamental. And I think as we go through the PowerPoint, you will have an appreciation and understanding of what these concepts are. You'll see that I have plotted graphs with acceleration that shows the rate in that change in speed over time. You will
Everyone hit the like button if you have appreciation for Dr. Wolfe's testimony.
see graphs of delta V, so the change in speed of the arm as it's being impacted by the taillight. And then ultimately we can calculate the force of that impact to be able to assess whether or not there's a mechanism for the injuries. And as I mentioned, that'll be my colleague, Dr. Rentschler, that will discuss that.
Can I ask you about delta V specifically? I'd like to focus on that for a second. Is that okay?
Yes.
When you say that that equation suggests or dictates that an object that is struck by another object with mass moves up to the same speed of the object that struck it, describe that in a little bit more detail in colloquial terms, if you will. Sixth grade terms.
I'm sorry, can you rephrase the question?
Probably not. Because I don't understand it as well as you do. If an object, does delta V describe the circumstance in which you have an object that may be at rest and it's struck by another object moving? Is that calculating the speed at which the object that is struck moves to the same speed as the object that struck it?
So that's sustained. Just ask him a simple question, let him answer.
Easier said than done. Sure. Can you describe in more conversational terms what delta V is describing in terms of mathematics?
Right. So let's just give an example specific to this case. If the majority of the arm is struck by a 6,000-pound vehicle moving, let's say at 20 miles an hour, that arm will experience a change in speed. It'll go from 0 up to about 20 miles per hour due to that impact. So that would be the change in speed. If my arm is at rest, stationary, is impacted by a 6,000-pound vehicle, it's going to change its speed up to roughly what that impact speed is.
Oh.
And what about acceleration? What are you describing, or what is math or physics describing in that equation in terms of the time it takes for that arm to now move from 0 to 20?
Right, so that's how quickly that change in speed is occurring. So to give you maybe an example you're more familiar with, let's say you're driving down the road, you come up, you see a red light at the intersection, right? You're gonna get on the brakes lightly and your vehicle is going to change in speed, right? It's going to slowly decelerate. Let's say you're driving and a deer jumps out in front of you, you gotta slam on the brakes, right? You're gonna change your speed much quicker. So that's an example of two different rates of acceleration. One where you're mildly braking, right? You're gonna coast down slowly, versus a sudden, emergency in front of you like a deer, you're gonna slam on the brakes and your speed change is gonna be it's gonna happen much quicker with that acceleration rate.
Are there circumstances in which the acceleration can be from 0 to say 20 miles an hour in milliseconds?
Yes, when we're talking about impact durations, especially of this nature, yes, they're not going to be, we're not talking about the impact occurring over a second, 2 seconds. That's extremely long. Even a duration of a couple hundred milliseconds in the context of this is considered long.
And then, of course, the force calculation is associated with the delta V and the acceleration calculations. Is that right?
Correct, yes.
In what way? What are we looking at in terms of that a little bit more complex calculation?
Absolutely. So if you look at the bottom equation there, where I have force is equal to mass And then that top component is the change in speed, right? That delta V, V1 minus V naught, divided by the change in time, T1 minus T naught. So if you substitute in that equation, right, that's delta V over delta T, which is acceleration. So there's a relationship between all of these equations.
And do all of these equations, or did all of these equations assist you in coming to determinations and opinions and conclusions concerning this case?
Yes.
Are these normally accepted methodologies in determining delta V, acceleration, force, all the force dynamics or impact dynamics in an accident reconstruction?
Absolutely. They are the core of physics.
Can we go to the next slide, please? What are we looking at here? Scientific method. What does that mean?
So the scientific method is a process that scientists typically use to be able to reach conclusions. And so you could think about it in this case, we make an observation, right? We have injuries to the arm. We've got a damaged taillight. So let's try to do some research to figure out, okay, has anyone done testing with that, right? Has anyone hit an arm with the taillight, see what happens, see what the forces are, right? And then we start to make a hypothesis, right? So what happens, it's kind of an if-then statement. If the arm contacts the taillight, does the taillight break? Does it not break, right? What's the hypothesis there? And
Magic
at
question.
least my understanding of reviewing Dr. Welcher's work, it appeared to be that his hypothesis.
Sustained. Next question.
Sure. Did you review, well, let me ask a different question. Going back to the calculations previously, the delta V, the acceleration, the force calculations that you described to the jury, did you see anywhere in any of Dr. Welcher's reports or his data that he undertook those core calculations?
No.
Oops.
With regard to the scientific method, did you see whether or not Dr. Welcher followed this scientific method as you're explaining it to the jury?
Sustained.
What did you note, or what opinions or conclusions did you come to about the scientific method, if any, that Dr. Welcher did or did not undertake?
Sustained.
Somebody's keeping track of the
Did
sustained
you review
objections.
Dr. Welcher's entire database? In other words, all the reports, all the raw data, and his PowerPoint?
Yes.
Did he undertake the scientific method as you know it?
Right, so that's sustained.
He didn't use the scientific method.
Continue to describe the scientific method as you know it and you employ it.
Certainly. So again, from reviewing Dr. Welcher's report, he indicated.
Sustained. I'm going to see you at sidebar.
He had to stop again. Did you see? Because Hank Brennan must be doing some sort of motioning or standing up when he's about to object, because he literally just, Dr. Wolfe just stopped and was like, okay, what now? As of a couple of objections ago, 50 Shades of Yuri Buchanan is keeping track and said there's 24 sustained and 0 overruled objections by the Commonwealth. Watch his face as he knows he's about to get stymied again. Dr. Wolfe, when he's just trying to get out, that Welcher didn't even use the scientific method or any physics type calculations. Watch.
Certainly. So again, from reviewing Dr. Welcher's report, he indicated.
Sustained. I'm going to see you at sidebar.
Really? This is why trials are called oftentimes the battle of the experts, because one expert will come in and try and prove that the other expert didn't know what they were doing or that their opinion is crap for whatever reason. And the judge, for some reason, doesn't want the jury to be able to hear about that. This is not new. This is simply a review of Dr. Welcher's report by another highly qualified expert who says he didn't use any physics calculations and he certainly didn't use the scientific method. But what he did do is dress up just like John O'Keefe and stick his arm out at the height of the taillight, which any person of any height could do, by the way.
Dr. Wolfe, may I inquire, Your Honor?
Yes.
Dr. Wolfe, where are we on the chart? I've lost my place.
I think hypothesis.
Okay. Let's describe, if you would, please, what role hypothesis plays in the general scientific method.
So generally, it's like I said, it's an if-then statement. So if you make a statement, if the arm contacts the taillight, then the taillight will shatter, right? So you want to do tests and experimentation and analyze that data to see whether you can accept or reject that hypothesis.
Rejected.
And what's the next stage?
So as I mentioned, after hypothesis, it's once you've determined that, what your hypothesis is, you want to test with experimentation, analyze that data, and that certainly may be an iterative process that you do multiple times to then be able to draw a conclusion from that analysis and testing.
What's the next stage?
To basically report those conclusions and findings.
Why is it important to report those conclusions and findings?
Well, I think so that you can, whether you can accept or reject the hypothesis that was put forward earlier.
Do you have to analyze the data following the testing that you undertake?
Yes, like I mentioned, I think it's an iterative process, because certainly you could do one test and it may not be clear what the answer is at that point, so you may have to do additional tests to basically parametrically evaluate your hypothesis.
Did you see this well, let me ask you first, did you undertake this scientific method with regard to your reconstruction or your testing in this case?
Yes.
Did you observe this same scenario in Dr. Welcher's report?
Sustained as to that point, Mr. Jackson.
Did you see this undertaken anywhere else?
Sustained there.
He didn't use a scientific method, and he didn't have a hypothesis.
Did you look for testing in Dr. Welcher's evaluation, all of his data?
Yes.
Did you find any,
No.
other than the static blue paint test?
That was the only test, correct.
Did you see any force dynamics testing?
That's leading, so you can
Sure.
get to it without that.
What about any other testing? Anything else that we've talked about? Do you see anything else done in Dr. Welcher's
As it
report?
pertains to an analysis to the taillight and the damage and the forces, no.
Let's move on to the next slide. Did you actually undertake testing in furtherance of the scientific method?
Yes.
Yes.
Oh, yes. Oh, yes. I guess he did.
Let's move on to the next slide and you can describe what we're talking about. What are we looking at here?
So you're looking at a test matrix of the various tests that we conducted at ARCCA. I could go through them one by one if you want.
Oh, sure.
Let me ask you foundationally, was your testing directed toward determining whether or not the scenario proposed in Dr. Welcher's report was consistent or inconsistent with what you would find ultimately?
The objection sustained.
Of course it is.
Was your testing specifically designed to determine whether the damage to Miss Read's vehicle, her Lexus, was consistent with the scenario that was proposed by Dr. Welcher?
That's sustained too. Ask it differently, Mr. Jackson.
What was your testing? What were you engaged in terms of your testing? What were you trying to find out?
Well, I think it was to, again, we talked about earlier about that hypothesis, right? My understanding, Dr. Welcher indicated that the arm contacted the taillight, but there was no analysis or testing to determine what's the expected outcome of that. What's the damage to the taillight?
So you answered the first question. I'm striking that second part. Ask another question.
The
Was there
jury's
anything
gotta be
else?
dead.
I think simply put, it's to find out what happens when you impact an arm with a Lexus taillight at various speeds. What happens?
What was your understanding of Dr. Welcher's hypothesis?
That's sustained.
He didn't have one.
Did you have an understanding of Dr. Welcher's hypothesis?
That's sustained too.
Did Dr. Welcher state a hypothesis at all, ever? Listen,
Ultimately,
they have the opportunity to bring Welcher back on rebuttal. And yes, Hank Brennan, I welcome ARCCA. I don't have any problem with ARCCA testifying. I welcome them. I can't wait for ARCCA to testify, but they communicated on Signal and they didn't turn over their messages. And so you should strike them. And yet he's objecting to every single question. Welcher was a clown. Welcher, his dad told him he could have been a doctor, but he decided not to be a doctor. His dad told him not to be a doctor. And so he became a biomedical engineer. And he sold his company to Aperture a couple of years ago for something like $270 million. I don't know how much of that money he got, but he was arrogant. He was smarmy, put his arm up on the desk. He was leaning over towards the judge, and he had no hypothesis. And he dressed in John O'Keefe's clothing, bought a cocktail glass from the same distributor as the Waterfall, and put some blue. It was like a Nickelodeon experiment. But, we welcome ARCCA's testimony. No, you don't. No, you don't. You're scared to death of it right now. We can all see it. The world is watching and we can all see it. Tell me if you can see it.
What were you trying to find out through your testing?
As I mentioned, I think it was to determine when you impact a taillight at 10 miles an hour, 15 miles an hour, 25 miles an hour, what happens to the taillight? What's the expected damage? What happens to a sweatshirt when it makes contact with that? What happens to the fragments? How does the arm move? What's the acceleration of the arm? What's the change in speed of the arm? And certainly, as I mentioned, my colleague, Dr. Rentschler, will discuss what are the expected injuries in that type of impact.
Did you see any of those questions answered in Dr. Welcher's report?
Yeah.
Ask it differently.
What did you see in terms of Dr. Welcher's report as it relates to those types of questions?
He got sustained.
Ultimately, did you undertake a methodology to perform the testing to answer the questions that you just explained needed to be answered for this jury?
Yes.
Describe that, please.
So we started out, we kind of worked at this incrementally, right? We didn't start right off the bat with utilizing an exemplar Lexus going right into an ATD or a test dummy, right? We wanted to start in the laboratory to have an understanding what happens at a range of speeds, in this instance, in our first two tests, between 10 and 17 miles per hour, right? What happens, what kind of damage do we observe, right? At 10 miles an hour, do we even break the light? At 17, what kind of damage do we get? What kind of accelerations do we get? And then we moved up to full-scale vehicle impact testing.
Is that methodology that you just described generally accepted in the field of accident reconstruction, in the broader field of engineering?
Absolutely. Everything from utilizing an instrumented test dummy to using an exemplar vehicle to all the data acquisition systems that we had in the laboratory as well as the vehicle. All of that is generally accepted techniques in the field of accident reconstruction to evaluate what we did in this case.
And are those techniques also supported by peer-reviewed articles in scientific literature related to accident reconstruction?
Yes.
Did you rely on this methodology that you just described to render opinions and conclusions as it relates to this case?
Yes.
Have you relied on that same methodology in rendering opinions and conclusions in other courts?
Yes.
Let's go to the next slide, please. What are we looking at here?
So we've gone over this before, but this is looking at the exemplar vehicle that we utilize for the latter part of our testing. You're looking at again, just annotating where the liftgate taillight is, as well as the quarter panel taillight.
When you say exemplar vehicle, what is this SUV that we're looking at?
So it's the same year, make, and model of the subject vehicle. So it's a 2021 Lexus LX 570. So it's the same weight, same geometry, same as the subject vehicle.
Is this a picture off the internet, or do you actually?
Brennan is going to say, but the exemplar that you used is white and not black, right, sir? See if they bought it. Let's see if they bought one too.
Same geometry, same as the subject vehicle.
Is this a picture off the internet, or do you actually have access to this truck?
We have access to that vehicle, yes.
Did you purchase it and bill it to my client?
And ultimately, what testing did you undertake specifically as it relates to this particular vehicle?
We did full-scale vehicle testing with the vehicle driving into an ATD arm, as well as an ATD arm attached to a dummy, and then a full-on impact to a test dummy.
Full-on impact to a test dummy.
Did you assess the damage to the right taillight after these various tests?
Yes, after all of the tests.
Did you assess the acceleration and quantify the forces that were involved?
Yes.
did you assess the material and textile damage to the clothed ATD?
The dummy
Yes.
had clothing on.
Ultimately, did you conduct lab tests in an effort to answer some of these questions as well?
Yes.
And you've already mentioned this, but you utilized in your testing the exemplar vehicle to the fullest extent that you felt necessary?
Absolutely.
Were
Yes.
you hampered or hindered in any way in terms of damaging the vehicle or utilizing the vehicle in any way that you wished?
No.
Let's go to the next
Remember,
slide,
Rentschler said
please.
he didn't do full speed testing because he didn't want to damage the car because they wanted to resell it, right? Isn't that what he said?
What are tests A and B? What are those laboratory tests?
So these were the initial 2 tests that we did to get an idea of starting to test this hypothesis. As I mentioned, we weren't sure at 10 miles an hour what would happen to the taillight. We wanted to see what would happen at 17 miles an hour with the arm. So again, it was to evaluate from a starting point what happens in this interaction based upon how Dr. Welcher had his arm oriented in his PowerPoint and analysis.
Next slide, please. What is this?
So you're looking at a photograph of our lab setup. You can see on the left side of that is our Hybrid 3 anthropomorphic test device. To the right is a linear impactor, and this is something we already have in-house that we built years ago for our testing that we do for the National Hockey League when we're looking at, what's the accelerations on an impact to a goalie wearing a helmet, right? We use this same device for that type of testing to measure head acceleration. So we applied this same linear impactor to be able to project, if you will, or accelerate the taillight at a known speed into the ATD arm.
What are some of the instrumentation that you use in addition to the mechanical impactor? What's some of the instrumentation that you use to track the data?
Certainly. So you could see, I'll get my, see around here. So at the top here, there's a blue camera here. There's another blue camera here. So these are our high-speed cameras. And you'll see there's a bunch of lights around those high speeds. That's just because the frame rate's so high. And again, it's only sampling a very, very short amount of time. So you have to have a lot of light when you do these high-speed tests. So we have the high-speed cameras running. We have an accelerometer mounted to the ATD arm here on the other side. So that's some of the instrumentation. There's also a couple other cameras that we're documenting this overall.
Can we move to the next slide, please?
I mean,
What are we looking at in these photographs?
So this is looking at, and not to be confused, this wasn't the arm position when the impact occurred. This is just showing you the setup. So on the left is just kind of an overall shot, and then on the right here is a uniaxial accelerometer. So that's going to measure, we talked about that term earlier, right? The acceleration. So that's going to measure how quickly is this arm changing its speed, right? What's the acceleration of the arm as it's impacted?
if you're not looking at your screen, come to your screen and just rewind a frame and check out their setup. Check out how they are conducting this experiment, and it makes Welcher's experiment look even more Nickelodeon-like, if that's possible. And this is what real scientists do. This is what real accident reconstructionists do. And I can't even imagine how much it costs, because now, remember, they didn't do this testing until they were able to be hired by Karen and her team. Imagine how much this testing costs. And so every dollar that all of you donated to the defense fund, that's what this was going for. I can't even imagine how much it cost.
Does that accelerometer put into motion some of the mathematical formulations that you talked about earlier?
Yes.
Let's move to the next slide, please. Tell me about these photographs.
So the importance of this is, more specifically looking at the right photograph here, might be a little bit hard to see, but we wanted to get the same exact sweatshirt or hoodie for the testing to evaluate if the taillight breaks, is there a mechanism for the fragments to penetrate and cause holes in the sweatshirt, as were observed in Mr. John O'Keefe's sweatshirt.
Next slide. Were you successful in finding the exact replica sweatshirt?
Yes, and I will note, as I mentioned, I know it probably is hard to see, but the material blend on the sleeves are the exact same. They are 60% cotton and 40% polyester.
But they're different sizes and different colors.
Is it important in your mind to maintain consistency with the data that you had received concerning John O'Keefe's clothing?
Certainly, I think we wanted to try to control as many variables as we could.
Let's move to the next slide, please. Test A. Describe Test A for us, please.
So you're going to see a series of photographs and then videos, but Test A was mounting a preconditioned taillight on that linear impactor to accelerate it into the Hybrid 3 arm to, again, evaluate the damage to the taillight and the acceleration to the arm.
Let's move to the next slide, please. What are we looking at in these photographs?
So you're looking on the left, a photograph just before the impact test was conducted. On the right, you're looking at a thermal image that is depicting the temperature profile of the taillight.
Describe that thermal image.
Certainly. Your Honor, may I refer to my notes?
Thermal images. Thank you, Miss Macy. I love you with all of my heart, and your family too. I was today years old when I started liking physics.
So what I did is I analyzed the profile of the temperature down in this area. And when we look at that segment, that lower portion here, where contact was made, the average temperature in that area was about 34 degrees with a minimum of about 33 degrees.
How did you get that exemplar taillight down to around freezing?
So all of the taillights that we tested were preconditioned overnight in a freezer.
Why was that important?
Freezer.
Well, it's my understanding that at the time that this allegedly occurred, the ambient temperature was 31 degrees Fahrenheit. So as I mentioned earlier, certainly there's a correlation between how plastics perform in cold weather. So we wanted to take that variable into account in our testing to precondition them down to temperatures that were consistent with at the time of the alleged incident.
Just to clarify for Charlotte, ARCCA was paid by the FBI the first time for all the initial. This, I believe, is additional testing, because now what they're doing is they were hired by the defense team to do additional testing to refute what Welcher did and to point out why what Welcher did was not adequate, didn't follow the scientific method, had no hypothesis, and didn't use any physics in his analysis. So yes, they were paid initially, but this is all new testing. Chat, correct me if I'm wrong. It's all new testing as far as I can tell. So great question.
What are we looking at in this slide, on this photograph?
So this is a video. Do you want me to go ahead and play the video?
Tell us what we're about to see,
do.
and then I'll ask the court's permission.
So you were looking at a camera that is mounted above the entire setup. If you look at the top portion of this video, you will see the taillight. Part of it's covered by the high-speed camera. But what will happen is the linear impactor will fire, and the taillight will be accelerated up to 10 miles per hour, striking the clothed ATD arm.
With the court's permission,
Okay.
let's go ahead and play the video.
And watch the video, my friends. Dr. Wolfe, did you give the dummy a big hug before you started testing? More of a Leslie wants to know.
Next slide, please.
I want to know too.
What is this?
So this is also a video, but with the high-speed camera. So it's the high-speed camera that's looking top down at the arm. So you will see when the video plays, you will see the taillight enter from the left and contact the arm. And I will note that this is essentially slow mode, so it's not happening in real time. So you'll see the taillight slowly moving, but it's actually in reality moving at 10 miles per hour.
Understood. Go ahead and play that.
Wow. I would have crushed his arm. Come on, man.
Can I ask a question now that that's played? How did you mount the taillight to the accelerator, that linear accelerator?
Right. So we had to get a little bit creative there because you may
Look
have
at this.
observed this when we had the physical assembly out earlier. The back of that, it's not some nice clean surface that we can just bolt on. So what we had to do is 3D print a bracket that we could bolt onto the linear impactor, and we used a polyurethane expanding foam to be able to marry those two together so that we could then bolt it onto the linear impactor to use it for this test.
Did you see any debris from that foam mounting mechanism?
Yes, there's a few flakes you can see of that polyurethane foam
I
off
love
the
it.
backside, kind of going into being dispersed there.
And they're letting it loop while he testifies. It's just looping. Just looping. Love it.
Okay.
That's
With
only
regard
10
to
miles
this
an hour.
particular 10-mile-an-hour test, what did you note in terms of the damage to the taillight?
It was very minimal.
And what did you note in terms of any damage at all to the hoodie?
There was none.
We'll go to the next slide, please.
There it is.
What are we looking at in this slide?
So this is looking at a side view. So same test, just looking at it from the side. And similarly, you'll see the tail light come from the left and impact the arm.
If we could play this, please.
Looks like a marionette. Oh my God, that arm would have been
What did you note in terms of deflection of the arm, the test arm?
Well, the arm essentially, and we'll see this in the data later, it reaches a common velocity with the tail light. Based upon the portion of the arm that was contacted, again, consistent with how Dr. Welcher has it oriented, it will become accelerated up to 10 miles an hour roughly.
Over approximately what period of time is that arm accelerated up to 10 miles an hour along with the taillight?
We'll see it on the data plots. I think it's about 10 milliseconds or so.
looping.
How long, do you know how long an eye blink on average takes?
Off the top of my head, no, I don't. Probably pretty quick.
Somewhere around 250 milliseconds? Does that sound right?
Sustained.
He tried to get it in there. I guess an eye blink is 250 milliseconds. That'll leave a mark, I think. What do you think? Think that'll leave a mark? 10 miles an hour? Not just a mark, a fracture.
Let's move to the next slide,
Bruising.
please. What are we
Taillight
looking at in
did
this
not.
series of photographs?
So these are extracted frames from the high-speed video that we just saw on the previous slide, basically showing just at contact, just after contact, and then post-contact, so you can see the kinematics of the arm and how the arm is moving.
Kinematics.
Okay. Let's move to the next slide, please.
Remember when Trooper Paul was asked if he knew what kinematics was?
What is this photograph?
So this is photographs taken of the taillight after the 10-mile-an-hour test. I will note that there was a couple small fragments of the clear portion of the assembly, the outer lens that was missing from that turn signal area towards the left here. There's a couple fragments missing, and then there was some small fracturing here in that area.
How would you describe the damage to the taillight at the 10-mile-an-hour test?
If I may go to the next slide, I think it might.
Sure.
So this was the totality of that damage at 10 miles per hour. So I would describe it as minimal and superficial.
Okay. Next slide, please.
He just disproved Welcher, who said that anything above 8 miles an hour hitting that arm would have shattered that taillight, correct? That is what Welcher testified to, right?
What is this?
So this is the photograph that I just shown you compared to that of the subject taillight, so that you can have a side-by-side comparison of the test taillight compared to that of the subject.
Were you able to reach any opinions and conclusions about whether the damage to the subject taillight is consistent with striking an arm at 10 miles an hour?
It's inconsistent, in my opinion.
Next slide, please.
Sue O'Connell says all jurors are riveted to the screen. This is what
This is
everybody
still
wants
test
to
A,
see.
is that correct?
Correct.
Were you able to reach any opinions or conclusions as to whether or not the damage to Mr. O'Keefe's clothing is consistent with being struck by the taillight at 10 miles per hour?
What I observed from the test is that there was no mechanism to create any of the holes that we observed on the subject sweatshirt.
Do you
There it
hold that
is.
opinion to a reasonable degree of scientific certainty,
Yes.
as well as the former opinion that you just gave us?
Yes.
Next slide, please. What are we looking at in this graph?
So this is a graph that shows the roughly, on the next graph, you're going to see a 24 millisecond window. So what I want to show you on this graph is what does that look like over a full second, so you can have an appreciation of just how quickly this is occurring. As you mentioned earlier, I think your comment about a blink of an eye, this is even shorter than that. We're looking at, as you'll see on the next graph, again, it spans over just a few milliseconds. So that yellow tick that you see in the middle there, what I've done is I've plotted that over a full second. So 1 second is equal to 1,000 milliseconds. So if we go 500 milliseconds to the right, 500 milliseconds to the left, this whole graph represents 1 second in time. This impact duration is occurring very quickly.
1 second, is that reflected from the beginning of the graph to the end of the graph? That's representative of 1 second, is that right?
Correct. So starting at this y-axis all the way to here is 1 second in time, with our impact duration happening over just a few milliseconds.
Do you think that Dr. Wolfe knows his bits from his bytes? Asking for a friend.
10 miles an hour?
Yes.
Next slide, please. What are we looking at in this graph?
So we're looking at the acceleration or the change in speed over time, that parameter that we discussed earlier. So what you can see is that as the arm is impacted, we had the accelerometer mounted on the inside portion of the forearm, if you will. You see that it starts to accelerate, right? Because it's changing its speed, and then it starts to level off after the impact has subsided, basically, and it's reached a common velocity.
What do we see in terms of the G-forces that the arm is subject to?
So the peak is occurring right around here at about, looks like just over 6 milliseconds. And the peak acceleration is just over 130 Gs.
And what does that mean? What is a G?
So a G is acceleration due to gravity. So if we're being held down by 1 G, so you could think of it as basically a multiplication factor, that it's 131 times the acceleration due to gravity.
And the next slide, please. What are we looking at in this slide?
So this is, again, that concept that we talked about earlier, delta V. This is the change in speed. So if we do some math to the previous data that we collected, it's a technique called integration, but we can actually add up all of that acceleration to determine what speed did the arm get up to. And when we do that calculation to this data, what we see is that initially at the impact, right, the arm's at rest, right, Newton's law, first law. And then we impart a force on it in terms of the tail light impacting it. It's going to cause the arm to accelerate and change its speed. So as I noted earlier, it's essentially going to reach a common velocity with the impact force based upon how Dr. Welcher has the arm oriented. And we can see that it's a tick over 10 miles per hour at just over 10 milliseconds. So that means that the arm in a 10 millisecond period is going from 0 up to about 10 miles per hour, which was the speed of the impact.
And 131 times the force of gravity is exerted on the arm at the same time?
Sustained us to that point.
Where does gravity play into this? What is the 131 Gs? Where's that force exerted?
So that is the acceleration that the arm experienced as a result of that impact. So that's how quickly it was changing in speed.
Understood. Let's go to the next slide.
So is this a good place to
It
take
is.
the morning recess? All right, folks, we'll take a recess. Dr. Wolfe, please file.
Yeah, because I think Brennan's really hyperventilating.
Emergency counsel regarding just scheduling, please.
All rise for the court, please.
To scheduling, Bev's biased beratements points out Commonwealth had all of ARCCA's testimony before trial. They had enough evidence to see that Karen Read was not guilty and still went ahead with the persecution. Right, Melanie? Yes. Yes, yes. You're correct. 100% correct. They did. They had it before the first trial because the feds hired ARCCA to do this accident reconstruction. And the U.S. Attorney of Massachusetts at the time, the acting U.S. Attorney, Josh Levy, had a conference call with both the prosecution and the defense and said, in good conscience, I cannot allow the Karen Read case to go to trial. So here's 3,074 pages of our investigation. It's protected under federal protecting, there's like some sort of protective order over the documents and the information, so they couldn't release it to the public. But here, take it. And included in those 3,074 pages was the ARCCA reports, the group text messages among the friends and fam, telling the guy never went in the house. She's telling them everything. Proctor's text messages. And they still went ahead with this persecution. Yes, they did. I know. It strains credulity, but we've been here for season 1. We did all the pre-trial for season 1, and we still can't believe it either. No messy with Alessi. I pray the jury sees the bias by Bev and Brennan. Welcher was allowed to tell a bedtime story. I'm screaming at the TV. I'm nervous about the jury after the last trial. Love you, Mel. You're the best. Oh, thank you. You're very sweet. All right. So we see at the high top, behind the O'Keefe family and friends section, which only seats 10, there is room for 10 media passes each week that has been allegedly randomly generated. Some reporters have received a pass every single week. Some have received none or hardly any. And if somebody doesn't show up that day, there's a standby line. So today I think this is Sue O'Connell on the left in the black shirt. Aidan Carney here in the blue shirt, light blue shirt, short sleeves. Jess Machado all the way here on the right. Sitting next to Jess, is that Ted Daniel? I'm not sure. I don't know how many minutes she's going to take, but we're a little bit behind, so we have some time to scooch forward. Well, that was fun, wasn't it? They built a cannon. They got some crash test dummies. Far cry from Dr. Welcher. No wonder Hank Brennan was so scared. Melisa points out that hypothesis or hypotheses after results known or harking is unethical in academic research. Blessings. Thank you, Melisa. You guys teach me so much every single day. Chloe Albert's Revenge says, but Trooper Paul said there was a pirouette and stuff. Where's the stuff? Don't see any stuff. I want stuff. Funny. Ms. V, I love looking at Dr. Wolfe's bits and bites. Oh, that's cute. Paulina, the clarity of the defense presenting their case. Yeah. Here's the difference, you guys. If you were here for season 1, because ARCCA was under contract with the feds, the federal government, the FBI, they were not allowed to be hired by the defense for season 1. So the defense attorneys could not prep them. They could not talk about their testimony. All they had to go with was the report. They didn't have any of the materials that the feds turned over to ARCCA. And this was what all that infighting was about before trial 2. Hank Brennan wanted all of the materials that the feds turned over to ARCCA. And Alan Jackson was like, we don't have it. We don't have it. We did not give it to them. The feds gave it to them. This is a very unusual situation. I've never seen it happen ever. And so the water was a little bit muddy. Nobody really knew how to handle this. The defense was not allowed to prep ARCCA, these witnesses, before the first trial. However, they did an excellent job. And so it wasn't until, I think, March, you can correct me, Chad, if we're very collaborative here, until March that Welcher is sobbing uncontrollably, says Joseph Fax. It wasn't until, I think, March of this year, or March, I think, because the trial started in April, that Karen Read's defense team was given the green light to go ahead and hire ARCCA themselves. And so that's why they did all this additional testing. That's why this is so much more clear, I think, this time, not just because of the additional testing, but because they were actually able to speak to them and prep them before the second trial. You picking up what I'm laying down? Thank you, Paulina. That is a great point. Maria says, sorry, Hank, no coming back from this. A lot of people think that. A lot of people think that. Kim Jong Kanone equals keeper to the gates of hell. Are you quoting me? Change your name. If the jury doesn't see that, Bev and Hank are clearly blocking them from hearing certain details. They're not listening. Clear Air said professionals versus pretenders. Michael and Yvette are here from Texas. And they say, side note, after Bev's sticky note, all questions regarding Welcher have been objected and sustained. The fix is in. FBI and the world is watching. Thanks for your opinions, Yvette and Michael. Appreciate it. Shout out to Boots on the Ground. Shout out to the Boots on the Ground who are watching. Scott, Natalie, Dina from the buffer zone. Love you guys. Love you guys. Keeping the faith. Keeping the faith. Like George Michael used to say. You got to have faith, the faith, the faith. baby. And we do. We're having faith because Dr. Wolfe is here. Who's afraid of the big bad wolf? Hank Brennan. Hank Brennan's afraid of the big bad wolf. And now you see why. And wait, just wait. Because I think I did hear Dr. Wolfe say, ultimately, you will hear from my partner, Dr. Rentschler. So I don't think he's going to testify today. Wouldn't that be great if he testified last? Because his job in all of this was to determine whether or not the injuries to the body of John O'Keefe are consistent with this exact experiment that we're seeing now, getting hit by Karen Read's Lexus at whatever miles an hour the Commonwealth is going to go with now. I'm sure they tested many different speeds. And so his job will be to come in and say, no, absolutely not. Because the arm would have looked like this. There's no way that these linear abrasions or whatever you want to call them, scrapes, lacerations were caused by an exploding taillight. It just doesn't happen that way. So shout out to the guys and gals out there in the buffer zone. You're doing the Lord's work. You're doing the Lord's work. And we thank you for everything that you're doing out there. Michelle, can Hank Brennan bring in signal? I know it doesn't matter. Oh, he will. He will. He brought it all out during his voir dire. These gentlemen, these doctors, have been subjected to 2 sets of voir dire hearings. The first before preseason. No, I think it was during the trial in season 1. They came in for, did they come in for 2 full days? I don't remember, but it was like during the trial and they did a full day. And they also came in this year in the preseason. And even though they were a little bit more highly qualified than Dr. Welcher, Dr. Shannon Burgess, you know, it was a close call. I don't think she said it was a close call on these 2 gentlemen, but she did say it was a close call on Dr. Maria Russell. The Blair Welch Project is here. Mel, help me out here. The car is the weapon. The light hit John. Why deny going near it in the Sallyport? Because it didn't shatter when it hit John. And so therefore, Proctor being over by that taillight gives more reasonable doubt that perhaps, just maybe, he might have given some pieces of the taillight to the taillight fairy, who then went over and sprinkled it at the scene. That's the theory. So why would they show an inverted video during trial 1? Why would they show an inverted video that made the passenger side look like the driver's side and the driver's side look like the passenger side? Try and hoodwink the jury until it was brought out on cross that actually it's mirrored or inverted. So when it looks like Proctor is going over by the driver's side taillight, that's really the passenger side taillight. So yeah, why would they obfuscate that? Ask yourselves that question. And I'm sure that the jury is. GB Guthrie, why is the question form for direct and cross different, and why does it matter? Thanks for all you do. When you call a witness in your case, you have to use a direct examination questioning method. You cannot use leading questions. When you're cross-examining a witness, which is a witness that the other side, who is a witness that the other side calls, you can say, isn't it true that you did this, this, and this? You would agree with me that you did this, this, and this, correct? Trying to limit them to yes and no answers. And so it is important that you are not permitted to cross or to use leading questions to question your own witnesses. However, we've seen Hank Brennan do that this entire trial. And Hank Brennan's method is that he asks the witness a question in a leading fashion, gives them the answer to the question in his question. It's objected to, sustained, and then he asks it again, and the witness knows the answer that he wants him to say because it was in the question. It's really not hard once you know what you're looking for to see that that's what he does pretty much with every witness that he's called so far. East Coast Chick, the difference in the actual level of science and physics applied between Welcher and Wolfe's analysis is absolutely incredible. Real science versus science. Yeah. Just joining, welcome. Court's on a short break right now. And then we will be getting back to Dr. Wolfe's testimony. Crash Daddy with the dimples. Michelle, the only people I see to the left of the court reporter where Bev might have passed that sticky note is someone to the Commonwealth. It goes from Hank Brennan, Lally McLaughlin, and the lady with the black hair. I don't know. Maybe somebody in the courtroom will. Maybe they saw it and they'll point it out. Maria, great question. How do they decide which 12 jurors will deliberate? Well, here's what they do. They take all the juror numbers. We have 18 jurors so far. Nobody's been dismissed yet, right? 9 women and 9 men. They take all the juror numbers and they're like little bingo balls, and they put them into this little like bingo drum, and they spin it around and they pull them out one by one. Now, if you go back and watch the first trial, you'll see, I think at the first trial, they were down to only 2 alternates. In Massachusetts, the judge picks the 4-person, and the judge picked the 4-person before they chose the alternates out of the bingo drum. In New York, the 4-person is always seated in seat number 1. In some jurisdictions, the jury picks the 4-person. So the judge in season 1 finale, not finale, it was maybe the penultimate episode, picked the 4-person as number 1, who was, some say, clearly not the most free Karen Read type facial expression person. And then he spun the drum and he picked out a bingo ball and he read a number of a juror that was clearly didn't think John O'Keefe got hit by a car based on facial expressions alone. Quickly like covered it in his hand, shoved it on the desk, picked out the other one, called out the number, quickly covered it in his hand, threw it on the desk. We rewatched it several times. It sounded like then he didn't show anybody these numbers, by the way. Threw them back into the bingo drum, and that was that. And the 2 jurors that were selected as alternates seemed to be, based on facial expressions and reactions during the trial, pro Karen Read. One of those alternates is an attorney, and she was hired by the defense team for this trial. Her name is Victoria George. She was there during jury selection. I don't think we've seen her since. She also has, I think, she was pregnant with twins during the first trial. So she's got babies at home. That is how it's done. Now, we watched another trial in this exact same courtroom. Margaret was the clerk. We liked Margaret very much. It was the Dr. Harry Turk trial. Dr. Turk was on trial for the murder of his wife, Katie McLean. Margaret showed all of the attorneys the bingo balls, had them all out on the desk so they could all examine them to make sure that every single juror was represented on one of those bingo balls. I'm just calling, I don't know what they really called. I'm just calling them that because it's something you can reference. Puts the bingo balls in there to make sure they're all in there, spins it around, pulled them out one by one and held it up for the world to see. This is the alternate. This is the other alternate. Complete transparency. Did not happen last time. And many people are of the opinion that perhaps there was some kind of shenanigans, tomfoolery, and ballyhoo going on with Jim, the court clerk. But that's how they decide. So that's a great question. Thank you, Maria. We watched it in the Turk trial. I'm not going to address any rumors about Kelly Dever being related to the McCabe's. There's some rumors out there floating around on Twitter. I don't know if it's true or not true. And because I'm a legal-based channel, I like to deal in facts and court papers and things that can be proven. So if you put rumors up in a super chat, it doesn't mean I'm going to read it. But the first part of this says that Mr. Read's paint tape, Alan Jackson was an Air Force mechanic, so he's familiar with this testimony. Yes, he's also wicked, wicked, wicked smart. Thank you for that. Mama 5 says, as an engineer, I appreciate this explanation for the jury. Judd continuously told Alessi he was confusing different topics and blew more smoke. Yeah. Yes. Miners Kel says, Hank goes up to the podium, added sticky notes, especially in redirect. I want to watch the trial and be able to watch the judge at all times. Yeah. We wanted to see Dr. Wolfe's testimony instead of focusing on Karen. We're part of that, but maybe the camera person is picking up what we're laying down. And Mama Mars points out tonight will be a fun Forensics Friday with Duty Ron and Ed Wallace. Yes, it will be. And so far, I think Dr. Wolfe is slaying. Anybody agree? How do you think he's doing so far? Becky, something just came to me. Why wasn't Karen's DNA found in John's hoodie? She was never mentioned, only unknown males. I don't know. Maybe chat. You can help Becky out with that. Was it tested for Karen's DNA? I mean, she did say she gave him chest compressions and laid on top of him. Matt 617 Boston says, couldn't this hurt Karen? John throws the glass at her taillight as she's leaving and backs into him in rage. Would explain cuts to his arm because it was already broken and jagged. Well, we're going to see what Dr. Wolfe has in store for us during the rest of his presentation. However, the Commonwealth has never had the theory that John O'Keefe threw that glass at the taillight, right? Could he throw a taillight at 37? I mean, could he throw that cocktail glass at 37 miles an hour? And it hasn't been the Commonwealth's theory. Now, remember when ARCCA initially got this assignment from the feds, they weren't really given a lot of information. I don't think there ever was a theory that he threw the cocktail glass at the taillight because they're real scientists. They're like, okay, well, let's think of, they found a cocktail glass there. So what could the cocktail glass break the taillight? And so they did that experiment basically on their own. I don't think you could throw it that fast, do you? It's a red herring, yeah. It's never been their theory. And I don't think it's going to hurt. I think so far this is a slaughter. Totally slaying. Becky said that's huge. It would have dislocated John's arm, would have shattered his arm. Bruised his arm. At the very least, there's no bruising. Hey, Willis, thanks for gifting 5 memberships. A lot of gifts today. Auntie Bev's Kangaroo Court and 3 Ring Circus, thank you for your 5 memberships. A lot of new members today. Thank your gifters. Not to be confused with grifters. Christine, thanks for gifting 5. Crafty Councilwoman also gifted 5. And Becky's Blue Eyed Paranormal gifted 5. That's at least 25 new members today already, and it's not even lunchtime. If you're a new member, check out the emojis that we have, especially for this trial. We've got a solo cup. We've got a leaf blower. We've got handcuffs. What, if any? The fan. We've got wait for us. That was from trial 1. A couple emojis, especially for Hank Brennan. The boss baby emoji, which we adopted after the Robert Tellis trial or during that trial. And there's a binky because he acts like a baby all the time. And then we've got How Dare You? The Derek Carney theme song. The puffy jacket, which hasn't gotten a lot of play this trial because the puffy jacket, Timothy Nuttall said at the first trial that he was absolutely 100% sure John O'Keefe was wearing a puffy jacket because he remembers everything that day, that he cut that puffy jacket off and it made a huge mess. Crystal Pond gifting 5 memberships as well as What the Duck. So that's like a lot. I lost track on my math, but it's a lot. Kelly Denver, Don't Call Me Dever, says, make sure everyone sees Auntie Deb's Dever video. I don't know if he made a video or if that was his live stream this morning. Kelly wants to know, what's your opinion of Proctor not being called? Concerns me a little. Curious what you think. I don't think Proctor can hurt them at this point, especially now. And I feel like Higgins needs to be called. I feel like Higgins needs to be called. They need to close the loop on Jennifer McCabe's 227 search, the butt dials. There's so many shenanigans that the jury hasn't heard about. And my personal opinion is they need to hear about a little bit more of the drama and the suspicious behavior that went on behind the scenes. And Proctor not investigating his friends and them being like second family to him. And Proctor's statements that he took of Jennifer McCabe and how each one was different and how she calls him a liar. It impeaches Jennifer McCabe even more. And so will they get a missing witness charge? We went over that motion the other day. I don't know. And so, I mean, listen, it's not over until it's over. So whether they're going to call these guys or not, really, nobody knows. I hope they do, because I really think the jury needs to hear a little bit more of the story, and I think they're probably dying to hear a little bit more of the story. And definitely, I don't see how Higgins could hurt. They need to know about him destroying his phone, cracking his SIM card in half, going to a military base to do it, putting it in 2 different dumpsters, getting a new phone number, the same exact day that Brian Albert did, got a new phone number, destroyed his phone. Why? Even if it has nothing to do with this case, it certainly leads to some reasonable doubt. My opinion, as of right now. The defense team knows a lot more than I do, though. I just feel like the jury wants a little bit more of the story. I know, if I was watching this for the first time? Dee, have you seen the picture from the new court reporter where she posted notes from the last trial? I don't know anything about that. No, I don't want you to email to me. I'm not going to get caught up in disparaging people who work in the courtroom. Are you kidding me? So that I can, no, not doing it. I have no idea what it is. I saw some handwritten. Who knows if they're her notes, other notes? Who knows if somebody didn't, Photoshop that into trying to disparage the court reporter? I'm not falling into it, but thank you. I'll still take your $5. Red's daughter, after Barrows and Lucky holding out for a hero, Bonnie Tyler, loving the portrait that the Glare made for Barrows. I didn't know that Glare made Barrows a portrait, but that's cute. What the duck if I did not thank you for the 5 memberships? Thank you. Melanie Little's middle finger. Did you see Auntie Deb's new musical release, Garage? Nope. He's so incredibly talented and funny, and I love him with all of my heart. Free Karen Read Justice for John O'Keefe. Check it out. Happy Crash Daddy Day to those who celebrate. That was Wayno. Wayno gets credit for that. Lady Dutch, question why Brennan didn't attack Karina on cross like he did with the rest, Barrows and Lucky. Perhaps he felt he was losing his battle. I have no idea what's in Hank Brennan's head. I don't think anybody does, except for like a giant earworm. I don't know. There had been reports that Karina was going to come in and testify that Jennifer McCabe told her that there was ring camera footage of Karen hitting John to try and pit her against Karen, but it probably wasn't allowed in because hearsay. So perhaps Brennan did not want to open any doors. Her testimony was not particularly, I don't know, crossable. What do you think? There's something particular that he should have crossed her on? I don't think so. ARCCA is not an insurance company. No. Cabby Stevens, I don't know what you mean. No, ARCCA is not an insurance company. They are an accident reconstruction firm. They are hired by such as people like the Department of Defense. And as one of my amazing moderators pointed out, Jessica, she's also, Christine, thank you for gifting 5. A veteran, where is it? I started. That the seats that they designed, ARCCA, saved many lives in Afghanistan. Thank you, Deborah Lee, for your 10. Sidebar check. Will the jury be allowed to handle the taillight during deliberating? Was it admitted into evidence? If it was admitted into evidence, they will. I don't know if it was just marked or if it was admitted because I'm distracted by the chat and all the other things I'm trying to do here, manning the ship. So if it is entered into evidence, they will be allowed to bring it back and use it during their deliberations. Sidebar check, and that is a great question. It was entered. There's your answer. There's your answer. Sometimes it's easier for you guys to pay attention than it is for me because, oh, look, something shiny. No. My job depends on this. As you know, when the Crash Daddies got Welcher's report, they absolutely laughed their butts off. Yeah, and I love how you change your username to Kelly Devers' testimony quote. Well done. Margaret, is Hank daft? The jury is listening to all these objections and are now wondering, what is Hank trying to keep from them and why? It's a long mid-morning break, and we were even a little bit behind. Right, no media. He couldn't mention that he saw something in the media, but Hank can talk about a blogger, yeah. Which had nothing to do with anything other than he wants to put it in front of the jury. And Lucky kept telling him, no, I did not feel threatened. Lucky was, in my opinion, the strongest and best witness for the defense so far. You tell me what you think. He was unshakable this year. Last year, he was a little more nervous. He was a little more uncertain. This year, he was like, you are not coming for me. And I thought he was fantastic. And as Kindergarten points out, we're tired of deleting rumors. So if you got timed out, it's because you're putting rumors in the chat. And we don't play that here. There's a lot of other channels where you can go for your drama. We don't do it. Well, so my granddaughter Leighton loves your voice. Oh, hi, Leighton. Thinks Brennan sounds like Donald Duck. Can you say hi to Leighton and Larson? Hi, Leighton and Larson. Mikey D's. Courtesy of Mikey D, your grandfather. Going to get in the pool during lunch. We love you, Melanie. Oh, I love you too. I love when families are all watching together. A lot of families have group chats every morning. Sending out my link. Patriotic is one. The first one, the first group chat that I ever was part of, I think. I'm not part of it, but they sent my link out and I love it. Again, this second cousin rumor, don't know anything about it. I'm not going to give it air or legs. Michelle, can Jackson say the FBI since the door was open? No, because the door is opened on a specific witness doesn't mean that it can be opened on a different witness. Because somebody says something by mistake, it doesn't mean that it can be used with another witness, but that is a great question. But as you can see, they had to dance around it. Let me know if you think it's clear that they weren't hired by Karen's insurance company or Turtle Boy. Rebecca, they should ask Dr. Wolfe about getting harassed by the Commonwealth since Hank wants to keep trying to say that Lucky wasn't, say that's a Lucky even after he said he wasn't. Well, it wasn't the Commonwealth that was harassing Dr. Wolfe. It was trolls on the cesspool of Twitter that found his wife's Facebook page and started blasting out pictures of his family and his children, which was horrific, trying to intimidate him from testifying, in my opinion, right? And I think he did bring out during voir dire that he was being harassed, that his wife is being harassed online. So I don't know if it's going to come out, but we'll see. We'll see what, I'm going to hold that for later because I don't want to help Hank at all. So there's that. Maureen pointing out that Dr. Welcher, proper experts ask for permission before referencing their paper reports. No electronic devices are being used by the expert in any capacity, with or without some permission, and she suggests that you grow some dimples. Miss Lisa would weigh around Bev's restriction not to mention Fedsby to ask the crash daddy if an insurance company contracted ARCCA so the jury can rule that out. That was my suggestion the other day when we spoke about it. And I just don't know if she would allow it because they had a couple sidebars and they were talking about that. And so I'm not privy to what they discussed. Cindy from Virginia wants to know, would the base of the glass be near John if it was thrown at the taillight? That's a great question. I don't know the answer because physics, science, kinematics, not my specialty. But I like physics now, but maybe somebody can tag Cindy from Virginia. We do have a lot of engineers watching. Let her know. Gail wanted to know, so the feds already know that Karen didn't hit John O'Keefe. ARCCA would have reported their findings, yes. An opinion, yes. Am I right? Yes. It is the opinion of these highly qualified witnesses that John O'Keefe was not hit by a car. And a car did not hit John O'Keefe. Interesting pointed out when they were talking about the tail glass. OMG, that's why Higgins said they didn't have whiskey. Not using drinking glasses. Here is Miss Jessica. Pointing out that the ARCCA witnesses created and installed the technology on our MRAPs or MRAPs in Afghanistan. They saved so many lives. Thank you, Miss Jessica, for your service. Love you with all of my heart. All right, sound is back up. Thank you, Christina. 2 song suggestions. He's telling them everything. Fairy Raven is here from Ireland. Hey, girl, hey. Nope, Welcher did not do any impact testing for the arm at all. Nope, and yes, Dimple Daddy's spotlight pointing out that Be in Trouble 31 said
Back
all
in session, you may be seated.
We're going to smash the like button before we get back into session here.
Are you all set,
Please.
Dr. Wolfe?
Yes, thank you, Your Honor.
All right, Mr. Jackson.
Thank you, Your Honor. Before Dr. Wolfe, before we get into laboratory test B, I failed to ask you, were you compensated or was ARCCA paid following the proceeding last year for any of the time?
Yes, last year. Yes.
Last year.
Correct, yes.
Do you know how much that was?
From what I recall, I think it was around $20,000.
Was ARCCA paid by the defense your initial testing, the initial analysis which we talked about earlier this morning? Was ARCCA paid by the defense for any of that?
No, not the report, testing, none of that.
Okay. What were you
There it
paid for
is.
last year related to the first proceeding?
My time to appear at the proceeding.
Travel?
Correct. Travel testimony. Yes, sir.
So the form, Mr. Jackson?
Sure. What about now? Have you been paid any additional sums by the defense specifically for your undertaking that you're testifying about today?
Yes.
About how much have you been paid?
I think when I spoke to accounting, I think they indicated it was around $50,000.
Okay.
That's it?
Let's talk about laboratory.
That's it? $50,000? And the jury has already heard that Aperture billed them almost $400,000. Do you see the difference in the testing and the quality of the work that was done? My head just rolled off. My head popped off, and it's on its way to Connecticut right now. That is fantastic. 50 grand. Look what they did for 50 grand. Praise be.
Test.
Indicated it was around $50,000.
Okay. Let's talk about laboratory test B, as in Bravo.
That's fantastic.
If I may have just a moment, Your Honor.
Sure.
What
Yeah,
is
let that
different about lab test B as opposed to lab test A?
So the tests were essentially identical aside from the speed increase going from 10 up to 17.
Okay. Let's take a look at the next slide. Just so I'm clear, Doctor, I want to make sure I'm on the same slide as you. Is this slide 35 pursuant to your notes?
This is slide 36.
36, got it. Okay. We can be a little bit more brief, I think, because is this similar to the 10-mile-an-hour test, just with increased velocity?
Correct.
Okay. What about the purple hued taillight on the right? What is that?
So again, that is a thermal image depicting the temperature profile of the right taillight that was tested.
And I'm sorry, go ahead.
I was just going to note that the average temperature profile of the taillight here in this test was approximately 30 degrees Fahrenheit.
Is that below freezing?
It is, yes.
Whiffen didn't know that.
And the ATD, the test dummy, if you will,
Yes.
is it also clothed?
Correct, yes. With you may notice a difference in the sweatshirt color. We put on a new sweatshirt in this test.
Was it also an exact replica of the sweatshirt at issue worn by John O'Keefe? I'll ask it a different way. How did it compare to the sweatshirt that was worn by John O'Keefe?
It was made by the same company and had the same material blend as the previous test and the one that Mr. John O'Keefe was wearing.
Next slide, please. What are we looking at here?
So this will be a video. You will see, much like you did in the other one, where the taillight will be accelerated up to 17 miles an hour, impact the arm. And one of the things you'll see is actually an artifact of the test, if you will, where the taillight, due to the fact that the impactor stops at the end of the stroke, that force actually causes it to decouple from that polyurethane foam that we use to adhere the two.
What do you mean by decouple? What does that mean?
So, as I mentioned, it once the linear impactor reaches the end of its stroke, it stops instantaneously, and the force of that stop just caused where we adhered the two together, just caused it to detach, basically break away. So, in essence, it doesn't matter because we only care about that. Remember, we're talking about that short duration of time, that 10 milliseconds. So once it breaks, it's already reached a common velocity to the taillight.
Okay. Can we go ahead and go to the next slide, please?
Thank you, Decline. Wow, look at that.
What do you note about this impact?
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over kind of the arm and the taillight there.
Do you note more damage or less damage to the taillight at 17 miles an hour versus the 10-mile-an-hour test?
There is more damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the taillight enter from the left, impacting the arm at about 17 miles per hour.
Okay, go ahead and play it.
Wow.
Can you describe the decoupling Is that shown here?
Absolutely. So as you can see where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right? This is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end of the stroke.
Understood. Next slide, please. What are we looking at here?
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct, not real time.
Okay.
Slow-mo version. Bam. That arm would have been toast.
What do you note in terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving now at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10-mile-an-hour test, which, again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide. And what is this depicting?
This is extracted frames from the previous video just showing right at contact, during contact, and post-contact.
Next slide, please. What is this a photograph of?
This photograph is depicting the damage to the taillight at the conclusion of the test, where, again, it's missing fragments of the outer red lens. I will note that the interior diffusers and plastic components are intact in this test.
See that?
When you say intact, what do you mean?
They are not damaged or broken.
At all?
Correct, at all.
Next slide, please. What is that a picture of?
Another photograph showing the taillight post-test. Again, no damage to the underlying diffusers in terms of being cracked, shattered, or broken.
And what did you note in terms of the damage to the outer acrylic, the red piece?
It broke into a few fragments, and I think on the next slide I depict those in a photograph.
Let's take a look at that. What is that?
So this is a photograph depicting the collection of the fragments post-test. I will note there's one clear piece, one red piece, another clear piece, and there is one more red piece in this bag. So the outer lens broke into approximately 4 pieces in the 17-mile-per-hour test.
Not 47.
And I'll point out one other thing just because you can see it in the photograph. This is that 3D printed bracket that we used to bolt it onto the linear impactor with the foam on the other side that mounted it to the taillight.
Thank you for that. Next slide, please. What is this a picture of, or pictures of?
This is a side-by-side comparison showing a depiction of the 17-mile-an-hour test impact to the test taillight, comparing it to that of the subject taillight.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
Yeah.
What's the basis of that opinion?
Huge.
The test that I've just showed you all.
Was that testing that we've just talked about conducted in accordance with the scientific literature and generally accepted methodologies that you've earlier described?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Slide 45, please.
We have a nope emoji too. Nope.
What is this?
You're looking at photographs post-test of the sweatshirt that the ATD was wearing at the time of the impact.
Is this the 17 mile an hour impact?
Correct, yes.
Did you note any defects in the fabric of the right arm?
There were no punctures, holes, or fraying of the material during this impact test.
Oh.
Based on this testing that you conducted in this case, is the damage that you saw of the shirt that John O'Keefe was wearing consistent or inconsistent with the shirt that's on the ATD?
It was inconsistent compared to the sweatshirt that Mr. John O'Keefe was wearing.
Based on that, do you have an opinion or a conclusion as to whether or not the damage on Mr. O'Keefe's clothing was consistent with being struck by the right rear taillight at 17 miles per hour?
It is inconsistent.
Next slide, please. What is this graph depicting?
So going back to, again, to these terms that we've talked about, this is the acceleration trace of the 17-mile-an-hour impact test. And you can see that we reach a peak acceleration at around 5 milliseconds, and that's at about almost 270 Gs.
You said 270 Gs?
Correct.
Or 217?
270.
Thank you.
70.
Did that have any significance on your analysis?
Yes.
What was that?
Well, we can use that to estimate, obviously we can integrate that to get the speed, but we can also estimate the force applied to the taillight with that information.
Can we go to the next slide, please? What is the delta V as it relates to the 17-mile-an-hour lab test?
So you can see, again, the arm initially at rest is accelerated up, increasing in speed, and then reaches just about 16 miles per hour, so reaching nearly a common velocity with the taillight at about 8 milliseconds in time.
Next slide, please.
Don't worry, the dots will all be connected when Dr. Welcher testifies, and he's going to testify about whatever 270 Gs, how that force would affect a human arm, what kind of damage it would do to the human arm. All the dots will be connected.
Did you conduct additional tests other than the 2 lab tests that we've talked about?
Yes, sir.
Describe just in general, and then we'll talk in more specifics. What were the tests that you undertook after the lab tests?
So we conducted 2 tests with a suspended ATD arm that was impacted by an exemplar 2021 Lexus LX570. We then conducted a test where the arm was then attached to a test dummy, and then our final test was a full-on impact to a test dummy.
Can we go to slide 48, please?
The jury does know that
What are we
Karen
looking at
connected
in
to the
this
Wi-Fi.
slide?
1237.
This is the exemplar 2021 Lexus LX570 that was utilized during this test program.
Was this the same vehicle that was utilized in all the tests, C, D, E, and F?
Correct, yes.
If we could go to slide 49, the next slide. What's depicted in this photograph?
Well, so there's a number of things here, so I'll try to point them all out. So obviously, we talked about just now the Lexus here, the exemplar vehicle. We have a forklift that was hoisted up that ultimately was suspending the arm. I think I have an additional photograph that shows it close up. But the arm was suspended from the forklift at the correct height to interact with the taillight. We have our high-speed cameras set up under this umbrella. There's another one over here. Another thing you'll note is we brought out the chest freezer when we were installing these in the Lexus to, again, keep them at that steady state temperature for as long as possible.
They even had a
If we could
pop-up
go to the next
tent.
slide, please.
And it wasn't even snowing.
What are we looking at in this photograph?
So this is the approximate position that we plan to have contact occur in these tests. So as you can see, the forearm is in contact with the lift gate and the quarter panel taillight along with the elbow.
Why did you choose this configuration for the arm, the forearm, the hand, the elbow?
It was based upon my review of Dr. Welcher's work, and that he did through his static and dynamic test or paint test that this is how the arm was roughly oriented when the alleged contact occurred.
What were you trying to replicate in positioning the arm this direction, this way, as it relates to the SUV?
Well, I think as I stated earlier, it was to understand, okay, let's get beyond just simple geometry, aligning things. What happens to the arm, right? What are the accelerations? What's the damage, right? What we want to answer some of those other questions that Dr. Welcher didn't answer.
Does this
So I'm going to strike the last part of that answer.
Does this configuration align with your understanding of Dr. Welcher's alignment of the arm as it relates to the vehicle?
Existing.
May we approach, Your Honor?
Yeah, because this is what Welcher's PowerPoint presentation said, and he's trying to show Welcher's wrong. Welcher didn't take his analysis far enough. Welcher didn't use the scientific method. He didn't have a hypothesis. The Alessinator says aperture equals lying is expensive versus methodology and math and stuff. They had an exemplar Lexus, Lula. I don't know if they bought it. They really didn't say if they bought it or if they had it. They just said they had access to it.
Thank you, Your Honor. May I inquire?
Yes.
Okay, let's go to the next slide. It's maybe self-explanatory. What was the speed of your first test out in the field?
15 miles per hour.
Next slide, please. What are we looking at in these two photographs?
So on the left is a photograph of the installed preconditioned taillights just after the install, and on the right is a thermal image of that. And if I may just point out with the temperature. So one of the things you may see here is that due to the reflective chrome here, this is just an artifact of that being really reflective. So when we look at the average temperature profile of the taillight for this test, the average was approximately 17 degrees Fahrenheit for the taillight.
Was it important in this testing to account for the temperature variance of the taillight assembly?
Yes, absolutely. And I will note we certainly strive to maintain that. One of the things you actually may see in this photograph on the left are these pellets on the ground, and that is due to the fact during the installation process, one of my colleagues was positioned adjacent to the taillight fixtures, applying a compress of dry ice to help mitigate any heat transfer during the install process.
Let's move on to the next slide.
They even had dry ice.
What are we looking at in this overhead view?
This is it's a drone video, so you're going to see the Lexus accelerate from left to right, impacting the hybrid suspended arm in the area where you could see the umbrella.
Can you use your spotlight and orient us? Where are the vehicles and the testing locations?
Yes. So the Lexus is starting here. You will see it accelerate in reverse with the hybrid arm suspended in this area here.
Okay. Is this a video or just a still shot?
This is a drone video.
Let's go ahead and play that. Dr. Wolfe, is that in real time or slowed down, sped up?
This is in real time.
Okay. Next video, please. What is this?
This is a camera that was mounted on top of the forklift that was suspending the arm.
Is this a still shot or is it a video?
It's a video.
What is the orientation of that arm as it relates to the vehicle that we'll see?
So it will make contact with the taillight, although I will note in this test, ultimately the contact ended up being more of a clip or a side swipe in this test.
Go ahead.
Because that's their theory now, is a clip. So they did the clip. Oh.
Did you see the impact area?
It's quick.
Right. What did you mean when you said more of a side swipe or a clip?
Whoa. Keep it on loop.
So I think the next couple of videos will help demonstrate that.
Let's move on to the next one.
Flying Melendas have entered the chat.
What are we looking at in this video? Or, I'm sorry, in this photograph.
So this is going to be a high speed or a slow-mo video. You're going to see the Lexus come in from the right and then move across the screen to the left. And you'll see contact occur between the taillight and the arm.
Okay.
I mean, his arm could have been torn off his body based on this video.
Can you explain for the jurors using this video what you meant by more of a side swipe or a clip?
Right. So this is where the hand and the wrist are kind of in the area of the quarter panel taillight, and then a portion of the forearm in contact with, I'm sorry, what I previously said, the wrist and the hand in contact with the lift gate portion of the taillight. and then on the forearm is more in contact with the quarter panel taillight.
Okay, can we move to the next slide? And what is this angle?
This is, yeah, same test, just a different angle with the high-speed cameras in slow motion.
And this is at 15 miles per hour, correct?
15 miles an hour, correct.
Can you explain for the jurors, given the fact that this is suspended, does that have any impact on the ultimate analysis or reconstruction, rather than being attached to an ATD?
Effectively, mass is mass. So whether we have an arm that is suspended or attached, again, it's the arm is on a joint, right? So the arm can accelerate freely of the rest of the body, right? So if anything, even if it is attached to the body, there may actually be some additional force associated with that, just because there could be more mass attached to it.
Understood. Okay, let's go ahead and play this video. Can we go to the next slide, please? What are we looking at in these three photographs?
So you're looking at, on the left, starting from left to right, just at contact, and then just after contact, and then post-contact. So as I mentioned, you can see that in this first one at contact, again, we don't have, the hand isn't and the arm aren't positioned as far out on the previous tests, and the hand is in the area and the wrist of the lift gate taillight, with part of the forearm in contact with the quarter panel taillight. And as you saw in the video, essentially the arm just kind of moves out of the way of the vehicle as it comes by.
Understood. Next slide, please. What are we looking at here?
This is a photograph of the test vehicle subsequent to the test, depicting the, I'll say, lack of damage to the taillights.
Describe what you did see in terms of damage or lack of damage on the taillight.
There was no damage or fracturing to the taillights.
Describe the orientation of the arm in this particular test that you said was more of a side swipe. What was the orientation of the arm to the taillight in terms of how much of the arm touched the taillight? It's probably a clunky question, but I think you understand it.
I don't know if I could break it down into, I think just qualitatively speaking, like I said, it appears to be the hand and the wrist and kind of the lower portion of the forearm, maybe to the mid forearm or so.
So nothing on the upper arm?
Correct.
Making contact?
Correct, nothing on the upper arm, yes.
Okay. If we can move past this slide and onto the next slide. What is this depicting?
So this is depicting the test taillights of the 15 mile per hour impact into the hybrid arm compared to that of the subject taillight.
Was there any notable damage at all on the on the exemplar taillight following test C at 15 miles an hour?
The only thing there may have been was some very slight abrasions maybe to the plastic, but there certainly was no breaking or fracturing of the lens assembly.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 15 miles per hour?
In this test, it was inconsistent.
Even in a side swipe?
Correct.
Was that testing that we just saw done in accordance with scientific literature and generally accepted methodologies in the area of accident reconstruction?
Yes.
Is the damage to the right rear taillight of the subject vehicle consistent with striking John O'Keefe's arm at 15 miles per hour in a side swipe configuration?
It's inconsistent.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Can we move to the next slide, please?
Told you, there's no engineering certainty. It's
What are we looking at in
scientific
this
certainty.
graph?
So you're looking at the hand acceleration over time. So you can see that because, as you saw in the previous video and slides, the hand initially made contact with the taillight. So that gets accelerated up first. So we're getting peak accelerations in this test for the hand of about 254 Gs. And yes. over a period of about a little over 6 seconds or sorry, 6 milliseconds or so.
What was the arm or the appendage outfitted with to determine the data on this graph?
Right. So if you think back to the lab testing that we did, right, because we didn't have, and again, this is kind of why we did the testing incrementally as we went about it, but in the lab test, we didn't have a way to mount the lift gate assembly to also evaluate that interaction. So when we moved outside the full-scale vehicle testing, we had a lift gate taillight, obviously the full vehicle. So we also instrumented the hand with an accelerometer as well as the forearm. So we were able to measure the acceleration of both the hand and the forearm in these tests.
Can we move to the next slide, please? And what are we looking at here?
So this is the, excuse me, the acceleration of the arm. So you can see that it reaches a peak around 5 milliseconds at about, looks like just under 200 Gs.
And the next slide. What's depicted in this graph?
So this is doing, again, the integration of the acceleration data for the hand to determine what speed did the hand get accelerated up to. And you can see that at the onset of this, it's at rest, it's impacted, and then gets up almost to 15 miles an hour in 4 milliseconds. Ultimately does reach at about 18 milliseconds, it does reach that 15, but it's nearly at 15 at contact.
Thank you. The next slide, please. And what is this delta V showing us?
So this is showing the change in speed of the arm. And again, because the hand was, and the wrist was more of the central impact to the ATD arm, this ultimately saw less acceleration, therefore less of a change in speed. So at around 6 milliseconds, well, roughly actually about 1 millisecond after it started to increase in acceleration, it's at about 5 miles per hour.
Is that reflected in the fact that the arm pivoted?
Yes,
spun?
there's some rotation going on, so it's not translating or accelerating.
Understood. Can we move to the next slide, please? Test D. What was the speed that you undertook in test D as in delta?
So this is a 29 mile per hour impact into the suspended hybrid arm.
We move to the next slide. What are we looking at in this series of photographs?
So on the left is my colleague, again, compressing the taillight while we install the upper the lift gate taillight to, again, try to maintain that steady state temperature. Over here on the right is the thermal image of the taillight after the install. So the average temperature of this taillight during the test was approximately 17 degrees Fahrenheit.
Next slide, please. Staying with test D, what is this depicting?
This is a drone video showing a top-down perspective of the test with the Lexus starting on the left-hand part of the screen, accelerating in reverse into the suspended hybrid arm over here at the location of the forklift.
Okay. If we can watch this video, please. Do your next slides show, there you go, the suspended arm. What are we looking at here?
So this is a video camera that was positioned on top of the forklift looking down at the arm. So you'll see the vehicle move from bottom to top as this video plays.
By the way, Dr. Wolfe, what are the purple and white lines that we see have predominated? I'm sorry, I was talking over that.
Sorry.
That's okay. What are the purple and white lines that we see?
So those are guidelines to help. I will note that this is kind of like a needle in a haystack. It's very hard to hit this small of a target. So just served as a guideline to reference as we're accelerating rearward into this.
Is this in real time?
This is in real time, yes.
What's the speed that the vehicle is entering the frame at?
29 miles per hour.
Thank you. What happened to the arm in terms of its suspension?
It actually gets ripped off from the mounting location.
Wow. Ouch.
Is there a reason you believe physically that that arm was ripped off from the suspension tethers?
Well, certainly there was enough force to break the tie lines to the forklift.
Was there a test value of those tie lines?
I think they were rated at 150 pounds.
What does that suggest in terms of the force that was exerted, just before we get to the other testing, the force that was exerted on the arms to tear off the tie lines?
Well, it indicates that the arm saw at least 150 pounds of force.
Okay. Next slide, please. What are we looking at in this video?
So this is going to be a slow motion video. You'll see the Lexus accelerate in reverse, making contact with the arm. And again, this is the 29 mile per hour impact test.
Okay. Next slide, please. And what is this?
This is a video, a high-speed video, so slow motion of test D at 29 miles per hour into the ATD arm that is suspended. So you'll see the Lexus enter the frame from the right and impact the arm.
Okay.
Yeah, I mean, that would have shattered his arm and his body.
Was this strike more reflective of what you were attempting to replicate?
Yes, this was a more central impact to the arm, yes.
Thank you. Next slide, please. And what is this?
So this is a high-speed or slow-motion video depicting the test D at 29 miles per hour, just a different perspective than the previous video.
Okay.
Bam.
Next slide. And what are we looking at here?
So this is extracted frames from the high-speed video. So starting out left to right, this is roughly at first contact with the majority of the hand, well, the hand and majority of the forearm in contact with the liftgate taillight, with a portion of the elbow in contact with the quarter panel taillight.
Can I stop you right there on that far left frame? Does that fairly replicate what you were attempting to approximate in terms of the orientation of the arm versus the taillight?
Yes, more of a central impact compared to that first test at 15, yes.
Is that more or less consistent with what you saw in Dr. Welcher's test, where he had his arm in that still shot associated with the geometry of the car?
Sustained.
Is this consistent with what you were trying to replicate after your review of Dr. Welcher's report?
Yes.
Sustained. Can I ask it differently?
What were you trying to replicate, or why were you trying to replicate this at the 29 mile an hour test in this particular orientation?
We were trying to see, based upon Dr. Welcher's orientation, what happens to the arm in terms of the acceleration and the damage to the taillight at that configuration at contact.
Okay, next slide, please. What are we looking at?
So this is a photograph depicting the damage to the liftgate taillight as well as the quarter panel taillight.
And what do you note in terms of that damage?
So on the liftgate taillight, a significant portion of that thick 5mm red outer lens is fractured and broken off. The underlying diffusers are still in place. There was a small crack in, I believe it was the upper diffuser here. The quarter panel taillight had the clear section damaged with the outer lens missing, along with some fragments from the outer portion of the red part of the lens.
Next slide, please. What are we looking at in this slide?
So this is another photograph depicting the quarter panel taillight. As I indicated, there is portions of the red lens cover missing. The interior diffusers remained largely intact in this test.
Next slide. What is this side by side depicting?
This is showing the results of the 29 mile per hour impact test to the test vehicle compared to that of the subject taillight.
Given that orientation of test D, were you able to reach any opinions or conclusions as to whether or not the damage to the subject taillight is consistent with striking an arm at 29 miles per hour?
It was inconsistent.
What's the basis for that opinion, Dr. Wolfe?
The results of this test.
And was that testing conducted in accordance with the scientific literature and generally accepted methodologies in the field of accident reconstruction?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 29 miles per hour? When I say the right rear taillight, I mean of the subject vehicle.
Sustained as to that.
With regard to your opinion concerning whether the subject taillight is consistent with striking an arm at 29 miles per hour, do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Next slide, please. What is depicted in this graph?
So this is looking at the acceleration of the hand in the 29 mile per hour impact test with peak accelerations close to 800 Gs at 2 milliseconds.
Next slide, please. What are we looking at in this graph?
This is the acceleration of the arm, reaching peak acceleration of about 500 Gs.
You indicated 800 Gs in the last graph. What's the difference? What's the difference in the delta between the 500 and the 800?
Between the hand and the arm?
Understood. Which one suffered or was subject to 800 Gs?
That would be the hand.
And which one was subject to the 500 Gs?
That would be the arm.
Next slide, please. What are we looking at in this graph?
So this is looking at the change in speed. So what speed did the hand get up to as a result of the impact? So we can see that in about 3 milliseconds, the arm is moving nearly at almost 25 miles per hour. And then a little bit later, again, this is still very quick in time, at about 14 milliseconds, it's at about 30 miles per hour.
Next slide, please. What's depicted in this graph?
So this is looking at the change in speed of the arm as a result of the contact. So starting here at about 2 milliseconds, the arm accelerates up to, by 8 milliseconds, we're at about 35 miles per hour. And this, you may be wondering, why are we getting more speed than what the input was? And that's because you get a phenomenon known as restitution. Basically, there's an elastic collision between the two where you can get almost a bouncing effect. So when you have something that weighs 6,000 pounds striking something that's much, much lighter than that, it can actually cause it to accelerate up to a greater velocity than the impact speed.
Next slide, please. Test E, 24 mile an hour impact test. What is that?
So this is a 24 mile an hour impact test to the ATD arm attached to a test dummy.
Next slide, please. Why did you utilize 24 miles an hour for this test?
So it's my understanding that this is the upper end. There is a triggering event of, I believe it's 1162.2, and I think at the end of that data, the speed is approximately 24 miles per hour. So we did a test at the end point, if you will, in that data set.
Welcher didn't agree
What
with
is
that.
this photograph showing in terms of the orientation of the arm and the hybrid test dummy, or ATD?
So the orientation is to depict, again, the orientation that Dr. Welcher indicated in his static and dynamic test to show what happens when again, that ATD arm that we had is attached to a test dummy and is struck at 24 miles per hour.
Next slide, please. And what is this?
So this is a thermal image of the taillights just after the install with the average temperature at about just over 33 degrees Fahrenheit.
Next slide. And what are we looking at?
So you're looking at a top-down drone video with the Lexus here on the left that will accelerate in reverse up to 24 miles an hour, striking the ATD arm.
Let's watch that, please.
Oh yeah, this is what we want to see because this was their original theory from the get-go.
Next slide. What are we looking at in this slide?
So this is a top-down video from atop of the forklift, or where the arm is suspended, attached to the dummy. So you're going to see the vehicle enter from the bottom into going to the top of the screen.
Notice I'm sure they used a stunt driver for this because no average driver would be able to make this happen. Oh, he did do a pirouette though. Look, the crash test dummy kind of does a pirouette. Trooper Paul might have been not half bad. Look at the pirouette that he did.
Next slide.
He's also, like a marionette. He's suspended
What
by
is this
strings,
view?
but
It's just another perspective. This is a slow motion video where you'll see the Lexus in reverse. I think this one actually has kind of a long build up before it starts here.
Paul was closer than Welcher, right? Is it just me? Thanks, Rena. True Paul's vindicated. Kind of. I can't move the closed caption. I've been moving them all over the place, and I just can't please everyone. I'm not a cupcake, and I can't make everyone happy. Hopefully, wherever you are is climate controlled, and you're okay with the heat or the cold or the air conditioning or the fan. But I move them constantly throughout the stream so that they're not blocking the super chats, they're not blocking the comments I put up, they're not blocking the chat, they're not,
And
just
could we
can't,
go to the
people's
next
faces.
slide, please? And what is this?
So this is a perspective from the high-speed camera, so a slow-motion video with the Lexus reversing into the ATD arm at 24 miles per hour.
Before you play this, Dr. Wolfe, I failed to ask this, it may be obvious. After each of the tests, C, D, E, F, were you replacing the taillight with new exemplar taillights that had been temperature accounted for?
Yes, every test had a new set of quarter panel taillights, as well as liftgate taillights. And even in the test where the taillight in the 50-mile-an-hour test where the taillight was not damaged, we still put on new taillights. We did not repurpose or reuse any of the taillights.
Okay, thank you.
New taillights for each experiment, and still only 50 grand. The pirouette happens, says be in trouble 31, but the dummy didn't fly 30 to 60 feet. He's also suspended by, Flying Walenda's contraption when they were on the trapeze at the Ringling Brothers Circus, which is very fitting because this is very much like the Ringling Brothers Circus, 3 rings and all.
Next slide. In this configuration, was the ATD outfitted with the hoodie that you've earlier described?
Yes.
At the time you outfitted the ATD with the hoodie in this configuration before this test E, did you confirm that the right sleeve, was damaged or undamaged?
After this test?
No, before.
Before, it was undamaged before the test.
Okay. What are we looking at in this slide?
So this is still frames from the high speed. So starting out on the left here, just at contact. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. And the middle here is just after contact. and on the right is post-contact.
Thank you. Next slide, please. What are we looking at in this video, or in this picture?
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here, there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer to.
Yes.
Just so there's no confusion.
This sounded like you
Thank
said, Mother May I? Mother May I? Remember that game from when you were a kid?
So the line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what about the clear acrylic toward the top left of that taillight housing?
It was partially fractured, but not the entire outer portion of it.
Next slide, please.
Trooper Paul must be ecstatic, Claire.
What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Sustained in that form.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
On what do you base that opinion?
I base it upon the test results that I've shown in terms of the video and the data acquisition.
Can you describe that in a little bit more detail?
So during this test, we had the instrumented hybrid arm outstretched from the test dummy with the accelerometer on the hand and the forearm. We had data acquisition on the vehicle, monitoring the speeds of the vehicle. We accelerated that vehicle into the arm at 24 miles an hour to conduct a dynamic impact test to collect data certainly about the acceleration that the arm experienced, but then also make observations about the damage that we observed to the taillight.
Do you hold that opinion that we've just discussed to a reasonable degree of scientific certainty?
Yes.
And were your tests conducted in accordance with methodologies that are generally accepted in the field of accident reconstruction in this particular test cycle?
Yes.
Next slide, please. What are we looking at in this series of photos?
So these are photographs depicting, excuse me, the test clothing. Again, prior to the test, there were no holes or damage to the sweatshirt. That was the same post-test. We did not make any observations with respect to any fraying, holes, punctures to the material of the sleeve.
Was there any damage whatsoever observed on the right sleeve of that ATD?
No.
Next slide, please. What are we looking at in terms of this graph?
So what you're looking at in this graph is the acceleration of the hand reaching a peak acceleration just after 10 milliseconds of approximately 435 Gs.
Next slide. What are we looking at here?
This is the acceleration of the arm during this 24-mile-an-hour impact test, reaching peak Gs of about 300 at 4 milliseconds.
And the next slide. What is this delta V graph showing us?
So this is showing the change in speed of the hand as a result of the impact, ultimately getting up to approximately 24 miles an hour, which again is the impact velocity of the Lexus.
And how fast did it get up to 24 miles an hour?
In probably about 10 milliseconds or less.
Next slide, please. And what is this delta V showing us?
This is showing the change in speed of the arm going to about just over, looks like about 22 miles per hour at about 10 milliseconds. So total window of time of about 8 milliseconds that it took to get up to that 22 mile an hour speed or so.
Understood. And next slide, please. Did you undertake, by the way, another question. On that, when the ATD was oriented in test E, is an echo, where it was standing with its right arm out, and the impact was on the right arm. What happened to the mass of the body of the ATD?
It rotated.
Was it projected at all off to the side?
No,
Was it projected rearward?
no.
The body rotated,
Was
but
that
it was not
rotation
projected.
expected based on your experience?
Yes.
What is the 29 mile an hour impact test in test F?
So this was a test that we conducted with a what's known as a rescue Randy or a test dummy that was a full-on impact to the right rear corner of the Lexus.
Full
Let's
on
take a look at
impact.
the next slide, please. With regard to test E, if I could please ask you about that. I want to go back to that test even though we're looking at this one. With test E, was that reflective of a direct impact on the arm itself,
Correct, right in the area of the elbow to the quarter panel taillight.
as opposed to a side swipe on the arm?
Correct, yes.
Thank you. Did you undertake to test a direct impact on the body of the ATD in this test?
Of the rescue Randy dummy?
Yes.
Yes.
What are we looking at here?
So this is the intended impact configuration with the rescue Randy suspended here by the forklift, and again, kind of in the path of the profile at that right rear corner.
How much does this test dummy weigh?
Approximately 200 pounds.
Next slide, please.
I don't see a sneaker come off in any
What
of
are we
these.
looking at in
Karen.
this photograph?
So this is a video. We had a little bit of a false start, so our high speeds weren't triggered, but thankfully we were able to pull our surveillance video to get at least an overall video of the test taking place.
Do you have, or well, let me ask you that did you intend to have high-speed video just like you've had in every other test?
Yes,
What went wrong? Something
just
didn't get clear?
miscommunication between the driver and the rest of the test engineers.
Got it.
So false start.
Okay. Was the taillight housing reassembled for this test?
Yes, it had a preconditioned new set of taillights on it.
And other than the taillight being damaged several times that we've seen, was there any other damage to the rear of that exemplar vehicle?
I'm sorry, can you repeat the question?
Sure. Other than the taillight damage that you rotated through in your testing, C through F, was there any other inherent damage to the the lift gate that existed when the exemplar vehicle was received by you?
When it was received, no, it was
Okay.
in good condition. No defects or damage were noted.
Okay.
She blinded me
What
to
are we going
sign.
to expect to see in this video?
So in this video, you'll see in the surveillance video, the Lexus will come from the right to left, strike the rescue Randy, and then you'll see the rescue Randy projected and slide on the ground.
Okay.
Oh yeah, Randy was
Can you play that
waffled.
one more time, please?
Can't really see. I'm gonna full screen it for you so you can see it better. But I mean, his body like lands on the ground and is
Next slide, please.
pushed.
What are we looking at in this series of photographs?
So this is a extract from our V-Box software and data acquisition system. So on the top, you'll see the video, on the bottom is the data. So this is another feed that we had of video. This was triggered, so we do have data from this perspective. So what you'll see is my colleague will move away from the assembly with the dry ice, and then the vehicle will accelerate in reverse.
That was my question. The blue, that's dry ice, gloves?
You can't, you don't want to touch dry ice with your bare hands. So
Okay.
it's, he's wearing gloves. He's capturing the thermal images now.
Next slide, please. And what are we looking at in this?
So these are extracted frames from that video you just saw from the data acquisition system. So on the left here is just before contact between the test dummy and the Lexus. On the right is just at contact.
Next slide, please. And what are we seeing in these series of photos?
So this is obviously during the collision sequence. The body now has loaded into the lift gate and the back window. What you're seeing here is the back window shattering. And this is just a few split second later in time where, again, the body is continuing to move with the vehicle as it's contacted.
Next slide. And what is this?
This depicts the post-impact damage to the rear of the Lexus. As I noted, the rear window is completely shattered. There's deformation and crush to the liftgate section of the vehicle. The bumper step was popped out, and then there was some minor fracturing in the bumper cover at the lower level.
Did you note anything regarding the internal components of the exemplar taillight, even at this direct impact?
So the taillight, as you can see, it blew out the outer lens cover. I believe the part of the clear diffusers were actually still in place. I think the lower one might have been fractured here, but I think the upper one was still in place.
At 29 miles an hour with a direct impact, did the exemplar taillight exhibit the same type of damage to the diffuser as the subject taillight?
I'm not sure I understand your question.
More or less damage in this photo to the diffuser specifically than in the subject taillight?
Well, I think there was more in the subject taillight. As I mentioned, I believe the top diffuser
More
on this
damage?
was correct.
Okay, that was my question. And is there another slide at the on the back end of this one?
That's it.
Okay. We can have the
Mangled.
lights.
Car, ton of damage to that car, 29 miles an hour.
Dr. Wolfe, you conducted tests at what miles per hour? Tell me the sequence.
It would be 10 miles per hour, 17 miles per hour, 15 miles per hour, 29 miles per hour, 24 miles per hour, and then a full-on hit at 29 miles per hour.
Regarding all of the tests you conducted, what did you observe with regard to the damage, if any, to the internal components of the quarter panel taillight? And I'm talking about the chrome pieces and the diffusers.
It was less in all of the tested taillights than that of the subject taillight.
Did you
There it
reach any
is.
opinions or conclusions as to whether the damage to the right rear taillight of the subject 2021 Lexus is consistent with an impact to John O'Keefe's right arm during a high-speed reversing maneuver?
Sustained in that form, Mr. Jackson.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject vehicle is consistent or inconsistent with an impact to a right arm during a high-speed reversing maneuver?
It was inconsistent.
What's
Bang,
the basis
bang.
for that opinion?
All of the test data that we did from the laboratory testing, moving up to full-scale vehicle testing, all of the collected data in terms of the photographs, the observations, all of the acceleration data collected. So all of the testing that we've walked through in this PowerPoint, along with certainly that was based upon all generally accepted and peer-reviewed methodologies in the accident reconstruction community.
Do you hold that opinion to a reasonable degree of scientific certainty based on your experience, training, and education?
Yes.
Did you reach any opinions or conclusions as to relating to the punctures of holes in the hoodie that you saw that was related to John O'Keefe?
Yes.
Do you have an opinion or conclusion as to whether or not the damage that you saw to the hoodie related to John O'Keefe is consistent or inconsistent with a impact from a right rear taillight of the subject SUV?
It was inconsistent.
And what do you base that opinion on?
Based upon all of the impact testing that we did with the clothed ATD arm in the laboratory as well as the field.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
Never.
The exemplar hoodie, I should say.
Correct.
Did you reach any opinions or conclusions as to whether the rear taillight of the subject SUV was involved in a center of mass strike of a pedestrian at a high-speed rearward maneuver?
Yes.
What is your opinion?
That the damage to the subject Lexus is inconsistent with a center of mass hit.
What do you base that opinion on?
The testing that we conducted in that last test that you just saw.
Do you hold that opinion to a reasonable degree of scientific certainty, Dr. Wolfe?
Yes.
Thank you. That's all I have.
All right. Is this a good place for a break, or do you want to get started?
Court's preference. Lunch is on here.
Is lunch here?
Doris, why don't we let you have your lunch? Okay?
Lunch is here, so
We'll come back ready to go at 1:30.
1:30.
All rise in court.
Just gonna give them 45 minutes for lunch. Oh, that was mic dropping testimony. Mythbusters. It was like a real life Mythbusters watching Dr. Wolfe talk about all of the different experiments they did. 1, 2, 3, 4, 5, 6 different experiments, all at different speeds, side swipes, direct hits, partial hits, and no matter what, none of those hits. Oh, is she gonna have something to say? We're consistent with the damage to the taillight as photographed in the Sally Port.
Okay.
Recess until 1:30.
Under her eye. Not even in a full-on crash. Amazing testimony. Amazing, because they got to do so many more experiments this time than they did in season 1. We can do a poll. We've got over 23,000 people here. What would you like the poll to say, my friends? All right, so they're out until what time do we say? 1:45. 1:45, right? All the experiments, no matter which way the Commonwealth says that it happens, Dr. Wolfe says it couldn't have happened that way. I am surprised that a human arm could break a taillight. That was the most surprising part of that testimony to me. What say you? The polls should say boom, bang, or pow. Boom, bang, or pow. Yes, it looks like Mr. Bederow would like to come in, so give me a moment. Hold off on your super chats for now because I'm going to turn them off. I think I got to... If I turn them off, are all the other ones going to disappear? I don't want that to happen. So how can I ask people to not send super chats to the point where people will not send super chats? Because that's Mark's rule when he goes on anybody else's show, and I don't want to be an exception to the rule, but I don't want to lose the comments that you guys have already made. So how can I say it a little bit louder for people in the back? Excuse me? Dominic? Bye, Dominic. GFY. It was nice knowing you, but really it wasn't. Hold on. Let me get rid of this person first. The whole class has to sit here now while you and your rude comment are booted forever. I'll find it. Or mods, can you find it? Let me send Bedero an invite. Una memento. Hold off on your super chats, please, so that I can address the ones that have already come in. We'll get Mark Bedero up here to give you his thoughts on the morning. Oops. I found it to be mic dropping. Oops. Yeah, I just wish you would have asked him if Alexis could have been rocketed into space. That would have been great. As we wait for Mark Bedero to join us. Thoughts, questions, comments, concerns in the regular chat, please. Bye-bye, Dominic Way. You're gone. What a shame. What a shame that you just couldn't be polite. That you insulted me in open chat. So rude. Who does that? Why do people do that? And you waited 24 hours? Because Mark Bedero does not like people to have to Mark Bedero does not like people to have to pay $5 for him to answer any questions. So here he is. Hello, Mark Bedero.
How are you?
Well, that was fun. The morning, wasn't it?
Boy, that was brutal.
For them.
Yeah, no, that was a systemic dismantling of their whole case in slow motion for 3 hours. Just it's brutal.
It was fantastic. It was fantastic. Tell us, go ahead, just talk, because I've been talking for a long time and I have to set this up. And
I mean, the difference between Dr. Wolfe and Dr. Welcher, both from the credibility in terms of their demeanor, in terms of the tests or lack of tests that they did, in terms of who the original engaging party was at the time that they were retained, in terms of the amount of money that they were paid, in terms of everything. I mean, you just saw the Dr. Wolfe, the ARCCA people, and you've only seen half of it. You haven't even seen Dr. Rentschler, who's going to tie the medical or the other parts of this together. And you just saw test after test after test, and inconsistent with the DA theory, inconsistent with the DA theory at every low speed, high speed, every point of impact. And I think, you know, if you dumb it down for jurors, perhaps the most impressive part of it, or the easiest part to remember, is the hoodie. The hoodie, which has no damage, and yet the real hoodie has 9 puncture holes, which I would suggest today, in the eyes of the jurors, look a lot more like potentially dog bite wound holes or something else than they do having anything to do with taillight. The other thing I think would resonate with jurors that you don't even need the expert for, you have your own eyes, watching the impact just on the arm. I mean, I don't think you need to be a medical doctor. Any lay person is going to say the only thing that this guy had on his arms were these lines of cuts, no fractures, no bruising. I mean, you saw the way that wrist was, and it's the exact same body weight. And then, you know, worse than that, you look at the actual arm wounds that you've seen on the autopsy, and all of a sudden those striations, they look more and more suspicious, and it doesn't go with what you're seeing. And it does feel more like dog bites than perhaps some people might have thought yesterday. And the bottom line is, you know, they're not playing with the burden of proof here. And it appears overwhelming, at least from a science standpoint, where it stands right now. The only disclaimer that you'd have to apply, they haven't had cross-examination yet. You got to allow that. They haven't done their rebuttal, although I'm not sure rebutting with Welcher at this point is something I'd want to do. And you sit here and you go back to what happened for several weeks before the trial started, where you'd hear Brennan say how much he welcomes ARCCA. That's what he would say with his words. but with his actions, he was clawing, scratching, kicking, doing anything he could to preclude them from testifying, and in particular, anything beyond their initial report. He didn't want any of that stuff that you saw for the last hour or so, with all those just incredible tests that just seem to really establish that their theory doesn't make sense. And even when you got to the higher speeds and the taillight would, I wouldn't say explode, but at least pieces would come flying off. It looks nothing at all like the taillight on the Lexus. And I guess the other problem they have is even at 29 miles an hour, which you saw is a hell of an impact.
Yeah.
And even though you saw the hoodie is not damaged, his arm is not seriously damaged. The taillight did break at that point, but not the diffusers.
Never. They never broke.
And, he testified that the diffuser on the actual taillight was damaged. Well, how the hell did that happen? At 24 miles an hour, but not happen at 29 or any of these other tests that they did. And, might that happen with a hammer? I don't know. But if the cross-examination here is going to be that you use Signal,
I have a feeling.
you deleted a few text messages and you sent an outline to Alan Jackson. And by the way, are we done with the $20,000 expense payment now that we know, if the math is correct, that Aperture got paid at roughly an 8-to-1, 8 times as much money, at least this round, as the ARCCA guys? What are they going to talk about? You sent them an outline. You're biased because there was an opinion that was created before they ever knew who the defense was. I don't know how the jury's going to react to Brennan's just constant objections, although they were sustained.
Like 99% of them.
He was making ouch objections. They were mostly sustained, but the stuff that, asking, did you know who Karen Read was at the time that you were retained? And he objects to that. The optics of that are bad. So, the cross will be interesting to see. Again, what's he going to do scientifically, and what is Welcher going to do on rebuttal? He was dressed up in an orange T-shirt, pretending to be John O'Keefe, and sticking his arm on paint and saying, look, that's my science, versus these guys. And that was just brutal.
And I think the highest speed that Welcher tested was 2 miles an hour, right?
Yeah. And he testified at 2 miles an hour while conceding that I don't even know where the impact was. I don't know what the speed even was. And I think he also said that, in his opinion, the taillight would crack at 8 miles an hour.
Right.
In reality, it took the mid to high 20s, I think, before maybe, I don't have any notes or anything, but, it never shattered into 47 pieces, even though you learned today for the first time that it's really not polycarbonate, by the way. That's interesting. It's
acrylic.
Yeah.
It's acrylic.
But they accounted for using it, which, I assume makes it more brittle, right? And they did everything that you would want, and they appeared to do it fairly. He testified methodically. I just can't believe that they're going to try to cross and say that you're a biased hack.
Right.
He can't possibly be serious about doing that. If ever there's a time to read the room, you need to do it now and not go down that line. Do the best you can. And if you think that the Aperture guy is going to come back and save the day with his new round of experiments, good luck and Godspeed.
First of all, I'm surprised that a human arm can shatter a taillight, right? Because that's what he proved, that it can at certain speeds. I think that everyone was of the opinion that that couldn't happen. We have seen that now that could happen. Yeah. And unlike Welcher, who I think may have tried to bury some results that were not favorable to him, ARCCA witness came out and said, yes, it can happen. It can happen. Here's how it can happen. It has to be at this speed. And then Rentschler is going to come in and slam the hammer down on what the injuries would be to that arm, because that's outside of Dr. Wolfe's expertise. And I think he's going to say that arm would have been shattered.
Yeah, and to be honest with you, I mean, again, I think it requires expert testimony and it's proper, but there comes a point in time, jurors are regular people, and even about topics that you don't fully understand, such as medical science, I don't think you have to be a genius to know that if your arm is kind of dangling out and gets whacked at that speed that you saw, that there might be some boo-boos, there might be some broken bones,
Yeah.
there might be a shattered wrist, there might be just hideous bruising, something, and all you have are these striations and lacerations that from a taillight piece, according to the prosecution theory, that these guys are telling you in so many words, they're saying it's not consistent, but let's call it what it is. What the jury's taking away from this is it can't happen.
Right.
I mean, hoodie is in perfect condition.
Yeah.
So how the hell did John O'Keefe's get 9 separate puncture holes in their tiny little holes? They don't really match the striations anyway. And so what are they going to say now? I mean, their whole theory is that the arm is what got smashed by and broke the taillight.
Right.
They can't. I mean, what are they going to do now? We'll say it was a glass. He threw a glass. I mean, that's ridiculous. They're kind of stuck.
Well, Welcher is out there right now doing more experiments in his basement. maybe this time Whiffen is with him too, and he's got a freezer, and they've got all kinds of things going on. Who knows? It's like backstage at Nickelodeon.
I know. The other problem they have, because again, ultimately, when it comes time to deliberate after hearing the summation, none of this gets looked at in a vacuum. And if you did look at this in a vacuum, you'd say they look like they're pretty much close to dead. I mean, how do they recover from this? But it's actually much worse, because you have to look at what you saw today in the context of, like, for example, Officer Barrows, who today, to the extent some people, he got hurt a little bit on cross with forgetting the photograph and this and that. How much more credible does he look in terms of what he saw in the taillight? Because Dr. Wolfe is saying it's not going to look like the way the police presented it. Right. And then you go from there. You have Jennifer McCabe, who said, I saw the taillight. It looks like that picture. Well, she takes a hit for that. Kerry Roberts, less believable. Proctor, less believable. Well, Proctor by proxy. He's, the ghost of Michael Proctor takes a credibility hit because he doesn't really exist. Buchanan looks less reliable. The whole case just looks kind of like a hot mess.
And all they had to do was take a picture of that taillight in the driveway at Dighton, and nobody did it. Ask yourselves why. Jurors, ask yourselves why.
I think, the answer to me would be obvious, but...
Well, that's what I mean. It's rhetorical for us.
Yeah.
But did Welcher even establish the speed that they contend that the vehicle was going when she hit John O'Keefe? Because the first trial we knew was 24.2 miles an hour. This trial, it's very muddy. He said, I never said it was 24.2 miles an hour. Where'd you get that from?
He may as well have said it, because, that's what Burgess's data shows, or whatever, that the car, what they claim is the car accident, was going at that speed. But the problem is you have an actual series of tests performed by Dr. Wolfe at that speed with the arm and all of that. And he said it doesn't match. The damage to the car is not consistent with striking an arm. The lack of holes on the hoodie, none of it. He didn't find anything that was consistent with what the prosecution is alleging. And you add in all these other problems that they have, and the burden of proof, all that stuff. And what do they do? I don't. And honestly, if you live in that county and you find out that we just paid $400,000 to have a guy dress up like John O'Keefe, and I think it was very well done how they pointed out that served no purpose, that was just a stunt by whoever ordered it or whoever decided to do it, because even though at certain times Welcher put the hoodie on, he didn't wear it when he was doing the actual
Right. The
Which-
paint experiment.
right, which I think is actually particularly more important now, to the extent that matters at all, because according to the experiments that were done at high rates of speed, the hoodie would have been fine. So he didn't even do it with the hoodie. He doesn't know what speed the accident was, Dr. Welcher I'm speaking of. He doesn't know where any impact was. And the only thing he did was give you one video of a test at 2 miles an hour where he just kind of rolls into the car. I mean, at this point, the difference between ARCCA and Aperture is just off the charts, and it gets even worse because when you say firm by firm, you said 24 miles an hour. Well, he's relying on Burgess for that, really. Right. And then you start going down the rabbit hole of Burgess and the academic fraud and the bits and bytes, and I had to change my opinion mid-trial. I mean, you start to ask yourself as a juror, are these even serious people, or are these just complete shills who will say anything for, several $100,000?
The difference in price and quality is insane.
Yeah.
$50,000 for them to do all of that extra testing? That's insane.
$50,000, and you've been led to believe that the critical point of cross-examination is going to be that Dr. Wolfe is in the tank for the defense, that he is literally crafting. Now, it is true that the current round of opinions did occur after they were hired. So, but their opinion was already the same even before. So if you went back just to the first trial, with their opinions were that it was not consistent. Now they've added on to it substantially by showing that Welcher's opinions don't make much sense, and that when they did the actual test that they still support their conclusions. But do you really think anyone on that jury is going to think that these guys are doing it, because their defense hired guns and whores? I doubt it, when you see that Welcher got $400,000 for doing nothing.
Yeah.
What appears to be, at least scientifically, in the eyes of the jury, for doing absolutely nothing.
Well, he didn't use the scientific method, right? He didn't use the scientific method. She wouldn't let any of those questions in.
No. So yeah, wow, that was much more effective than I even thought it would be. And you assumed that they were going to be the most important witnesses, but that was just so methodical, and just, that was death by 1,000 cuts over 3 hours, and just a systemic destruction of their whole premise of the case.
What stood out to me too was the noise that it made when they were doing those experiments. It was pretty loud, right? And some of those drone shots were pretty far away, and people in the house would have heard it.
I've heard even people who've done other tests. I'm not scientific tests, but just slammed the car in reverse up to 20 miles an hour from a dead stop, and it's loud. There's noise. So they don't have anything really that he did that they could even wrap their head around to say it's even remotely consistent, other than, I suppose, that at 24 miles an hour, there is taillight damage. Right. That seems to be the only thing that it even remotely could fit. But when you look at the tests they've done, and the damage, and the diffusers, and the hoodies, and and the lack of injuries, the lack of bruises, and so on, you start to say, yeah, I'm not crediting that beyond a reasonable doubt, because you're always left with the problem that they're going to have, which is their experts have to thoroughly destruct the ARCCA experts to the point where the jury says, it's not even reasonable what these conclusions are. Again, let them let them call as rebuttal witnesses, in all fairness, but short of destroying Dr. Wolfe and what's coming up with Dr. Rentschler, added it with what you saw with Barros, Loughran, some of the other stuff, the medical examiner, they're cooked if the jury pays attention to the burden of proof. They're cooked.
And if there's no damage to the hoodie caused by the broken taillight, how do you get shards of the taillight that are microscopic, allegedly, in the clothing?
Well, that's another fair question. I mean, how does the hoodie get damaged in the first place? How do you find this substance on it? Then you come to find out that it was intermixed with other evidence, which is why you need an expert in police procedure. For this point, amongst many others, because an expert in police procedure would say, if they took the hoodie and it was thrown with other clothes and other items and it could have commingled and the glass could have moved in there, or the taillight pieces, whatever it was, you need somebody who's able to tell you that you never combine that kind of evidence. And it was unaccounted for. It was in Proctor's possession for 2 months.
All in the same envelope.
Yeah.
Whatever. And the envelopes are all mismarked and there's no chain of custody. And that's why I wish we could hear Proctor try and explain all of that, because it would even give more of an abomination to the procedures that were not followed. I don't know if they're going to get the missing witness charge, but I guess we won't know until whenever she has the charging conference, which I want. And I don't remember if last trial, if she did it right before closings or if she did it at some point, like even before that. You know, maybe, was there a rebuttal case last year? I don't know. I'm conflating my cases now.
Normally, you would have the charge conference, before summations after, all the evidence is in. You wouldn't determine it until all the evidence is. So assuming that's how she does it, which is, I don't know why she wouldn't do it that way.
Because nothing is normal in this courtroom. You said normally,
right,
so
right. But this would be the normal procedure, though, would be at the close of the evidence, which means if they're hoping for missing witness charges, they're not going to know until they rest.
Right.
And it's too late.
You can't bank on that because based on all of her rulings in this case, like yesterday or the day before, because I don't know what day it is anymore, when Liza said, we still have the outstanding motion about Michael Easter. And she's like, oh, yeah, that's denied.
And then kind of hand shrug. Yeah, no, that was not the judge's best look. That was not a good look. But yeah, you don't know if she's going to give him the missing witness charge. So, might it still make sense to call Proctor and Higgins? I think so. But, this also may factor into why they think they don't need to, that they think that,
strong.
If these guys get through the cross and the rebuttal, that it's so open and shut that they just are in the business of risk minimization. They don't even want to risk it. To me, I would sweep the knee, aggressive, smother them, and I don't think these people can hurt you. I mean, they can't prove a car accident. Like Brian Higgins can't prove a car accident. Proctor, is almost certainly corrupt, and he's not going to convince anyone at this point he didn't plant the taillight. There are so many other things. The only thing that the ARCCA guys apparently are not going to account for is the actual damage that, the defense says happened at 5 o'clock or whatever at One Meadows. They're going to have to, I guess, live with how they confronted Welcher about that.
Yeah. Yeah. No, I just lost my question. Rebuttal. So she's going to allow a rebuttal, right? She's going to allow Welcher, I think, to come in because now he's doing more experiments to rebut the new testing that ARCCA did. Were there any other rebuttal witnesses? Oh yeah. Maybe the dog DNA expert and Crosby.
Yeah. I mean, I guess at this point they need to go even stronger after the dog thing because the hoodie,
right.
There's, at least as it stands right now, if you credit, again, there's been no cross, but if you credit after he testifies what Dr. Wolfe just said about the hoodie, then what is it? I mean, don't tell me it's hitting the brush on the street or the bush that he was. I mean, forget it. The point is you need to disprove that it could have been a dog. And you've had Dr. Russell say, I think it's a dog. So, and you have a hoodie that doesn't fit, and there's the shoe. Of
Will
course,
is going to die on the shoe hill. What about the shoe? And notice, Will, that the shoe did not fall off during any of that crash test dummy testing. So there goes that theory.
So I think they're going to call the dog guy in rebuttal as well. But I mean, it feels very melodramatic again when you're talking burdens of proof. I mean, the defense doesn't have to prove anything, but it feels like they've proven a lot, and
Right.
that's not good for the prosecution.
Right. That no matter what Welcher said, it couldn't happen. Because they ran every single scenario at every single speed. And Garrett Wing, I can't wait to hear from Garrett Wing. I haven't heard about him when he's coming. And I'm wondering, I don't think that, I guess Rentschler maybe the end, maybe last, because he said, ultimately you will hear from my partner, Rentschler, which indicates to me that he's not going to be testifying today or on the same day.
Right. And then the question is, are they going to call the cell phone guy?
Yeah. You think Welcher is allowed to be watching the ARCCA testimony? Because I know like certain jurisdictions allow it, certain don't.
I mean, I don't even know what the rules are in this court. They
I
seem
know.
to change on a daily basis. So to tell you the truth, I can't even keep track whether
know.
he's allowed to watch or not. To be honest with you, it doesn't offend me if she said that the experts can watch other experts. I mean, that does not offend me in the least. If in a normal trial, if Welcher said, I'm familiar with this testimony, it seems to me when you're dealing with experts who are contradicting or challenging or analyzing other experts, that's
In civil court, we're allowed to do it in civil cases all the time. The expert will come and sit in the courtroom.
Yeah,
And will actually help you with your questioning of the other expert.
I mean, if the goal of the exercise is to inform the jury on matters for which they may not understand, such that you need experts, it seems that in order to get to the truth, it would be better to let each expert have as much information as possible. And if they want to go back and forth of accusing each other of being wrong, fine. But they ought to have the full amount of information to justify why they believe that. So if Welcher is allowed to watch, that doesn't even, I mean, I could care less.
Somebody's pointing out that today is D-Day. Isn't that appropriate?
It's D-Day, yes.
It's D-Day. The defense storming the beaches of blasphemy in 2025. That's fantastic.
No, that was something else. That was really effective.
And to think that most of his testimony was based on this new testing. I mean, how much of his testimony was based on their original testing?
I can't even remember, but
I don't know if any of it was.
Yeah, I mean, you know, and we'll see what they do on cross if he's going to get into, you know, your original opinion. You didn't see this, you never, you know, looked at this, you didn't consider this. But at this point, does it really matter? Because by doing the testing they've done, he has seen the taillight break and said it doesn't match. He has seen all the various permutations of what could have happened and said it's not consistent. And so I thought they were very effective at kind of nullifying what could be coming. The same way you saw a philosophical difference in the way the defense deals with problems and the way that Brennan does. You know, Brennan lets it come out on cross, I guess, hoping some of it gets forgotten or just isn't addressed, where, you know, they get into how much are you paid and any kind of potential bias,
right,
that sort of thing, and just kind of diffuse or deflate the balloon a little bit beforehand. So I thought that was the right way to do it. And
the cannon testing, that's what came from the first trial.
The cannon testing came from the first trial, right?
Right. So shooting the cocktail glass at the taillight. Did it break the taillight? I don't know. My notes are a mess.
I think it
37 miles an hour.
Yeah. But you know, look, the other problem they have, again, there's no glass from John O'Keefe's glass on the bumper.
Right.
There's no evidence of this. So again,
it's never been their theory. It's never been the Commonwealth's theory. But when ARCCA was hired, they didn't know that because they were just told, here's a couple of things.
Yep.
Tell us whether, number one, the injuries to John O'Keefe's body match being hit by this car, and number two, whether the damages of the car match being hit by John O'Keefe's body. Go.
Yep. I mean, it's going to be fascinating to see if on cross, if Brennan adjusts a little bit and lays off some of the bias stuff, because it's going to look, I mean, there is desperate looking flailing cross and there is desperate looking flailing cross. And if you think anybody with a straight face is going to believe that Dr. Wolfe is sending secret messages on Signal to lie about his findings and strategize and be corrupt. I mean, at some point, the prosecutor's got to value his own credibility with the jury. And now would be a good time, because if you're going to ask them with a straight face and explain to them why Welcher is 1,000 times more credible than Wolfe, you know, it would help to harness as much credibility and good faith with the jury as you can possibly get. Calling these guys hacks ain't going to do that.
Right. Right. They didn't show when a body would have been injured in a car hit, because that is going to be his partner's job to testify. Dr. Rensler, who is the other crash daddy, Tootly Pip, will be testifying about that. That is his role here, and he will be testifying at some point in the future. This Dr. Wolfe, Daniel Wolfe, his only expertise, not his only expertise in the world, but with regard to this case, was the taillight damage. And that is why he testified about the cannon shooting the cocktail glass at it, because that was one theory that they tested. And then the arm hitting the taillight, and that was the other theory that he tested. So, I mean, he showed that the damage to the car would have been much greater with a direct hit. And in any event, none of these events would have damaged the sweatshirt.
Nothing damaged the sweatshirt, and you still didn't get the level of taillight destruction.
Right.
Both in terms of how much of the outer lens would have been destroyed. And I think, you know, they'll have to explain this perhaps in more detail, but the under layers, you know, obviously the more impact, the more damage.
Mm-hmm.
But how is the diffuser on the real taillight more damage from an alleged side swipe at a lower speed than a direct, I mean, obliteration that you saw at the end there at almost 30 miles an hour, and a direct impact, and it's still not to the level of taillight damage either on the surface or underneath. And you just go back to the arm. I mean, I don't know. Picture a jury. I'm assuming none of them are medical doctors. I don't know, but
yeah, we don't know.
Assuming they aren't, it's hard to picture the 12 people sitting around saying that his arm with cuts, again, not a medical term, lacerations, abrasions, whatever you want to call them, that's all he would suffer, and there'd be no bruising, no breaking. I mean, based on what you saw today, you would expect, you know, a
Shattered arm.
Shattered. You would expect the bone in there to be in several multi-fracture and just destroyed. And I would imagine too, at autopsy, if his arm was destroyed, even if they didn't want to do x-rays, even just by touch, feel, and vision, they would note, wow, that arm is shattered. And if they thought it was, then they probably would do x-rays and you'd see it. And the fact that everybody glazed over that and just skipped it.
Well, they didn't do x-rays of his lower extremities either, but Dr. Irene Squirty Bello opened up his legs.
Right.
And Dr. Russell was able to get that in. Dr. Irene Squirty Bello said, you know, I examined the legs, and then when they were, and she used a word and I can't remember what it was, but it means like to open up the leg, but it wasn't really brought out or specified. Dr. Russell just threw it right in there, which I loved. They weren't able to get in that it was actually the FBI that hired them, but do you think that what they were able to get out of them was good enough this time, based on what we know that Ronnie said last time about them discounting ARCCA because they didn't know who hired them and thought it was an insurance company or Turtle Boy?
Yeah, I think it's good. I mean, look, it's frustrating from their standpoint because it ought, I mean, not the FBI technically, it ought to have been out. The Justice Department, U.S. Attorney hired them. There's been enough FBI mention or
Reflected the legs.
in this case. Even though it didn't come out, yeah, I think they separated it as best they could. But I also think it's less of an issue this time than last time because you saw the difference when they could actually prep the witnesses. And I think, you know, in some ways, this would cut against Brennan's cross too, although the jury may not be fully aware of everything that happened. But if he's going to allege that these guys have always been in the tank and they prepped
Right.
before the first trial at this point with these witnesses or this witness, you can see was bare bones.
Mm-hmm.
This was much more in depth. So I don't think the fact that the jury didn't hear FBI, DOJ, U.S. Attorney,
That could also work against Karen, in my opinion, anyway. It could be like, oh, they wanted to bring federal charges against her too, and that's why the FBI was in there. Like, you don't know the way people think. They're not lawyers.
I don't think it matters. I think it's been pretty well established that they weren't hired. And the other thing is this, depending on how aggressive Brennan gets and how calm or composed he stays in staying, avoiding touching the third rail, if he's not careful, he'll open the door to it. I mean, if you start exhibiting claims of how biased they are and how you're in the tank for them, and they're like, we didn't even get hired by them, at some point, fundamental fairness would require, Your Honor, we need to tell them who hired them so the jury knows, because he's implying these are like hacks for us. So he needs to be careful. Like the same way, if he wants to examine him about the signal stuff, which is stupid anyway, okay? And by the way, these are young jurors.
Yes, they're going to get it. They're going to be like, Big Wolf.
They probably all use signal and all that, okay? So if you're going to cross-examine him about signal, then he ought to be able to explain why he uses signal. Right. And when it comes out because they were harassing my wife, do you really want that? And that does not open the door to you now bringing in other allegations of harassment like he tried.
With Lucky.
Right. Just because you did doesn't mean I can. So does he really want to get into that stuff?
It's going to be exciting to see what he decides to talk about. And Sam points out when the taillight hits the crash dummy arm, it doesn't even touch the upper part of the arm where the deep lacerations are, right? Like, so it never, ever did any damage to the area between, the bicep area between the shoulder and the elbow, no matter what, even if it was going 29 miles an hour.
Yeah. I mean, there are certain things that he could do on cross that I would do, not the signal stuff, not all that, but there are, look, if you're trying to show that they have developed bias over time, you're never going to get them that they gave a report before they knew who the defense was. Mm-hmm. At the end of the day, you can't get past that. That's just, they were hired by a third party. They gave an opinion before they knew who the defense was. Yeah. Now, some interesting things have happened, I suppose, in between trials. I know, like, we heard about his wife getting harassed, and, that allegedly occurred because she joined one of those Facebook groups or something. To me, that's crossable. I get it. If you're trying to show, but is it going to have any real impact when he already concluded beforehand? I don't think so. It doesn't strike me as very powerful. And in any event, you need to utterly destruct these witnesses. You need to make them not credible. You can't have them even be possible, right? If their opinions are possibly accurate, that is by definition reasonable doubt. By definition.
Yeah. Well, if you're sitting back there thinking of any other way this could have happened, that's reasonable doubt. Imagine if Lally got up to do the cross. That would be fabulous. But he needs to earn his $250 an hour. Brennan does, and he likes to pound the podium and get up and yell and scream. And wow, there's no way Lally's doing cross. But imagine like the little bit of vindication that Trooper Paul got today from watching that crash test dummy spin around and do a pirouette, even though it was on strings like a marionette. It made him feel probably just a little bit more validated.
Their case to me looks to be on fumes. The last several days, this is the worst. This is as rock bottom as it gets. Again, pending cross and all that. Right. But following, Lucky, following Barros, their own expert really not being great, the medical examiner. You could go on, and you just say the wheels really do seem to be coming off the bus as they approach the finish line. They don't have much momentum. They're not in a position of strength. The DA usually in a case like this, especially given that they're not calling the lead investigator, you would think it's because we know the science is going to make this the be all end all. And the reality is they got some evidence out there. I get it, but it's not that compelling. It's refuted by defense experts. Some of their other experts just were not that impressive. And I don't see how they get where they need to get, not knowing what the jury is, obviously, but it seems pretty difficult.
There's been no confirmation that the FBI investigation is closed. Is that correct?
I have no idea. I mean, we know what was said publicly a few months ago. Now, that came from the Canton police chief, so take that for what it's worth. She resigned a week later. I don't know that that's related or unrelated. No clue. I don't know.
Mm-hmm.
When you start hearing some of the stuff that you're seeing today, you know, you do start wondering, are they not looking at this with any degree of concern? Because, you know, the interesting thing is this. When the feds punt, if that's really what they did, I, again, don't know.
Mm-hmm.
They had the ARCCA opinion, but they didn't have the ARCCA opinion on steroids that now exists.
Right.
I mean, it's actually
so much
stronger
yeah.
than it was before. So, you know, how that factors in, I don't know.
Yeah, let's talk about the alternate selection and the bingo balls, and you know how last time it might have been like, maybe the defense team wasn't shown the bingo balls. I don't know. That's what it looked like to me. I think that, are they allowed to request that the judge or the clerk show everyone all the bingo balls, for lack of a better term, before they go in the drum, and then see them when they come out? I'm sure that is a reasonable request that should be granted.
I mean,
by this judge.
The fact that we're even talking about this is serious. Right. Tells you that there's a crisis over there, that's how people believe that there are issues. So that's an issue for sure. But yeah, why not? Why couldn't they? I mean, I think transparency, the defense, prosecution as well, has a right to know. We do know, I mean, I've heard you say this, that in some of the other high profile cases, or even profile cases, there's a hell of a lot more transparency. Everybody gets to see. And in this case, it wasn't. I think the concern would be, they're kind of screwed either way. And this is what the public thinks. If they do it right this time, okay, in other words, the way they did it in that other trial,
Turk, yeah, it was Turk, yeah.
Are they implicitly, to some anyway, acknowledging, well, we did it wrong the last time?
No, but just a little more transparency. The world is watching. Let's just be transparent, you know, let everybody see what's going on here.
There's going to be a segment of the population, though, who's going to say, why didn't you do that last time? Why didn't you do that last time? I mean,
people are always going to say what they're going to say. Why didn't she pull the jury last time? Why didn't the defense ask to have the jury pulled last time? Why, you know, why is she being tried for the second time when she was acquitted of 2 charges the first time? There is no missing witness. It's a missing witness charge that is given to the jury when witnesses are available, but the Commonwealth chooses not to call them because it gives the jury an opportunity to make an adverse finish my sentence. Inference.
Adverse inference, yeah. I mean, you know, think something dastardly. I mean, if you have cases with missing witness charges and you get it, or any case in which you have an adverse inference to your benefit, all it is a license to scream and yell at the jury about how sketchy this is, and the judge is going to tell you you're allowed to I mean, that's a powerful one. You know, I'm just a screaming lawyer, you know, doing whatever I'm doing, but the judge is going to tell you that you can do exactly what I'm suggesting, essentially, in so many words. So, you know, if they get the missing witnesses, it's good. I don't know if they will, because it's really too hard to predict rulings in this court.
I know.
Because
you know, every day is a new day.
Yeah. Now, the defense may also be factoring that we don't need to call Proctor because we really, really want to emphasize that he is the boogeyman. I don't agree with this, by the way. I would do it. I mean, I would drag him for hours with some of this stuff. But they may be thinking about this differently and have a lot of trial experience at the highest level. We all know that.
Right.
But that they may choose that they want to emphasize that knowing what you know Barrows, okay, the ARCCA witnesses, that the reason they didn't call Proctor, it's not about the text messages and that stuff. They wanted to hide him because there's no answers for the taillight stuff, on top of the fact that the video was stuffed in his pocket for 2 years. And everybody knows that the video, you know, there's inverted video, there's missing footage from the exact time that the car was alone in the Sally Port with these people. And, you know, isn't it funny that the guy who was holding all that video and all at the time that this stuff might have disappeared was, you know, the ghost of Michael Proctor, who they're not calling. I just wonder if they almost prefer him to be a ghost rather than somebody that they could just pound. I mean, I think they could utterly just eviscerate him beyond belief. And there's nothing he or Brennan could say about it. I mean, nothing. After the witnesses you're seeing today, I mean, maybe, who knows? Maybe they're calling him last. Maybe they want to get all this out there. You know, I mean, it seems clear they're not going to, but you never know. They still can. They still have the right to do it. So who knows?
JJ wants to know if you think the Commonwealth's case is as bad as the Celtics head coach.
No, because I think Missoula is a good coach who had a bad series, you know, and he won a championship. I don't think that this DA's office is going to win any accolades as it relates to this case. You know, they're probably going to lose this case. Probably. I mean, we don't know, but they're probably going to lose. They're going to have to explain, you know, why they ignored this type of evidence before the first trial, the second trial, why they spent $400,000 on experts for hire. I mean, these are classic experts for hire, the Aperture, whatever. It's a cottage industry. You know this. I know this. In the legal world, there are experts for hire. The Aperture appears to be experts for hire. What do you want us to say? And, you know, we'll get there. It is what that is how a lot of times this works. They're going to have to explain why they hired a special prosecutor for $1 million when they didn't have a conflict, why they dragged the Norfolk community through this again and again, why they spent all the money with the extra security for this buffer zone stuff. And I mean, this thing is just bleeding money all over the place on the heels of the Birchmore thing. And this is the fallout from this politically is going to be pretty bad, I think, for a lot of people in Norfolk government.
What do you think about Brennan's trick questions that he's been asking some of these witnesses? Like, do you remember when you were shown photographs during the first trial? And it's not true. And then he's tricking the witness into thinking, well, this guy's not going to lie to me. I mean, and I think that's what kind of confused Barrows a little bit.
So I don't like it to an extent. I don't like the initial question being posed as an affirmative statement that is not true. If the witness had said that he saw a picture and you kind of got him to believe and agree and lock down that it was, you know, at the first trial, then it doesn't offend me that he would just ride that all he wanted and said, so when you saw it at the first trial, you know, when you, the initial question stated as a false test, that's a little sneaky. That's not how a lot of lawyers would do it initially, as opposed to just determining, you know, you did or didn't.
Is it improper or unethical?
You can make that argument. I mean, again, it's cross-examination. The witness said, I did look at it. He didn't say, oh, well, I thought I did because you told me, but not that he's supposed to think like that. I mean, I guess I'm a little surprised that the witness was not prepped. He said he went to meet at the hotel, took a subpoena, just confirmed he would testify, but never sat down and prepped.
Which is totally permissible and expected. That if you're calling a witness, you are supposed to prep them. You're allowed to talk about their testimony. You're not allowed to tell them what to say, but you're allowed to go over their testimony with them and even put them through, you know, a mock cross-examination.
Yeah.
Right.
I mean,
It's
So-
not improper in any situation.
No. So, it kind of came out a little clunky with him in the sense that, I mean, look, he was never even cross-examined at the first trial. He didn't testify inconsistently. Nobody drilled down on what he said about seeing a crack. Now, the fact I mentioned this the other day, actually yesterday with Peter, I don't know if you watched that thing.
No, I didn't get to see the whole thing. A little bit of it I did.
But I kind of outlined why I think it's pretty strong evidence that Lally suppressed favorable evidence about Barrows before the first trial because he called him as a prosecution witness. He had to say what he saw, which was a crack, not what everyone, not exploded like the other people were generally saying. And he never drilled down and said, well, what do you mean? And show him a picture. If you knew that that's what Barrows was going to do as the prosecutor, you would have shown him that picture.
Yeah.
And he says, that's what it looks
Oops.
like.
Hold on. Wait.
He's screwed. And he didn't.
Right.
And he didn't do that, which tells you he didn't want the answer. And he probably called him on direct called him as a witness to avoid the defense calling him, knowing that if the defense doesn't know, they're not going to have the guts to just throw it out there. And by the way, that would be the correct move. I would not have crossed him either, knowing what we now know. I mean, it turns out if they ask the question and he says, oh yeah, it looked nothing like this, then they would have probably got an acquittal or something close. But you can't fault them for not asking that question when you assume he's going to potentially make it worse. But the real scandal there is Lally had to know because he didn't ask him.
Right. Right. And he prepped him.
Yeah.
You would imagine. And who knows if Tully was involved in that prep as well.
It is the exact same thing as Lally not asking Kerry Roberts at trial about the Google search, which would have been powerful evidence because he knew.
Right. All that exculpatory evidence just held from the defense, which is not the way our justice system is supposed to work, by the way. This is
I mean, they knew about, I mean, maybe that's not the best example because they knew about Kerry Roberts and they just chose not to cross her. But my point is, if they know that Kerry Roberts did not hear that Google search, I don't know how, as prosecutors, they're just not troubled and saying, what's going on here? What are we doing? We need, or at least advising her to get counsel before she gets grilled about it at the second trial. But they just ignore so many red flags, which would appear to suggest that something nefarious might be going on here.
Mm-hmm. Yeah. And I think, the more evidence of that, the better. But, again, a trial is a living, breathing thing. And it's not over until it's over. So
Right.
maybe the defense is thinking, all right, we know that this ARCCA testimony is going to be such a slam dunk that we don't need to risk it with Proctor, Higgins, Brian Albert. Because Brian Albert, by the way, is a professional witness. Like, this guy knows how to testify. He's testified hundreds of times, He comes in with his Mr. Rogers cardigan on and, it's not worth the risk with him, maybe, but Brian Higgins?
Yeah.
I want to hear from him.
Pretty much nothing you could say, again, going on what we know, which may not be the same. There's probably nothing you could say which would talk me out of Proctor and Higgins. And Higgins, look, now you have evidence that Higgins might have been in the Sally Port with Berkowitz. You already know that they're going to link that to Berkowitz finding a piece of taillight. Higgins was there with him, but all of a sudden, you start thinking about Higgins, the man in the house, which is different than Jennifer McCabe. And it's only her. You don't have 11 witnesses this time saying nobody came in the house.
I know.
Destruction of the phone in a way, multiple garbage bags, multiple dumpsters, the day before a preservation order, the selective disclosure of text messages through the help of your FBI buddy. I'm only giving them this, though.
Right.
The Canton Police Department stuff. I mean, you could go on and on with Higgins. The Jeep, which I think at this point is a huge point to either demonstrate that either McCabe is lying, and if that's not the case, then Welcher's opinion is even more damaged than it is today if the Jeep was there. And I mean, all they have to do is throw out some doubt here, there, and everywhere, and it's all over the place.
Yeah. Yeah. They're not getting as much of the suspicious behavior as I would like. I just I feel like the jury wants to know more of the story. And so that's my only
Well, it does.
hesitation about calling these people too, is
It does feel like
not
maybe
calling them.
at the first trial, I mean, they went a little too far with proving what happened, or at least suggesting a theory of these people did it, you know, in the basement and da 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 da.
Except Lally called every single one of those witnesses.
Right, that's true.
Right.
But
So
maybe this time though, there's an overcorrection in the other direction, which is to be hyper careful about that. But the reality is they've put out a lot of stuff about Higgins and even Proctor. I'd want to finish that up. And, you know, they also have to be concerned. I don't know that this matters what the jury even remembers or what they don't, but, you know, they wrote a lot of IOUs in a spectacular opening statement.
mhm.
But if you don't, you know, if the check is due
Yeah.
and you don't cash it, you know, does that work against you? Because they said a lot of things about Higgins, Albert, and Proctor, which at least at this point is not going to be delivered.
Right. And then that gives Brennan the opportunity to close on that. Remember what they told you in closing? They told you the evidence was going to show you this, 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 and this. And yeah, just because we didn't call these people doesn't mean they couldn't have called them. And they didn't call them, and they didn't prove, they're not prove it. You know, they sold you a bag of goods in the beginning, and there's no evidence of that now.
They did put on a case, so the prosecution can comment on the adequacy of what they did and didn't do, other than obviously Karen not testifying. Obviously, there's no, you know, that would be error. But, you know, if they don't put on a case, then the prosecutor can't say they didn't do this, they didn't do that. They have no obligation to do anything. It's burden shifting. But they did put on a case.
Right.
So they are, in theory, subject to, you know, pick and choose attack.
See you close the session.
Do you want to hang out, or do you got to split?
For a little bit. Yeah, what time is it?
All right, so counsel, we have a juror that needs to leave at 3:45, so we're
Of
going
course.
till 3:45 today. Okay? Okay.
Super chats won't be read until the end of the stream. If you're going to put them up, I'm not going to address them until the end, because Mark likes to take questions that people don't pay for, et cetera, et cetera. He's not a YouTuber. For whatever reason, that's the way it's going to be. So just guide your actions accordingly. Please, kindly. So we're still on direct, right?
No.
Did he finish?
Yeah.
Put us back in session, you may be seated.
So jurors, we are going to stop today at 3:45. All right, Mr. Brennan.
Thank you, Your Honor.
Oh boy, here we go.
Go-
It's going to be
All right, so, okay, great. Thank you. All right, do we have the actual? Okay, great. Yep. So,
Exhibit 216.
thank you.
No, AJ did not bring up signal.
All right, Mr.
We're
Brennan.
going to see if he brings it
Good
up.
afternoon, Dr. Wolfe.
Good afternoon.
When you testified in direct, you shared with the jury some of the work that ARCCA does. Do you remember that?
Yes.
And you had mentioned a couple interesting things, that there had been some work with the Department of Defense.
Correct. Yes.
The work with the Department of Defense, was that during your time or before you got there?
That would have been prior to my employment. Yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCCA before you began working there.
ARCCA as a whole, yes, the work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff for the company.
This is all you got?
You know what's coming. It's going to be attacking the integrity and intelligence of this expert, and this is going to be nasty.
You lied, and you said that you did this work.
Company does some things for the NHL.
Yes.
You didn't tell us much more about what you do. There's other things that ARCCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation, insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do and the NHL but didn't share the rest of the stuff with us?
That's just some of the prominent clients that we have.
Okay, see what he's doing now? He's planting the seed in the jury's mind that they were hired by Karen's insurance company.
Yes.
And AJ should be able to get up there and redirect and say, you were not hired by Ms. Reed's insurance company, were you? What do you think?
It's clearly what he's doing. We'll have to wait and see where it goes, but he needs to be ready to act and ask. Yes.
Yep.
I see.
I see.
You provided us a CV, didn't you?
Yes.
And that's like a resume, tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the director of accident reconstruction at this company, ARCCA, since 2017.
No, not since I started.
You started with ARCCA in 2017.
Correct, yes.
When did you become the director of accident reconstruction?
I think that would have been in January of 2024, so about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACDAR.
Yes.
Did you pass the test on both parts first time?
I don't recall if it, I think it was I had to retake, I think, the practical section in the afternoon.
Well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
It is, but much of the concepts that are covered in it are very elementary.
Well, not so elementary. You had a hard time with part of it, didn't you?
Well, with respect to the portion that I had to retake, it's a practical exam where you have to reconstruct an accident, where you have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation, then the whole problem is graded wrong, even if you did all of the math correct.
So we understand there's a multiple choice question part that's the easier part, correct?
I don't know if it's easier, but there is a multiple choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like things that you did today.
You don't go out into the field, no.
And when did you first take that second part that you didn't pass?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say, you took it again.
Correct.
And ultimately, you passed both sections of that test?
Yes.
In your CV, you list your schooling, and you list your degrees, don't you?
Yes.
Here we go. Did he lie about his degrees too, like Shannon Burgess?
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
In your entire resume, you only mention pedestrian collisions, or that you're involved in pedestrian type events 3 times. Is there anything specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note areas of specialty, and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle HD EDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No,
Have you ever taught regarding pedestrian collisions?
no,
Have you ever been a speaker in a presentation about pedestrian collisions?
yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
He should teach because he's a great
You
teacher.
asked questions about your involvement in this case. Yes?
Yes,
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
yes, another agency.
Another agency. And at some point, you came into court and testified last year.
Yes,
And during the time before you came in and testified, you weren't wholly independent of the defense, were you?
Really going to do it.
Here it is.
well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
My question, more precisely, before you testified, before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes,
And in fact, some of the time,
Do you notice how he moves away from the mic every time he's going to do or say something stupid?
Yeah.
All right.
that you spent, ARCCA actually billed the defense for, and they paid that bill, didn't they?
eventually after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Yes,
Do you think that you're under a sequestration order today?
yes,
Did you talk to anybody about any of the prior testimony in this case before today?
no.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Who set up the car?
It would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Was there
Because Dr. Russell said limo. So now he's going to go with limo. Do you believe this guy?
anybody from the defense with you on the ride over?
There were 3 young ladies in the back seat. I think they might have been interns, and Mr. Woke.
And who?
Mr. Wolke, I think is it pronounced? Am I saying it wrong?
You know who didn't drive him? Tully.
Look, no, the interns won the lottery. It's like, they all want to, all the female interns want to go with Dr. Wolfe, so they got priority. So
Anything about this case before your testimony today as far as the trial?
Before today?
Yes.
Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
With the FBI.
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
He's opening the door.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual verbatim communications with the defense, did you provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records, you know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date, it's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think you had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, I think it was 50.
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics, yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well,
Isn't
you were
the
asked to search.
the young jury going to know that you can't go to recently deleted? Like, it doesn't it automatically delete after 30 days, even if it's in your trash?
I think that's the default on an iPhone, I think. I don't think the young jury cares. I mean, you just heard overwhelming science, and he's attacking him, which is, I mean, you have a right to cross him, obviously. And if, he didn't do a test the right first time, that's fine. That's proper. I don't know that it means much, but why is he so nasty in tone, implying that this guy is a snake? I mean, this is going to backfire so bad, but, be you, I guess. You be you, and we'll see where it goes.
Look at my freeze game on point today. He's got his tongue stuck out. That's awesome.
Grin, like, are we going to do this again? We're really going to do this again.
Bring it. Do your worst. Let's go.
The text messages, did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communication?
When I was in the DA's office, we used to have these expressions for lawyers who were just nasty for the sake of being nasty, or cross-examine, just doing it like this. And you'd call the cross-examination, yeah, but everything is, essentially, yeah, but this, yeah, or, just this nothing. It's just bullying and yeah, but this, and trying to convince the jury that by seeming indignant that you're establishing something, and all you're doing is probably going to put people to sleep. This feels like a Dr. Russell redux is what you're going to get here.
He sounds a little bit like Gilbert Gottfried, and that is exactly what he did to Lucky when Lucky said, I wasn't paying attention because I was grieving the loss of my wife, and I wasn't paying attention to social media. Yeah, but, it was so gross, and I think the jury's probably over it at this point. Yeah, totally destroy, like Higgins and Albert. Right.
Communications with the defense.
Well, it's something that I routinely do.
I just want to take that back to the question.
Is there any reason why you deleted all of your text?
So I don't mean to interrupt. You just made a really fascinating point. I don't think they're going to do it, but Brennan is implying that this guy did something nefarious with his messages. If the jury were to learn what Higgins and Brian Albert did, and also if you call Richard Green, all the deleted information from Jennifer McCabe and the one Google search that was deleted, that's a huge backfire. I don't think they're going to do it, but he doesn't get this righteous indignation if that happens.
Well, I've heard that Green is in the building. People say that Green's been spotted in the building, so that's great.
That answers that.
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
Okay. And so, at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of
Here he goes.
communication, not text messages.
So Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any.
Brennan, that's the point.
Right. And since you tried to pierce the attorney-client privilege by trying to get messages between attorney and client, thinking that that is not a sacrosanct privilege, it would be very smart for all attorneys going forward to use Signal when communicating with clients, in my opinion.
Clients might expect it, actually.
Right.
They might
Any
find
record.
been using a form of malpractice if there was a breach of data that you did not carefully protect. This is a big red herring about nothing. This is absolutely embarrassing that we're cross-examining an engineer PhD who's talking about what he talked about on direct with using a messaging app that encrypts. By the way, the United States government uses Signal.
Right.
Anyway, okay.
Right?
I don't believe so, no.
Well, you have.
Date, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you have it. You're using it. Do you have any records from your Signal use?
I'm going to allow that.
Do you have any records from your Signal use?
I do not, no.
So you know full well that Signal as an encrypted app leaves no record.
There may be a setting that you can change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Before you testified last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Sustained enough.
When you testified at the prior proceeding, did you attempt to portray yourself as totally independent?
Yes.
The truth is, before you testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
So before you testified, you wrote out questions that you thought could help, that you should be asked when you testified, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question. So
Sustained.
I'll ask you again. Before you testified, did you write out a list of questions that you wanted to be asked?
Yes.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
I didn't say verbatim, but did you list out the answers to each and every one of the questions that you had prepared?
Yes.
So for every question, there's an answer that you provided so that you could follow a script, so to speak, yes?
A script.
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that's not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
And then you put a footnote, a comment. and you said, not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. If you need to show the jury, it doesn't matter in this case. You write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
And so when you were writing out these questions as is your routine with the answers, is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence has gone from the roadway.
They never called. I mean, that's what you should
No.
say. They
And
did. They liked my answer. You didn't, so you ignored me.
Right. And everyone who's watching for the first time should know that both sides had the opportunity to call them, contact them, hire them. Well, not hire them until they were released by their contract from the feds, but they could have called and spoken to them, and they would have spoken to them. They just didn't have the answers that they wanted.
The vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
And you said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct. Yes.
And do they happen more often in the day or at night?
More often at night. Yes.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
And in fact, when you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, when you shared it last year and this year, was it an important point for the jury?
I think so, because it helped gave them an understanding, I think, of my background and lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would leave it out?
Well, I think because I didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day, it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something was important that it helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
If you want the jury to get to the truth, why are you trying to keep ARCCA out?
The fact that he's implying that he misled the jury deliberately, it just feels like there's nothing this guy won't do or say to establish what he thinks is appropriate to establish. I mean, this is just not how prosecutors generally act. They just don't.
Yeah. Somebody said, did he just imply that the jury's too stupid to understand? That might be the way they're taking it.
But you offered to. You would have it requested. Why did you invite, why did you invite somebody else
Excuse me.
to inject in your...
It's better than over here.
Why did you leave something out? Why would you even provide that invitation for that?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Be
Yes.
done?
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
Is that a self-reflective question?
Yeah.
I would do my best to do that. Yes.
Well, when you say do your best, would you do that if you became aware of it?
Yes.
I'm going to allow it.
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
What, dear?
Correct.
When you were
Yes.
sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
The reality is you hadn't. You'd only testified and been qualified 11 times at that point.
Correct. I misunderstood the question. I thought it also encompassed deposition, so I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why I provided a comment with the specific breakdown for
And
clarification.
when you came back and testified under oath the second time, on the record, under oath, did you clarify and fix the mistaken testimony that you had provided just days earlier?
I don't recall being asked a question. No.
No, it wasn't whether you're being asked. The question is, did you take the affirmative step to fix the misstatements under oath that you made? Objection.
Yeah, approach, because he's not required to do that.
He's also calling it a misstatement is an unfair term, and that's Brennan's word, and that's not appropriate. I mean,
Nothing he does is
After your
appropriate.
first testimony, after your first testimony, you appreciated that you made a statement under oath that was wrong, didn't you?
Yes.
In fact, you made a note, I realized in my testimony I said about 20 times, when you asked me how many times I've been qualified, I misinterpreted your question, which was my fault, but in looking at my D&T list, it's 11 trials, 7 depositions, 18 testimonies total. Not sure if you want to clear it up or just leave it. Those
Correct.
words?
Yes, sir.
Did you just leave it?
I'm not responsible for asking the question, sir.
Right. So now he's going to blame the defense attorneys for not asking him the question?
he also gave a perfect substantive answer to why he said approximately 20. So, and then he self-reported it, but wasn't asked the question. And Brennan wants the jury to think that this guy lacks integrity because he didn't stand up and say, oh, by the way, you need to do this. That's different than the last time. I mean, this is embarrassing.
Which is downright laughable, being that Shannon Burgess lied about a degree that he had that he was still trying to get 17 years later that doesn't even exist. So,
Well,
you know, I mean,
that's another very good point is, do you really want to dive into this guy's academics and credentials and just highlight what your own guy did?
and make your own guy look so much worse if that was even possible.
Yeah.
Let me see if I have anything else.
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the
Oh, we're
facts
going
of
after
case,
the white.
one
Here we
side over
go.
the other.
Wow. I hope he says, yeah, my wife was harassed relentlessly by trolls on the other side because she apparently was commenting in maybe like a Facebook group that was like for Karen Read. Oh, this is going to be great. Look at his face. He's like, you want to come for my wife? You want to come for my wife? Come at me. Come at me. Let's go.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Yes.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
Chaka is in the corner because we're in the land of the lost.
Well, he talks to the Twitter lawyers. He feels like cross-examination by Twitter.
No, I have not.
Yep.
No.
Look at the judge's face. What am I going to do when the inevitable objection comes up? What am I going
You're
to do?
unaware of anything that may influence you to lean one way or another?
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
Part of your testimony today to this jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct, yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Rentschler have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
Yes.
And so some of the data that you shared and some of the opinions overlap with each other, wouldn't you say?
Certainly, he's going to rely on a lot of that test data, yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Rentschler cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't read that reference.
Did you read 25, the book that is cited, Forensic Pathology, 2nd edition?
I'm going to have you come to sidebar.
Wow. It's got nothing.
At least he's on substance, finally, a little bit.
Is this a learned text?
Let me again ask you about this book that is cited in Dr. Rentschler's report. By the way, have you read Dr. Rentschler's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Rentschler, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked you was, did you, in working closely with him, take the time to study his report?
Wouldn't that
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he.
Say again?
wouldn't that lead to the confirmation bias that he just said you shouldn't do?
Right. Right. First he said read his report. Now it's study his report. So he keeps asking his question a little bit differently each time. That would lead to confirmation bias, 100%.
He cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report.
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of whether or not crash test dummies should be used during experiments as a basis for an opinion of whether abrasions can happen through cloth or an arm, Wouldn't that particularly interest you since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes,
And
yes.
as part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education? Don't you
Yes.
think- and they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question.
You hear that? When you get upset with my question, you generally tend to answer a different question the way you want to answer it. Oh, my freeze game is so on point. He's the reason people hate lawyers. He's the poster child for the reason that people hate lawyers until they need one. And even if they needed one, they still wouldn't hire him, in my opinion.
Strike that, Jules.
Let me ask you again. Don't you think, as an expert, it's important when you come in and you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw in Dr. Rentel's report references to this very issue about what should be used when you're doing demonstrations or study of what can cause tears to clothing, weren't you interested in the basis for those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read the book that he cites as support, Forensic Pathology, 2nd edition, Vincent J. DeMaio? Did you read it?
No, I did not.
Did you brief it?
No.
Did you peruse through it at all?
No.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury mechanism caused by player surface contact during soccer, a survey and systematic review? Did you review that?
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the... You're shaking your head.
So I'm going to let him answer the question first.
Injury component.
So as I mentioned, Dr. Rentschler is assessing the injuries to the arm, okay? He indicated to me that we could utilize the hybrid arm to assess the injuries to the arm.
So you have no independent experience or research or knowledge, not Dr. Rentschler, you don't have any independent research or science or knowledge to support your idea, your theory, your opinion to this jury about the tears to the clothes into the skin.
I was relaying the observations from the testing that we conducted with the ATD. Ultimately, like I said, Dr. Rentschler, it's my understanding that he will testify to the abrasions or the lacerations to the arm.
You've given multiple opinions about this to this jury, didn't you?
Correct, yes.
I'll ask you one more time. I'll ask it this way. Name other than someone called Dr. Redsler, name the papers, the studies, the learned treatise, name the resource material you relied on as the basis for those opinions, that a hybrid three-arm can be used in these type of demonstrations as a basis for that type of opinion.
I certainly, ATD crash test dummies can be used for impact testing, yes.
Not impact testing. You're talking about pierce to clothes, abrasions to skin, and I'm asking for the third time. Name one journal, one paper, one study that supports your proposition that you're relying on the basis of your opinion in front of this jury today. Name one.
I did not cite any in my report, no.
Can you think of one that you didn't cite?
Not that I'm aware of, no.
Maybe he's on the cutting edge of the research here. Hmm?
You had mentioned on direct examination that when you first started looking at materials some time ago, at the beginning, you were unconstrained in the scope of your study. Is that fair to say?
Are we talking about 2023?
Yes, we are.
Okay, yes.
You were unconstrained. You could have done anything you wanted to.
I don't know about anything.
When you said unconstrained, what did that mean?
Well, the agency that retained us didn't ask us to do specific work per se or specific tests.
Because the
You didn't do
FBI
it-
has an unlimited budget.
Any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Retrial thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Pressurized
Why does he?
cannon.
Why do they
And
want to
you-
keep calling it a potato cannon? Is that a real thing, or is that just like his disparaging term for this cutting edge technology that they're creating? Mark, is a potato cannon a real thing?
I'm on Google right now. It's
Oh, okay. I thought maybe I mean, you know so many more references than I know. So
why I'm
Shot a
here.
glass at the rear
Yes.
taillight, yes?
Yes.
You determined that at
Real thing.
37
It is real,
miles per
okay.
hour, there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency to the jury, didn't you?
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
you're thinking outside the box.
Now,
Nobody knew what the
when you gave
Commonwealth
that
theory
theory
was.
last year to the jury, did you know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about a glass being
Opined.
thrown at the tail light was consistent with damage, did you think about how, if a glass was thrown at the rear tail light, the bottom would have bounced off the vehicle wherever it was and landed near Mr. O'Keefe's body?
I'm aware that it was found near his body, yes.
And knowing that it was found near his body, or you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the body.
now it's 7 or 8 feet off the road. I don't know that anybody's testified to that.
No.
I think somebody said 30 feet. I think there's been a lot of nobody ever measured it. We know that. But now he just states it in his question as if it's fact.
Yep.
Bottom of the driveway.
That's what he does.
Broken glass was found near his body 7 to 8 feet off the road. Did you consider if somebody threw a glass and broke that taillight, cross your mind, how would the bottom of the glass bounce with him to where his body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, do you consider how the speaker would be left at the curb?
No, I did not evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the line?
Well,
Debris
it's
field.
my understanding, I think that there were plows that came through that night, so I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yard or were just down the middle? Look into that at all?
No, I did not.
So did you give any careful consideration to if the glass was thrown and hit the back of that taillight, how there would be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not, if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail blight to break?
Is there a reason why you were backing off that opinion on direct examination today?
Sustained.
You weren't fully embracing that theory today, were you?
I'm going to allow that.
I don't know if I agree with that.
In this case, you provided reports recently.
Yes.
When did you provide your report? Was it April 6th
April 6th?
or was it May 6th?
I think it's May 7th,
May
if I'm not
7th.
mistaken.
So you provided a report May 7th, yes?
Correct.
And do you know when this trial started?
Early April?
You provided your PowerPoint. When did you provide your PowerPoint?
I think it would have been Thursday of this week.
Well, it wasn't last night. It was
Sorry,
probably-
maybe Wednesday.
probably
Wednesday or Thursday.
Wednesday. Is that fair?
Yes.
Ooh, that PowerPoint hurts, doesn't it?
In looking at pedestrian accidents, it's important to try, if you can, understand the exact positioning of the body, isn't it?
If a collision occurred, yes.
And if a collision occurred, you can't always identify the exact position of the body, can you?
No, oftentimes it can be very difficult, yes.
You would want to know if it is a collision between a car and a pedestrian, whether the person was fully impacted or it was a clipping type incident. Wouldn't you want to know that if you could?
That would certainly affect the trajectory, yes.
And you would want to know, if you could, the body posture, whether the person was standing up straight or crouching,
If a collision occurred, yes.
whether they were turning or standing straight, or they had their arm out. That's helpful information, isn't it?
It can be, but when we're talking about how quickly this impact duration is, right? If you recall back to the PowerPoint, right, we're talking about a 10 millisecond window. So however the body is positioned at contact, that's how it's positioned. It's not going to be able to have any significant movement or change in orientation in that 10 millisecond window.
The position of the body can change the trajectory of the person who's hit, can it?
Sorry, can you repeat the question?
Positioning of the body, the way they're positioned, that can change the trajectory if they're hit, after they're hit, can it?
It can, yes.
Whether they're moving towards a vehicle or away from it could affect the trajectory, couldn't it?
If they have some relative velocity, yeah.
Trying to determine the point of impact when you're looking at a scene, it's important when you do trajectory studies to know where the point of impact is, isn't it?
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
If you don't have the point of impact, if you don't know the point of impact, if you don't know the exact body position, that creates variables in your studies, doesn't it?
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection or what's known as like a wrap projection where the pedestrian wraps onto the hood and then becomes decoupled, those studies are applicable there. But when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize those studies.
So you would not want to know where the point of impact is?
In this particular case, no, I don't think it would be helpful.
You would not want to know the body position?
I don't think that it would be helpful in determining, because again, we have to start with, does the damage, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Well, if the evidence indicates that the contact is inconsistent, then that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So
Right.
you don't want to know the body position.
Can you answer that?
I don't understand his question, Your
If
Honor.
there's no car accident, there's no body position. What part of that don't you understand?
When you're doing studies,
Not him, Brennan.
you don't want to know the body position?
Can you answer that, Dr. Wolfe?
Again, it depends on the type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
I was
this.
talking about studies, as far as data, information. You, as the person doing tests, would you want to know the body positioning?
And this time we'll get an answer and that'll be it.
Oh, so 5 times is good. 5 times
Can
the
you answer
charm.
that, Dr. Wolfe?
No.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Assistant
He's so gross.
jurors disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your
That's a
question.
tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please? Now look at force on the bottom. The first letter F signifies force, correct?
Correct.
And the last 2 letters, MA, signifies mass, yes?
Correct.
That's a very important part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can't it?
I'm not sure I understand your question.
Let me make it more simple. When you did these tests,
Let me note down for you, Dr.
you
Wolfe.
chose an arm from a Hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided to choose an arm in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
I don't know that you can have custom-made ATDs.
You probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained in that form.
May I approach?
Yes.
Does he want to beat him with the
So on
arm?
your photograph, is that a photograph of your materials in this case?
Yes,
And in that photograph, it shows the arm that you used in your studies, doesn't it?
correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes,
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
correct, yes.
You didn't put that photograph into PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
I'd like to move this to evidence, please.
Okay. Any objection, Mr. Jackson?
Board's permission, I'd like to show this very
Just give us a minute, let Madam Court Reporter mark it.
Exhibit 217.
Yes, now you can play it.
This is the arm that you used in all of your videos, right?
Correct, yes.
And you can see, could you zoom in, Ms. Gilman, on the weight? 9.38 pounds.
Yes,
There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86, isn't there?
correct, yes.
So when you do the math, and have you done the math before on this? When you do the math, it's 26% difference, isn't it?
In terms of more force?
No, of mass, weight, 26% difference, right?
I'm going to trust you, yeah.
Well, do you have a calculator?
I do.
Can you do it?
Sure.
Okay. And before you do that, you took this from Mr. O'Keefe's 6'1". You used a crash test dummy that, what is the height on it?
Well, the ATD, I believe, is 5'7". The Rescue Randy, I think, is 6 feet tall.
We'll talk about the Rescue Randy later. We have questions about Randy. But let's talk about this. 5'9". You said 5'7". It's actually 5'9".
Sorry, 5'9", yes.
5'9". And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole
He
body.
wasn't 5'9".
Correct.
Okay. So when you do the math and you take the 9.38 pounds based on the 171 pound doll, and you look at the percentage, doesn't it come out to 5.48% total body weight?
Yes.
Okay. And so the difference, when you look at it, it's a 26.3% difference from his actual weight, isn't it?
Correct, yes.
And so I'm probably at the 6th grade level on this, but isn't it very basic that the more something weighs, the slower something has to go to have damage? And if something weighs less, the other part that collides with the force has to go faster?
The force is going to be greater if the mass is greater.
So if you throw a 5-pound rock into a window, you can throw it slower to cause the same damage if you have a 2-pound rock.
I don't know if I agree with that analogy.
So you agree that based on the 26% difference, in order to actually be accurate, to be specific, to be scientific, you then have to adjust the speeds that you presented on the demonstrations, and you have to reduce the speed by 26%.
I don't agree with that.
You don't agree with that. You think that having a lighter arm, so what you're telling us is having a lighter arm will cause the exact same amount of damage to the taillight studies as a heavier arm. Is that what you're telling us?
Well, if you look at, for instance, the 29-mile-an-hour impact test, that's significantly more kinetic energy. So the momentum of a 6,000-pound vehicle moving at 24 miles an hour, 29 miles an hour, that's going to overcome whatever the mass is that it's hitting at that point.
You're sidestepping my question.
Sustained. Ask a question, Mr. Brennan. Just ask a question, no more.
My
comments.
question is, are you telling us that having a lighter arm does not impact the damage in these tests as opposed to using the heavier arm?
Certainly not in the field test, no.
And so you disagree that when you look at the weights of those arms, do you disagree there's a 26.3% difference?
Yes.
You disagree?
No, I'm sorry, what was your question?
Do you agree there was a 26.3% difference in the arm weight that you used opposed to John O'Keefe?
Yes, the hybrid arm compared to Mr. O'Keefe's arm, yes.
Mark?
The arm that he used was lighter, lighter than John O'Keefe's arm.
Right.
And Brennan is blaming him for using a lighter arm. Wouldn't the damage be less under the logic that he's putting forth now? I'm not a science person, but wouldn't the heavier arm getting hit at the speed create more energy, more force, more whatever the hell we're talking about here?
Let's see what Dr. Wolfe has to say about that.
I'm not understanding.
I don't know the answer.
I think he's doing this backwards. If
I mean, he's just saying, why didn't you use, if they make a 12-point arm, 12-pound arm, why wouldn't you use the arm that's closer
but
to
I
the
think
size of John's?
the damage to the taillight would be greater with the 12-pound arm than the 9.3. In other words, if you crash into a stick versus, a heavy log, right? The damage is going to be greater on the log. I think he's got it backwards. The point he's trying to make, I think, makes no sense, I think. I guess you have to see where this goes, but I think he's way out of whack on what he's trying to do.
As usual.
And you are denying that there needs to be an adjustment to your calculation because the mass, MA, is different. You're denying that.
I think, again, if you're, and this is something Dr. Rentschler, I believe, will
No, I want
touch
to talk
on.
to you. I don't want to talk to Dr. Rentschler.
Well, because when you're addressing the forces for injury and the mechanisms for injury, right, you would account for the difference in the weight.
So you're saying that it makes no difference that you use an arm that was 26% lighter. Is that what you're saying to us?
No, I don't think it would have made a significant difference, especially if you look at, for instance, if you're looking at the 95th percentile hand and the 50th percentile hand, they both weigh 1.25 pounds. They're the exact same weight. There's about a pound more roughly in the forearm and a pound more distributed in the upper arm.
But that's not my question. It's not whether it's significant or not. I'm asking you, are you saying under oath right now that a 26.3% difference had no impact on the calculations in that study? It would have no impact at all.
The calculations, yes, but in terms of the damage, no, I don't think that 1 pound difference, when we're talking about something that's 6,000 pounds, striking something that's, quite frankly, whether it's 9.4 or it's 11 something, it's not, you're not going to get a difference in the damage.
So why not just have a 3-pound arm up there?
Well, I think that's unreasonable, sir.
What's that?
I think that's unreasonable.
What's the difference? It's a 6,000-pound car, according to you. What's the difference between 26% and 40%?
Well, I don't even know that I agree with your percentage because, again, you're accounting for the whole part of the arm that goes up to here, which we did not strike that part.
It's, how much lighter? 2 pounds and what? How many ounces?
Sorry, what was your question?
How much lighter is it, the arm that you used?
In terms of a percentage?
No, in terms of weight. The weight. 9.38.
Right.
And Mr. O'Keefe, 11.86, right?
About 2.48.
And you're saying that makes no difference? None.
Not in the observed damage at those speeds, no.
Why didn't you use a 5-pound arm, sir?
I'm sorry, what was your question?
Why didn't you use a 5-pound arm?
Because John
Again,
is not a child.
I don't know that they make a 5-pound ATD arm.
You didn't tell us when you did these studies, you didn't disclose in your PowerPoint that you used an arm that was much lighter than Mr. O'Keefe's arm, did you? Stationary, unlike a person, it affects the aftermath.
Oh, that just skipped ahead for some reason. So let's just go back a little tiny bit.
It's doing us a favor.
Yeah.
Arm is going to get accelerated up to that speed. So that the speed would still, that mass would still be accelerated up to 10 miles per hour. Same thing in the vehicle testing. It's going to be, given that weight difference, it's going to be accelerated up to that speed.
Now, can we see the video of test A, please?
Is he going to drag this out till end of day so that he's got to come stay the weekend?
Yes. And cost them more money. Yes.
Yep.
Now, this is your study, 10 miles per hour, you claim, with a arm that is 9.38 pounds, correct?
Correct.
Mr. O'Keefe, 11.86 pounds, yes?
Yes.
Yes. Okay. Now, this light on the end of this, you're trying to replicate the light on the back of a Lexus?
Correct.
If a Lexus at 6,000 pounds hits a person, the Lexus isn't stopping automatically, is it?
No, it would move at a common velocity with the arm.
It would continue to push forward through the arm, yes?
It may, yes.
And the arm can push into the light before the body turns, yes?
I don't know that I agree with that, no.
If the light on the Lexus, not at this speed, but if the light on the Lexus was broken or breaks and it hits the arm, it's not going to bounce off the arm, it's going to push through, isn't it?
It's going to move at a common velocity with the arm.
And that will move not only the arm, it will move the person's body, won't it?
It may, yes.
It may push the body, it may throw the body.
I don't know about throw.
And the light, if broken, will continue to press against the arm until there's separation. Isn't that fair to say?
It could, in some instances, again, it could bounce.
It could, because it's not always the same. It's dynamic.
He's trying to show that the taillight caused the injuries to the arm without having an expert say it.
The
He
problem,
knows now that he hasn't proven that in his own case in chief.
but the problem is we're getting into speculation. It could be this, it could be that. Sometimes it does this, sometimes it does that. And Brennan, you have the burden of proof. So if we're going to say it could be this, it could be that on a key material fact of the case that you need to prove, you're going to lose.
Could be more reasonable doubt.
That's how it is. So you got to do better than this.
Mm-hmm.
Process, isn't it?
It is dynamic, yes.
You could do the test many times and get very different results, couldn't you?
I don't know that I agree with that.
Would you get the same result every time?
I think you would certainly get similar results.
Every time.
If you had the exact same impact location and speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay, so jurors disregard that exchange between counsel. Next question.
Did you hear the objection? Because I didn't hear what he said.
Yeah, his sniveliness, and then Brennan says it's not. He's arguing with whatever Alan said. Flip that to the other side. What do you think she would say?
Yeah, the exact opposite. Move along. I wanted to hear what Alan said, argumentative. I didn't hear.
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay, so
Objection. It is on Dr. Welcher. No, it's not.
jurors disregard that exchange between counsel. Next question.
Disregard.
If the body position changed, you may get a different result. Isn't that fair to say?
I was going after what Dr. Welcher had represented in his report and analysis. So we did testing to analyze his orientation that he had demonstrated in his report.
You don't like that question either?
Objection.
Sustained.
If the body position changed, it could change the result. True?
That's why they
I
did it
don't know what you
multiple
mean
ways.
by body position. Do you mean the whole body, the arm? What part of the body?
Okay, let's start with the arm. If the arm position changes, it could change the result, couldn't it?
Well, I'm not aware of any other orientation that Dr. Welcher provided in his analysis report as to alternative orientations.
If the arm position changed, could it change the result?
Does Brennan not understand that these tests were done in response to what Welcher did, and he's trying to emulate as best they can his fake science painting experiment where he just kind of leans into the car and they're trying to replicate it? So it's an imperfect thing because look what they're basing it on to disprove it.
Right.
Basically discrediting his own expert by doing this.
100%. But here we are.
I'm sure
Land of
that's
the lost.
correct. He'll mention you did that because you're trying to emulate what the other guy did.
Right.
Yes, I mean, I presume if you don't have your arm on the taillight, then yes, you'll probably get a different result.
What if it's bent in a different way? Could that change the result?
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think. I'm asking you.
You can think.
Just a general question. Over here. If you bend the
Over
arm,
here, he did the same thing. Over here. Over here.
He is so unprofessional, and I don't care how skilled you are, how frustrated you are. You're a scientist. You can think, and then says over here, and she says nothing. She just tolerates this.
Well, because he runs roughshod over her, because what you allow continues, and she just allows it. It's like she has no control over this courtroom. She has no control, except when it comes to the defense, and sustaining all of their objections. It's outrageous. It's just gross.
Dr. Welcher suggested.
you're a scientist, right? You can think. I'm asking you. Just a general question. Over here. If you bend the arm,
Over here.
could it change the result?
It could.
Thank you. Okay.
It's not the experiment
When a
that your guy did with
person-
the blue paint.
A pedestrian is struck, they are not held stationary on a harness, are they?
No.
In this case, the crash test dummy is on a harness,
Yes, he's supported.
strapped
Yes.
by its hips or pelvis.
Yes.
That's not real life. That's not how a pedestrian is usually when they're hit, right? They're not strapped to a harness, are they?
No, and again, the purpose of this test was to evaluate the arm. We're not looking at the whole body here with this test.
And when we talk about injuries, part of injuries is not just the impact, it's the drag, in this case, from the car,
He's
isn't
not
it?
talking about injuries.
It could be, yes.
But when you put the dummy on a harness, restricting or restraining its movement, it is not going to replicate hitting somebody and their movement, including the drag, is it?
Talking about the taillight, Dan,
I don't know.
the way you set it up. I mean, he's got the wrong witness.
Right. And he said a million times, I'm not here to do the injuries. Dr. Rensler is going to do the injuries. I don't even smoke, and it makes me want to have a cigarette right now. People in the chat are like, I haven't smoked in 25 years, and I need a cigarette right now.
I don't know that I agree with that because it will replicate, again, when we're talking about that impact pulse of 10 milliseconds, it will replicate that. And that's ultimately what we're after, is what's happening in that 10 millisecond window in terms of the contact and the damage and the acceleration.
I know that's what you're after. What I'm asking you is when you end it, when the light stops, unlike a Lexus, and the dummy is stationary, unlike a person, it affects the aftermath, the drag and the push after, doesn't it?
Yes, the kinematics would be different, likely, if it's not restrained like that.
In real life, a pedestrian usually is not restrained, are they?
Correct.
In real life, a 6,000-pound Lexus, upon contact with an arm, doesn't usually stop on a dime, does it?
No.
In real life, this case never would have been prosecuted.
Could I have the photo from test A, please? And so there is no break, but there is a crack in this light that was a result of this experiment where this light hits that restrained dummy, yes?
Yes.
And this is at 10 miles per hour in your world and 7.67 if you take off the 26% weight.
Objection.
Sustained as to that form.
we can move to test B, please. Now this test B, a similar test, it has the same limitations, doesn't it? This dummy is restrained at the pelvis.
Yes.
Could you show the video, please? There's two videos. If we could see the first one. And was the dummy restrained by its head as well?
Yes.
Was its arm restrained in any way?
It was tethered, but it was free to move.
This test you have is 17 miles per hour with the arm that's 9.38 pounds. Mr. O'Keefe, 11.86 pound arm. If you consider that 26% difference, wouldn't it be fair to say that this test, rather than replicate 17 miles per hour, would actually replicate 12.6 miles per hour?
Objection, Your Honor.
No, can you answer that?
Not the way it's phrased, no.
And so looking at this test, test B, which you say is 17 miles per hour, can you do a calculation for the 26% difference, or is that something that you don't think is fair?
I don't think that'd be a fair way to characterize it. Again, if no matter what the mass is there, if you're accelerating it, if you're impacting at 17, that arm is going to move at 17.
Well, not just the movement, the damage. If this arm was 5 pounds, do you think the test would have the same exact result?
If it's 5 pounds,
Yes,
probably would be less damage.
it'd be less damage. So to get this amount of damage, you would have to increase the weight, right?
Sorry, what was your question?
To get this amount of damage, you couldn't use a 5 pound arm. There would be less damage with a 5 pound arm.
Correct.
Right, because the less weight you use, the less damage at that speed. That's
Correct.
basically how it works.
Correct.
Okay. So, in this test, if we could run that back again, you have a restrained dummy at the hips and the head. There's no follow-through of the light or the body that's attached to that arm, correct? And at this speed, you can see the shards of taillight. You can see them move, can't you?
When you say move, you mean just
Not stationary.
yeah, I mean they're moving from the taillight as they break.
Detached from the taillight.
Correct, they're broken.
That could create a debris field, yes?
Yes.
And you can see them floating in the air, some of them actually floating and then touching the sweater. Do you see that?
Possibly. Some of it might be, again, some of that polyurethane foam.
Yeah, some might be. And why don't we play it again so we can see clearly? Some might be taillight shards too, right? That black object spinning, that's not poly foam, is it?
No, it would not be.
That'd be taillight shard, right?
Correct.
And so, even at this speed, you can see in this type of collision, there is significant, bless you, significant amount of taillight shards that are broken from the taillight and spewed into the air, yes?
He breaks to say bless you to somebody in the courtroom that sneezes, but he badgers the witness like there's no tomorrow. Make it make sense.
Well, I think on the one of the slides I had, I think I showed the fragments that were left, and from what I recall, I think there was 4 pieces from the taillight, from the lens.
If you could put that back a little so Dr. Wolfe can see it again, to the point of the collision. Even at this speed, go ahead. Stop. You can see pieces, large, small, medium, maybe even microscopic, are now breaking off from that taillight and being littered into the air, aren't they?
Yes, there are pieces coming off.
Say what?
If it's microscopic, you can't see it, right? Isn't that the whole point? Needing a microscope, but whatever.
He wants to get back to the microscopic pieces in the clothing, but there's no damage to the clothing, so.
Another problem.
If we can go to test C, please. Use only an arm. Now, in test C, you actually use only an arm. Isn't that fair to say?
Correct.
You don't use a body or a crash test dummy.
No.
You don't, in fact, this is not the 12-pound arm either. This is the 9.38-pound arm.
Correct.
And when you do this test, you have the arm, it's basically just an object suspended in the air, isn't it?
Yes.
And you said, I think on direct examination, I think you said that this is the same as if it was on the dummy. Is that your testimony?
Well, in terms of, again, the amount of weight that would be interacting with the taillight, whether it's attached to the dummy or not, what's in direct contact is going to be the same.
Well, the fact that it's just floating up in the sky like that, it's very different than if it was attached to a person or a dummy, isn't it?
In terms of how it moves immediately after the impact, yes.
Not just how it moves, as far as the impact. Isn't it different?
I don't know that I agree with that.
Okay. Well, wouldn't you say that in addition to the arm, if you had another 200 plus pounds being held down by gravity, that would affect the force that's acting on the arm?
Well, the arm, again, is going to be accelerated, but the center of mass of the body is not going to see that acceleration.
Have you testified before in this case about the importance of the full body and gravity?
I'm sorry, what was your question?
Have you testified before in this case about the effect of gravity and the full force of a body as opposed to just an arm?
Yes.
Okay. And do you remember whether you thought it important on a previous time you testified that there was significance to the arm would be attached to a 200 plus pound body and there was the issue of gravity that would affect force?
From what I recall, I think that had to deal with whether or not the pedestrian would be projected based upon an interaction with the arm or a full-on center of gravity hit, right? When we're only hitting the arm, we're not hitting the CG of the body.
You did test B, and you claim it was at 17 miles per hour, test B.
Correct.
And we saw the damage. This is at 15 miles per hour, test C. Could you play this, please? It might be a delay, so you could fast forward a little bit, please. Okay. How many times do you think that arm spun around?
I don't know.
That's not what would happen to a person who got hit. Their arm wouldn't spin through their body like that, would it?
Correct, it
Their
would
arm
not.
wouldn't spin that many times.
No.
There'd be the pull of their body weight, yes?
I'm sorry, what was your
There'd be
question?
the pull of their body weight,
The body weight, yeah, would affect the movement afterwards, yes.
gravity, yes?
Yes.
Yeah. And so there's a reason why you do this test at 15 miles per hour. Is there a photo related to this, to the damage to the taillight? There is a reason why at 15 miles per hour the damage is much different than the other test at 17 miles per hour, isn't there?
Correct.
Right, because at 17 miles per hour you have a dummy that is strapped by a harness in its pelvis, and when it's hitting the arm, it's affecting it much differently than just a arm floating in air. Yes?
No, I don't agree with that. The primary reason there's a difference in the damage is because of the amount of the arm that's outstretched and interacting with the taillights. There's a difference in those two tests.
Mm-hmm. And so the body and the weight of the body, you're saying, has nothing to do with the amount of damage.
Not in these tests, no.
So when somebody gets hit, does the body weight have anything to do with the damage? Not just the area that gets hit. Does the body weight affect it at all?
Not in terms of the impact, like the rest of the body, it's not going to matter if, for instance, only my hand, like in that last test we just saw, it was the hand and the wrist, how much my stomach weighs, my head weighs, is not going to affect the damage to that taillight and that interaction.
And by the way, this test, you said 15 miles per hour. If you consider the 26%, you're only at 11.1 miles per hour. Is that the right math?
Again, I don't agree with that because if you look at the data and you integrate the acceleration data to get the speed, right, that we saw in those plots, the hand basically gets up to, I think it was 14 or 15 miles an hour. It reaches that common velocity of the vehicle.
Let's go to test F. On test F, you placed the dummy more behind the vehicle, didn't you?
Correct.
And when you test and you put it more behind the vehicle, this is more of a full impact than it is a clipping, isn't it?
Certainly, yes.
And when you put this dummy behind the car, this was not a legitimate crash test dummy. It was a different type of dummy, wasn't it?
Yes, it's called a Rescue Randy.
A Rescue Randy. And that is not typically the type of dummy that you're going to use for crash tests, is it?
I wouldn't agree with that.
When you did the Rescue Randy and crash test F, did you use the 12-pound arm or did you stick with the 9.38?
The hybrid arm wasn't attached to the Rescue Randy. And
The hybrid arm was not. Is that what you said, or it was?
it was not. No, not in the full impact test.
Okay, so what was the weight of the arm on the Rescue Randy?
I don't know specifically the weight of the arm. I know that the total mass of the Rescue Randy was 200 pounds.
Isn't the weight of the arm important when you're talking about impact with the arm?
I don't think relative to the rest of the mass of the body.
So now the mass of the body counts, but before it didn't.
Sustained enough.
Okay. If we can see in test F, we have some photographs. Start with the first one, if you could widen that, please. Now, this is a direct hit.
Correct.
Is this simply a photo or a video? Could we go to the next one, please? So the Rescue Randy's placed much further in the car than the other type of test that would be more similar to a clip, yes?
Correct.
Next photo, please. Okay. And that is the result of the impact?
Correct.
Do you see the debris field?
Yes.
Is it near Rescue Randy?
Some of it is, yes.
Yeah, it's spread out a little bit, yes?
Do you see that Rescue Randy's leg has been like completely twisted around? It was like hanging off by a thread.
He also went straight backwards. Like he just got launched backwards, not into the yard. But yeah, that
Compound fracture. I mean, his bone is practically sticking out, his fake bone. I mean, come on, man.
You know what Rescue Randy looks like? If you watch Family Guy, every time somebody gets hurt, they end up looking like that with their leg aside.
Right. Poor Rescue Randy, he needs some meds.
That's fair, yes.
But it's not right on his body. It's a distance from his body, yes?
Break that.
There may be some, I can't tell from this photo, there may be some around his body, but
Right, so he would, according to this, he'd be in the street. His body would never have made it to the lawn. It would have been on the street. Debris field.
yes, there's also debris close to the Lexus as well.
Arms are all
And,
broken.
and this is the demonstration where you didn't turn on the videotape, so we don't have a videotape.
Correct, we had the false start, yep.
What's that?
We had the false start.
The false start. Is there another picture after this? Those clothes. Are there holes or tears in the clothes?
Yes, there's damage that's consistent with road rash when clothing or a body makes contact with the pavement and is grinding into the pavement.
Pavement's hard.
Yes.
How about frozen ground?
Hard as the
Frozen
ground.
dirt.
Is that hard?
Yeah.
I suppose it can be.
Well, do you have any doubt whether frozen ground in the
Science is
Northeast
hard.
in the winter is hard? Hard as a rock?
I haven't done any analysis to assess that.
And so seeing holes in those clothes is what you would expect after Randy hits that hard ground, right?
We're really going to call him Randy, aren't we? We're just
Look at all the dirt. There was no dirt around those bite marks on the sweatshirt. Can we just point that out?
look at the size of the holes and the I mean,
This is if John O'Keefe was dragged along, God forbid, the roadway with, more than with no snow on it, because there's no snow here and not enough snow to track a cat even.
Are you talking about frozen grass or paved?
I'm talking about Randy right now. These holes in the clothes are what you would expect after Randy hits the hard ground, correct?
I'm going to allow that. Is that what you'd expect?
Or-
All right, jurors, feel free to stand up and stretch.
Please, 7th inning stretch. We need a shirt. I'm talking about Randy right now.
I'm talking about Randy.
By the way, isn't he like palm up? So that's the inside of his sweatshirt.
Randy,
not the outside.
Randy may be this trial's, White Claw. And the first trial was kind of White Claw. Randy may be the buzzword.
So holes in the clothes is what you would expect after Randy hits the ground, yes?
If there is prolonged sliding contact with the asphalt, certainly you could expect to see tearing, large holes, material fraying, and even transfer of pavement material onto the clothing.
You've done no studies on hard ground like a front yard, have you?
In terms of a pedestrian sliding on the grass?
In clothing tears, yes.
No, sir.
Try not to
And if you
laugh.
could
Look
go
at him.
back one slide.
He's trying so hard. Keep
You
it
see
together,
the debris
Dan.
field is near but not on, Randy?
Randy was supposed to
Can you tell if there's any small pieces or microscopic pieces?
Randy just got done.
Can you tell us
Hearing
whether?
in a Monty Python movie.
Can you
It's
tell us?
only a flesh wound. I'm still here. I'm still here.
Could you tell us whether Randy was married or what his educational background?
Randy is mangled. Can we just say for what it is? Randy is actually mangled. You can't even make this up.
It really is like Monty Python.
It's
Pite?
waiting for the knight to come out with a shrubbery and a sword.
But you've got no heart to know that.
Right. Yeah, 'tis only a flesh wound. Randy, you can't get me. Oh, okay. Say his name.
On or in Randy's clothes in the study, did you look?
No.
Bless you.
Thank you.
If I could go to test E, please.
Somebody wrote in the chat. Even Randy is free Karen Read.
Test E, you cite as having
Do we have Randy's
a speed
CV?
of 24 miles per hour, correct?
Can we
Correct.
get
And that's with a arm that is not
Deb to make a Randy song? A Randy.
Okay.
We need a Randy song.
We do need a Randy song.
9.38 pounds. Yes?
Correct.
And to remind you, Mr. O'Keefe's arm would be about 11.86 pounds. Yes?
Randy still has his
Correct.
shoes on.
If you would reduce 26%, you'd be at 17.8 miles per hour, wouldn't you?
Objection.
Are you doing the math, Dr. Wolfe?
I don't agree with his characterization, Your
Okay,
Honor.
next question.
I understand you don't agree, but if you took 26% off the 24 miles per hour, you would come out to 17.8 miles per
I
hour.
agree.
wouldn't you?
I'm going to allow that.
Was Randy with Bella's mom? Randy called in sick the next day. Somebody get Randy a wheelchair. The comments, you guys are amazing, amazing.
I'm going to allow that.
Oh wait,
That's what the calculation would yield.
Okay.
oh, I gotta hear that again.
I don't agree, but if you took 26% off the 24 miles per hour, you would come out to 17.8 miles per hour, wouldn't you?
I'm going to allow that. I'm going to allow that.
That's what the calculation would yield.
Okay. On test E, there are some differences between your test and what would happen in real life. For example, there is a harness, correct?
Correct.
And the harness prevents the dummy from being thrown naturally.
Correct.
I mean, naturally.
The harness affects your ability or one's ability to see the study and see what the trajectory would be after impact, correct?
Well, that wasn't the purpose of the study, to assess the trajectory, sir.
I understand. I'm not trying to criticize, but it affects the ability to see the trajectory when the dummy's on a harness, doesn't it?
Yes.
Could we put up the first video on this, please? A photo 115, if we can start with.
At what point does Randy's head pop off? I mean, Randy keeps it takes a beating and keeps on ticking.
If you could stop it right there. And you can see the feet aren't as firmly planted on the ground as a person would be in most circumstances because of that harness, yes?
Randy's gonna
Correct.
meet.
And that affects gravity, doesn't it?
Affects gravity?
Well, when the car hits, the gravity, the weight of the dummy is less because it's held up by a harness, isn't it?
Now,
Right.
Randy's
So gravity really is, again, it's suspended at this point. Just
How could you be suspended at this point? What did you say, Mark?
how could you call Randy a dummy? That's not nice.
No, it's really not. He's very disparaging towards the crash test dummy. Randy was seen at the seaport having dinner with Karen. Road rash Randy. Oh, the chat's getting a little Randy. The chat
Randy
is
was
getting a little
Randy was
Randy.
spotted in the buffer zone.
Oh my
No.
God. Randy needs to be wrapped in bubble wrap.
I can be
above the ground.
The arm that's extended, is there a glass in that hand?
No, there's not more weight in the hand.
Randy
So
couldn't
there's
hold
no
a glass.
object in the hand in any of these tests?
No, because ultimately what would happen is because of the accelerometer being mounted on the palm of the hand, if you had a glass there, it would interfere with those measurements.
I understand why you didn't do it, but would you say it's fair to say that if a glass was in the dummy's hand on these tests, it could affect or change the damage?
Well, if you add another, I think that the drinking glass we utilized for the testing last year, I think was 0.7 pounds. So if you add another 0.7 or pound to the hand, that hand contacts the liftgate taillight, you certainly could see damage to that taillight, which we certainly didn't see on the subject vehicle.
So weight does kind of matter, right?
It can, yes.
Not just 0.7 pounds, the 2.5 pounds can matter too. Weight matters.
Yes.
Because that's kind of what we were talking about for the last half hour. Weight matters in these tests, doesn't it?
Correct, but you can't look at this in isolation just between damage, and you can't separate it from the injuries, right? What's going to happen to the body in terms of the injuries in a 24-mile-an-hour impact?
Does weight matter?
In terms of the force?
Size matters.
And so we see this dummy with the arm stretched out.
I'll be here all next
correct?
week.
Correct.
Okay, can we bring this back?
Randy kept his shoes on. And Randy would not lie on his
Stop
CD.
right there. This isn't approved crash test dummy, is it?
The Rescue Randy portion, no. It's not instrumented like a hybrid.
Is the arm the hybrid 3?
Yes, the arm is the hybrid 3.
So you took, in test F, you didn't put the hybrid 3 on the Randy, but on this one you did?
No, because you risk these AT devices can range from $100,000 to $150,000, and you run the risk of destroying that equipment in a test like that.
So in test F, did you put the hybrid on the Randy, or did you keep Randy's original arm?
It's just the Rescue Randy in the last test.
On F.
I'm
Correct.
totally bringing
This
Randy
one,
to Cancun with me.
You
next
have the
year.
hybrid arm on Randy.
Correct.
So you're switching up between tests, what pieces you're using, aren't you?
At least he did some tests.
I would say adding, but
Well, adding and subtracting. It doesn't have two arms. There's one off, one on. One's Randy and one's hybrid. So you're switching.
yes.
Different result.
I'm not sure I understand your question.
Okay.
Are you trying to say a different result between test F and this test? Because they're not the same test.
Oh, I understand. I understand. If we can have this come back a
Turtle
little
Boy and Randy living rent free in Hank's Head.
bit more. Okay, and let it run. Stop. You can see the shattered taillight moving, and most of it's moving in the same direction, isn't it?
Yes.
And that's what creates a debris field after a collision, doesn't it?
Yes, I mean, components will break off and fall to the ground, yes.
Now, since Randy is on a harness, he's not going to be thrown the same way as it would happen in real life, is he?
Correct, and that wasn't the purpose of this
I
test, sir.
understand. When you chose 24 miles per hour without the 26% deduction, which would make it 17.8 miles per hour. When you chose 24 miles per hour, it's because you had looked at the text stream data that had been taken from the defendant's Lexus, right?
Correct.
And when you looked at that data, you understood that during that event, 10 seconds of data is captured, yes?
Yes.
But that doesn't define the whole event, does it?
That only encompasses what was recorded.
And you said you chose 24 miles per hour because that was about the speed at the end of that 10 seconds.
Correct.
You do realize at the end of that 10 seconds, the car, the defendant's Lexus, was going faster. It was still accelerating, don't you?
Objection.
I'm going to allow it.
From what I recall, the last data point, I believe the throttle was still around 74%.
Well, ARCCA specializes in text stream data, don't they?
Yes.
Okay. So you are looking at that, you would agree that at the end of the 10 seconds, the defendant's Lexus was increasing in speed.
Well, we don't know, again, beyond that data point, what the data is.
At the end of that 10 seconds, the car was going up, not down, in speed, yes?
Correct.
And you can't tell how much longer that car traveled for after that 10 seconds, can you?
Correct. We don't know.
So when you chose the 24 miles per hour, it was just based on a data point. It wasn't based on you believing that there was an impact at a certain speed, was it?
No, and the triggering event itself it's not a collision by definition, and nowhere in that data can you parse out whether or not any contact even occurred.
We know that.
Okay.
The point is,
We do. It's like Weekend at Bernie's. I need a wellness check on the jury. Wellness check on the jury, please. Clean up on aisle 3 and free my boy Randy Tibbetts. Where's
you
Ashton
can't
Kutcher?
tell how fast the vehicle was going if it was in a collision from that data, can you?
Does Randy know that?
Sorry, can you repeat the question?
If that vehicle was in a collision, you wouldn't be able to tell from that data what the speed was at the time of the collision.
If contact allegedly occurred at some point in that data set, no, you would not be able to pick a row in that data and say, this is where the collision occurred.
Or after that data set, you would have no idea.
Outside of the data?
Yes.
No.
Okay. And so when you look at this experiment that you did, if you were to add, you said 24 miles per hour, but that's not considering the 26%. If you were to add 7 more miles per hour to this collision, would you expect more damage to that right taillight?
Potentially, yes, but you're certainly getting into the realm of injury at that point.
I'm not asking about that. I'm asking you a simple question about damage. If you were to add 7 miles per hour on
You didn't like that answer, Mr. Brennan?
No.
You didn't like that question? You didn't like that answer?
to this test here, would you expect more damage to that right rear taillight?
Yes.
Okay, can you finish the video? Okay, now I want to ask you some questions. You can stop there. I want to ask you some questions. Can you bring it back to right before the collision, please?
Oh, I bet. How do you think Larry is like
Speed
trying not to
changes
bust
the
out
result
laughing?
of this, doesn't it?
In terms of the impact speed?
Yes, the impact speed can change the result of this, of the damage to the right rear taillight, can it?
Correct.
And the angle of the arm can change the damage to that right rear taillight, can't it?
It can, yes.
Did you take any pictures of the debris field after the impact and damage in this test E? Did you take any photographs of the debris field?
I believe so, yes.
Was it included in your materials that you provided us?
It should have been in all of the test materials that was provided, yes.
Was the debris field within a certain range? Was it within a certain circle, 10, 20, 30 feet?
That sounds about right.
And so a debris field, although it might scatter, it almost forms kind of a ring, doesn't it?
It can, yes.
And it can form that ring away from where the body lands, can't it?
It can, yes.
And in this test, which you say is 24 miles per hour, without the reduction to 17.8 miles per hour, in this test, upon impact, there is a number of pieces of taillight that shatter, isn't there?
Yes.
Did you count how many?
About 19 pieces.
19 pieces. Could you move forward just a little bit? And when they break and scatter, some of them go up, some go down. Stop, please. Yes?
Correct, yes.
Some of them come in contact with Randy's arm. Yes?
Correct.
Now, Randy being on a harness, it's not like real life when the Lexus goes by, could continue to push him with it, right? He can't go with the car or the Lexus because he's on a harness. Yes?
Correct. He's not going to move from that position.
If you can move forward, do you see Randy's feet?
Yes.
See the right foot?
Yes.
It's twisting, right?
Correct.
Turning. Stop. Could you show the photo of the sneaker, please? When you were reaching your conclusions that you offered to the jury today, did you consider this photograph?
No.
Did you know
Sneaker inverted with
that
black
this
sole,
sneaker
maybe.
was up against a curb in the area,
Yes.
and you didn't consider this at all?
Wasn't a part of my analysis.
Okay. You can go back to the video.
I wish you would say the FBI didn't give it to me.
You see the spin and rotation on the foot?
Yes.
Can you keep going?
Rescue
And the
Randy's on
turn
a
of the
leash.
sneaker?
Yes.
Yeah, and its foot would have been run over by that tire. Yeah, look, its foot would have been crushed. Hello.
Okay. I want you to go back, Ms. Gilman, please, to the point of impact. In your studies, you would agree there can be a clip of a pedestrian that causes significant damage to a taillight where the pedestrian incurs no lower body injuries whatsoever. That can happen, can it?
Well, I don't know that I would describe this as a clip to the arm. This is a full-on impact to the arm, so it's not a clip. Again, you saw at the 15 miles per hour. I think that's more analogous to a clip or a side swipe where the arm just kind of gets brushed out of the way. This, I would say, is a full-on impact to the arm.
Okay. To use your words, in a full-on impact like this, a pedestrian could be involved in a full-on impact causing that amount of damage to the taillight that's reflected in this video, but suffer no lower body injuries. Isn't that fair to say?
I don't address injuries, sir.
Well, let's play it forward. Do we ever see Randy's knees hit the car? Hips? Ribs?
Happening to his legs.
I see the foot getting run over, but
Randy
I
lost
don't see.
a foot
I don't
and
think there was contact
I
with the legs. No.
destroyed.
They're going to use ARCCA's experiment to prove his theory. Oh.
I do believe Randy's pirouetting though. So Randy does kind of look like Chupa Paul. Maybe they're brothers. Who knows?
No.
Would you agree that a pedestrian could be in this type of collision and suffer no lower body injuries based on
No.
your presentation here?
Sir, I don't address injuries. Biomechanics is not my area of specialty.
You said it's common in vehicle-pedestrian collisions that there is some type of bumper displacement. Have you
Correct.
said that?
Yes.
Okay, bring it back to the beginning, please. Stop.
Who got
Any
hit?
bumper displacement in this collision?
In this specific test, no.
His shoe got run over.
You said
Still
that
got run over, but
on
his shoes stayed
direct,
on.
you would expect that there would be some panel deformation. What does that mean?
So if for instance, let's say the hand is not contact.
Did you say defamation? Panel defamation. How dare you defame that panel? I'm going to sue you.
God.
Panel deformation?
Oh,
What does that
defamation.
mean?
All right, forget it.
So if for instance, let's say the hand is not contacting the taillight or a portion of it is contacting the lift gate, you could see deformation to that body paneling.
You said that you would expect to see, not that you could. What you said on direct is you would expect to see panel deformation.
Yes.
And you said in this case, there was none, right? Talking about the defendant's Lexus. You said, I would expect to see panel deformation, and in this case, the defendant's Lexus, there was none. That's what you told us on direct.
Correct.
Let's watch let's watch your video. Play it ahead. Is there any panel deformation, stop, in this?
No, sir.
Okay. So when you said on direct examination, relative to the defendant's Lexus, you would expect panel deformation, there was none. There are examples, one that you gave us yourself, where there is a collision causing this amount of damage to a taillight where there's no panel deformation,
I'm going to allow it.
right?
If I recall, I think you're referring to my prior testimony in another proceeding where I had not conducted this testing yet. So ultimately, that's part of the reason why this testing was conducted, to evaluate that.
In this case, the damage to the right rear taillight, there's no panel deformation here, is there?
Correct, there's not.
When somebody is wearing a hat and they're involved in a collision similar to this,
Oh,
can their hat fall off?
Randy didn't wear a hat, so the science is no longer valid.
Yeah.
Potentially.
Did you look at photos? Was there a photo of the hat, Ms. Gilman?
See, Welcher put a hat on and dressed up like John, so that mattered.
Yeah, it's a way
Before you
better. He
came
did a
to
way
your
better
opinions and
experiment.
conclusions, did you look at this photo and see a hat on the grass?
I did review this, yes.
And did you give any consideration when you did your tests to whether the hat would come off Randy or any crash test dummy when you hit it at that speed?
No, that wasn't a part of my evaluation.
Could I have photo 77, please?
He's mentioned Randy more times in this trial than he's mentioned John O'Keefe, by the way.
What's that, sir?
So I don't know if you'll be able to see it in the photograph, but there was some material transfer from the jeans that the Rescue Randy was wearing.
And so as a result of that impact, there was scuffing from Randy's jeans onto this exemplar Lexus.
There was scuffing, yes.
Did you look at the defendant's photos of the defendant's Lexus to see
Yes.
if there was
Sorry.
it's okay, to see if there was any scuffing in a very similar area?
I don't recall it being at that portion of the vehicle close to the rear wheel.
Where did you see the scuffing on the defendant's Lexus?
I think there was some scrapes along the wraparound section of the bumper cover.
The bottom part?
Correct.
Sorry, Renee.
It's not claimed that's attributed to the collision, so I don't want you to consider that.
Right, because
But
Randy
did you
was
see
the only
other
one
scuffs
struck by a
a little
Lexus.
higher up on the
Thank
Lexus?
you, Sarah.
I did, but I don't know that those could certainly just be normal wear and tear to the vehicle.
Is that normal wear and tear?
This, no, because we observed it in the test.
Could I have photo 153,
Rescue
please?
Randy is tweeting?
Hmm?
Did you know Rescue Randy has a Twitter account and is tweeting?
That's insane. We have a couple of Rescue Randys in the chat, too. People have already changed their name. One said, changed his or her name to Rescue Randy and said, I'm alive, all caps.
Now, this is a photo without the hatch back up. This is just the lighting fixture, right?
Correct.
And could you close up in on that? And you would agree if you went 7 miles per hour faster, it would cause more damage to that, wouldn't it?
Yes.
When the taillight is shattered and it spreads through the air, does it have the potential to impale a person, for example, on their nose?
What?
I'm sorry, can you repeat the question?
In your test, you saw that upon collision, there was a scattering of taillight that broke from the fixture, correct?
Correct.
Would those shards, as they float or fly through the air, would they have the ability to impale a person on their face or even their nose?
I think that would be unlikely.
Because Karen said she picked a piece of glass out of John's nose. It wasn't plastic. This is acrylic.
And finally, we've discussed, you now would agree with me that weight does matter, doesn't it?
It can if it's significant, yes.
I have no further questions.
All right, Mr. Jackson?
Oh, Jackson's going to try and get him out of here for the weekend. There's a juror that has to leave in 5 minutes.
Oh, yeah, that's right.
Just a little tiny bit behind.
Yes.
PowerPoint, Wolfe, go back. Can we, Dr. Wolfe, go back to your do you have your PowerPoint
Yes.
set up?
Your Honor, may I?
Yes.
He's good manners. Asks the judge's permission. We don't know that he was holding the glass. This is all made up nonsense.
Forward, and I don't. You have that ready?
Yes.
Can you go forward? And I don't have them memorized, so bear with me. Can you go forward to test E? And I'm going to ask you a couple of quick questions.
Randy's going out after this. Going to hit the waterfall.
Okay, if
See
you
if
could scroll
McCarthy's-
through,
Maybe
keep
go
going.
intimidate a window or two.
please, to the next slide, the next. Can you, is this a video or is this a still photograph?
It is a video.
Is this at full speed or is this slow?
This is full speed.
Okay, can you go to the next slide? Okay, go back one. This is a test at what speed?
This is the Lexus moving in reverse, contacting at 24 miles an hour.
All right. Let's go ahead and play this at full speed if we could.
How many people are dressing up like Randy for Halloween this year? Kelly Mack is. Rescue Randy's got more game than Higgy, somebody said.
Dr. Wolfe, can you, that's awfully fast. Can you
Try
get
to-
to a point where you're moving frame by frame just at the point of contact?
Step by step. Inch by inch. Randy's been rehomed.
Am I able to display my screen without doing the... Trying to see how I can get this to work.
Frame rather than,
All right, we're just going to try and move towards
it may be
real
more
time.
difficult than we thought. Let me ask you a couple of questions.
Sure.
Based on that. Did you,
It's Mark's dog.
review
There's no dog in that.
that video?
That's Winnie. She's had
in slow
enough.
motion as
Rescue
well
Randy.
as at full speed?
Yes, from a frame-by-frame perspective.
And in terms of a couple of different questions about that particular test, when there's impact with that right arm, what's the speed that the arm gets to upon impact?
In test E,
Right. If the car's going 24 miles an hour, what's the expected speed of the arm?
so the hand got up to a little over 24, the arm got a little over 21 miles per hour.
The debris that comes off of the taillight, the fragments, what speed would they be going at the point of impact when they crack and are released from the taillight?
At the impact speed or less.
In order to penetrate the sweatshirt and cut the arm across, would the shards have to be going faster or slower than the arm?
They would have to be going faster. If they're moving at a common velocity with the arm relative to it, they would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
I also want to ask you about do you have in your PowerPoint the photographs of the sweatshirt at the what you call the full-on impact, test F, as in Foxtrot?
I don't have any of those in the PowerPoint.
Okay. The photo that you were shown, if I could ask Ms. Gilman to show the same photograph that she showed earlier of the subsequent to test F, as in Foxtrot, with the holes in the sleeve.
If she can.
If she can.
Can you do that, Ms. Gilman?
Very kind.
Thank you.
Dr. Wolfe, you're shown just the left arm underneath the, whatever you call the dummy, Randy, right?
Yes.
Hey, show Randy some respect.
Did Mr. Brennan show you the rest of the sweatshirt?
No.
What did the rest of the sweatshirt look like after this full-on impact when he was launched on the asphalt?
Mangled. So there was not only significant road rash to the clothing all over the torso section, the left arm, the right arm. There was holes in many different locations of various sizes. There was also just on the skin of the dummy, there was road rash on the face had been scraped. The torso had been scraped. So there was significant body damage to the torso as well.
Taking just the sweatshirt.
And that's Randy's
separating
left
that
arm.
out, what about the bodice of the sweatshirt, the front of the sweatshirt? Were there holes and frays and damage to the front?
It was covered in all of those, yes.
What about the back of the sweatshirt? Did that also have damage?
I don't believe the back, because I think he fell onto his stomach.
What about the other arm?
Yes, both arms did.
Randy's hot.
Were the holes and frays larger than the holes, the puncture holes that you saw on John O'Keefe's sweatshirt?
Certainly larger and again spread out amongst the entirety of the sweatshirt, at least on the front side.
Was the damage to the sweatshirt that you saw in this experiment consistent with the damage or defects that you saw in just the right arm, those 9 puncture holes on the right arm of the sweatshirt of John O'Keefe?
No, this is distinctly road rash. There's a clear distinction between the two.
Looking at this particular set of defects in the arm, is that misleading in terms of its comparison to John O'Keefe's sweatshirt?
Sustain.
I get knocked down. Let's pick it up again. 30 on the playlist. Tub thumping by Chumbawamba. Damage to the car, though.
Your Honor, I'm going to ask to approach very briefly on an issue that we discussed earlier.
I mean, you know Brennan's going to be like, I need some more questions, and he's going to have to come back on Monday.
Yeah, he's coming back. It's already after 3:45.
That juror's got to go, and, you know, they got to...
On behalf of,
Yes.
you were asked on cross-examination about some of the work that ARCCA does on behalf of private lawyers, even insurance companies, correct?
Yes.
Correct.
You were not hired by an insurance company. That's not who hired you on behalf of Ms. Reed or
Praise
anything
be.
like that in the initial hire, correct?
Correct. It was not an insurance company.
Thank you.
Thank you.
A couple of more questions, if it's okay with the court, Your Honor, before we break.
Okay.
Thank you.
That was good to get that in.
You were asked several questions about the glass and whether or not the glass weighed in on your analysis of the damage to the rear tail light, correct?
Correct.
did you consider that the glass on the rear bumper did not match the cocktail glass that was found close to John O'Keefe's body? Or were you aware of that?
I don't think initially I was aware that there was a difference between the glass cup that was found and the glass on the bumper.
Oh. Now we know they don't match. It's not a match.
You were asked a lot of questions about the difference in the weight of the arm, and I'm going by memory, 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Have I got that right?
Approximately, yes.
Okay. Are you aware that anybody has ever measured the weight of just John O'Keefe's right arm?
I'm not aware of that, no.
When you were asked questions about whether or not his arm weighed 11.8 pounds, are you aware of anybody ever weighing just his arm?
No.
What is that based on? 11.8, where'd that come from?
I don't know.
Mr. Brennan mentioned the word statistic. Based on the statistics, his arm would weigh that much. Height, weight, etc.
Correct.
Does a statistic determine the actual weight of an arm?
No, not conclusive to what Mr. O'Keefe's arm weighed, no.
As you sit here, do you know whether his arm, John O'Keefe's right arm, if weighed by itself accurately, because pounds and apparently half pounds matter, if it weighed 11.8 pounds or if it weighed 9.4 pounds? Do you know?
I don't know, no.
Do you believe that your testing, the totality of your testing, was dependent upon those 2.5 pounds based on the weight of the hybrid 3, or at least the arm of hybrid 3, and the statistic of 11.8 pounds?
Sustained.
In what way does that differentiation of 2.5 pounds or approximately 2.5 pounds, in what way does that make a difference in terms of your testing?
It doesn't, and that's part of the reason why we increase the speeds to almost 30 miles an hour to look at, again, when you're bringing that much more kinetic energy from the vehicle, that's going to overcome any mass that arm has. If it, like I said, if it's a pound difference, 2 pound difference, the momentum of that vehicle moving at 30 miles an hour versus 24 miles an hour, again, kinetic energy is equal to 1/2 times the mass times the velocity squared. So even if you go up a few miles per hour, you're exponentially increasing that amount of kinetic energy from the vehicle.
That's a good answer.
You were also asked a series of questions about reducing the speed of the testing by a certain percentage. Remember those questions?
Yes.
Did that make any sense to you mathematically? Okay.
Sustained in that form.
What effect, if you can tell us, well, let me ask it this way. Is the speed of the testing vehicle tethered in some way to the difference of that 2.5 pounds that Mr. Brennan was asking you about?
No, and again, as you saw throughout the PowerPoint, when that vehicle is coming in at 24 miles an hour, 29 miles an hour, at those speeds, that arm, when it makes contact, is going to get accelerated up to that velocity. It's just going to reach that common velocity. It's not going to, you're not going to somehow affect the vehicle speed due to that, the fact that the arm weighing 10 pounds roughly, and you've got 6,000 pounds. It's not going to somehow scrub off speed of the vehile.
Thank you. Your Honor, at this point, I would be going through a couple of photographs and videos that might be a good place to.
Okay, I understand you said it's on. So we'll start today. Dr. Wolfe, you have to come on today. All right, jurors.
He has to come back.
One question I have for you. So I know a long time ago we told you that Thursday would be a half a day. I'm told that we're nearing the end of this case, so I'd like you to think about whether you're able to stay all day next Thursday. Think about it over the weekend. If you've made appointments or anything like that, I'm not asking you. But think about it, and on Monday, if you let Tony or Paul, whoever's with you Monday, if you have an issue with it. Just
You're preparing.
all right, so please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it, let us know, and again, be very careful with your social media use. Have a great weekend. Thank you.
All rise to the court, please.
Nobody docks Randy on socials. Thank you. Let's see if they come back. Probably not, but we're a little bit behind. Well, Mark, wait, let's see if they're coming back. Thoughts, questions, comments, concerns?
I don't know where the DA goes. I mean, they need to knock these witnesses out. They can't be even possibly accurate in the sense that the jury believes that Dr. Wolfe could be right, which would mean maybe there wasn't a car accident. I mean, it's really basic connecting the dots. And, you know, Brennan's cross, it felt like the same again with Dr. Russell. It was snarky for no reason. More than snarky, it was pissy. He was pissy. He was snivelly. And I don't think it resonated well. The witness stayed calm, cool, collected. I don't know what Brennan established other than apparently John O'Keefe's arm was 1.5 pounds more than not Randy, the crash test dummy arm, and Randy, I guess, both of them. The expert said that that's not going to matter for the testing that we're doing. So what did he get? I mean, he didn't get him to back away from anything that matters. And frankly, I think the redirect, again, was very good in establishing that he might have been fast and loose on cross by suggesting that the direct impact made the hoodie covered in holes and whatnot, but he didn't show the other part, which apparently was even worse and entirely not consistent with what, you know, a hoodie would look like, John O'Keefe's hoodie, for example, in the impact. I guess he's trying to show that you undersold the speed, the velocity, and that therefore you should have gone higher and maybe there would have been more glass or more taillight. But based on what? Based on speculation. And that's the whole problem with the prosecution case. He doesn't know that. I don't think you're going to get that from Welcher. And I think the real takeaway is you have these witnesses are actually scientific, using the scientific method, doing all kinds of testing. They have, in many ways, exposed Welcher as just kind of a hired gun who's overpaid and who did nothing other than say 2 miles an hour. I'd say in trouble.
All it's going to take is for one juror to believe that that arm broke that tail light, and it's another hung jury.
But I think you're going to get 12 jurors who are going to with the injuries.
Yeah, I mean, it's going to have to be brought together with the injury component of it. That if it happened this way and it broke the taillight, the arm would have been shattered. And I mean, they didn't get to hear that today, so that is still going to be.
It's really bad because, you know, Rentschler presumably will say that, but even beyond that, I don't think you need an expert for that. And there are certain things that jurors, even though it's beyond their knowledge base, just their eyes. Sorry, someone's home from school. Their eyes don't deceive them, and it's hard to fathom 12 jurors sitting around looking at those videos, looking at the impact, and saying that John O'Keefe had not even a bruise, never mind all the fractures. And I just don't think people are going to accept that. And with all the other problems going on here, I mean, they needed a knockout blow, and I don't even think they came close. I mean, if they lost, never mind carrying the day, I think the needle moved farther to the defense actually establishing what happened.
We'll see when it's all wrapped up. I mean, it seems like there's not, I mean, this is the first time that the judge has ever asked the jury to actually work a longer day than she promised them. Usually she's giving days off at will. And yesterday was, you know, look, it could have been something else other than the heat. It could have been that the witnesses weren't available. Maybe the ARCCA guys were not in town yet. I don't know what it could be. But if she wants to wrap this up by end of next week, I mean, how many more witnesses could the defense have? Let's say we know they have Rentschler. We know, well, if Richard Green was in the courthouse, we assume they have Green. Dr. La Posada,
right?
that's 3.
Um,
Garrett Wing could be 4. Are there any more lay witnesses to come? And then you got rebuttal. So
Probably not. Again, we can, go over this 100 times.
Right.
Why not this? Why not that? Doesn't sound like you're going to see the neighbor from the next door house. It doesn't sound like you're going to hear anybody in 34 Fairview. I mean, it seems pretty clear that they're wrapping this up with experts. That's what it looks like anyway.
Oh, Ellington. There's a guy named Ellington, right? I think his name is Ellington or
Who is he?
Elkington. He's a witness because they made a motion to, the Pens made a motion to not allow his report in or something. I can't remember his exact name, you guys.
Remember,
Ellington, maybe it's like Ellington or something. I'm not sure what his expertise is. Cell phone data, Derek Ellington.
oh, that's right. He's another, yeah. But some of these witnesses could take time. I mean, I think obviously the other ARCCA witness will take at least a few hours. Green, I imagine, would take a few hours. I would imagine Brennan's cross of Green would go on
Right.
for a couple hours alone. So I don't, maybe next week, but who knows?
Then rebuttal, then a charge conference, and then, closing. So I think best case closings would be the following Monday.
I think
Best
so.
case, right?
Yeah, I think
All right.
so.
I'll let
Yeah.
you go because I got 100 super chats to get through, but you got to
Okay.
go. Thank
Take
you so much for coming. We had so much fun laughing with you today.
Yeah, say hi to Randy. Bye.
Oh, I will. Randy's coming with me to Cancun next year, you guys. By the way, Dave Matthews just announced next year's Cancun shows, and I highly recommend if anyone's into Dave Matthews, you should look into getting a package for yourself. And how about that, Randy, everyone? Props to Randy. We've got a lot of super chats to get to and questions. And so let's do it. Hang on. Get rid of this thing. If you're not sticking around for questions, make sure you smash that like button on your way out. Hit the bell. Do all the things. Hit the subscribe button because it's free. And you don't want to miss a minute of this, do you? Legal onlooker, I'm sorry. I saw you put this question in twice and I was going to get to it at the end because I couldn't interrupt the stream, but even before Mark was here because it's a totally different topic. And you asked, why can Lori Vallow file twice to recuse and at least get another judge to review, but not here? The Lori Vallow case that's currently ongoing right now is in Arizona. Every state has different rules. And in this case, the defense did make a motion for the judge to recuse herself prior to the first trial. She's the one who heard it. She's the one who denied it. And so it has been tried and failed in many states. Like I think Florida, we saw Sarah Boone. Was it Sarah Boone who filed a motion to recuse the judge and it was heard by another judge, also denied. She says she's a nurse anesthetist. Considering law school, don't know if I'd be able to deal with crooked judges like that. Well, listen, I'm not saying that she's crooked. I'm just saying that there are a lot of judges that are unfair and they're not going to always rule the way that you want them to rule. And you got to be able to roll with it. You just got to be able to roll with it because that's the reality of the system. It just is. Listen, when I was a young lawyer, and there were not a lot of young women lawyers at the time because I'm ancient. There were judges in Brooklyn who would not allow the female attorneys to wear slacks in the courtroom. You had to wear a skirt or you couldn't come in. When I was a young lawyer in the 90s, I would automatically be seen as the court reporter when I would walk in to do a deposition. And it was the boys club. The old men would be like, the older men, lawyers would be like, oh, honey, you can set up in the corner. And I would say, it's the 90s, women are lawyers too now. It's just the way it is. Is there going to be a calendar? Crash Daddy Dreamin' said Crash Daddy Wolfe for the cover of the calendar. Didn't hear anything about that. Trevor said Dr. Welch's blue paint experiment was straight out of that Jury Duty show. I love that Jury Duty show. If you haven't seen Jury Duty on Amazon Prime, highly recommend. It's awesome. It's heartfelt. It's hilarious. It's like a Candy Camera meets, I don't know, that Ashton Kutcher Punked. It was fantastic. Thanks, Trevor. And this is why the prosecution didn't employ ARCCA, said Gail. Stuff said if she was a non-biased judge, this information would be compelling. No? Well, I think the information is all compelling. It's all compelling. And, a lot of it got in. A lot of it got in today. So what the jury thinks of it, I don't know. But like I said, all it takes is for one juror to think that's a totally plausible explanation about what happened here. His arm broke the taillight. He spun around. The rest of that dummy's body didn't hit the car. But again, we saw his foot get run over by the car and the injuries to the arm would have been no sirens today. You're right. I think only once. The injuries to the arm would have been shattered, but we didn't get to hear that from this witness because that's not his expertise. But Hank Brennan did the best he could on cross, I thought. Bees and flowers, Melanie, you're the best. The feds are not done. Justice for John O'Keefe will come. This is a real expert. Happy to support the Karen Read Legal Fund and stand up for her innocence. You are loved, Karen. Thank you, Bees and Flowers. How long is a rebuttal case? Says RBF Canoni. However long it takes. However, it depends on how many witnesses the Commonwealth calls in rebuttal. That would be after the defense closes its case. And then she did say that she was going to maybe consider a surrebuttal. I don't know that that's ever been ruled on yet. So we will see. I think we're thinking, best case, we're into the week after next for closings. But again, I don't know how much longer. I mean, you see how long Hank Brennan can drag out a cross-examination. He can drag it out all freaking day. It could be like not until the 16th, the week of the 16th, that we could see closings. Also, keep in mind that the 19th of June is a federal holiday. It's Juneteenth, so court's probably closed on that day. And so, I don't know. But she did ask the jury if they could work a full day. She said next Thursday because she had originally promised them apparently a Hoff HOFF day. I mean, if Brian Albert is not really the reason one of the reasons that I wanted to see Brian Albert on the stand is his pronunciation of the word yes. Do you remember how he pronounced the word yes? Yes. Yes. Chloe Albert's revenge. Dr. Wolfe is going to huff and puff and blow Hank's case down. Should be grateful. Now has a bedtime story to tell his grandkids. Are they going to settle for a mistrial, use an excuse to revoke her bail, then find some way to break her? Said Catbox. I don't think they'd be able to revoke her bail. She's out on $100,000 cash bail. I think eventually they did reduce it to 80 so she could get some money back to pay for experts and lawyers and stuff. But I don't think if there was a mistrial, if there's another mistrial, they will not put her in jail. Thank you very much. Go Georgia. Thank you, Maria. Says, I read that the jurors have to leave their notebooks with the bail. They leave them on their seats at the end of the day. Does that mean that the judge has access to all the notes that the jury's taken? No. Not supposed to. Judd Welcher, crash test dummy, says, I've seen a new filing from Brennan to exclude a report from a defense expert. I'm not sure if I have that one or not. Hannah, why is everyone ignoring that Wolfe stated that the glass could have been broken? The glass could have broken the taillight, both inside and out. So the arm experiment means nothing. Well, because it's not the theory of the Commonwealth that anybody threw the glass at the taillight. So I guess that's why. Susie, can defense demand that method of bingo balls method be done? Yep, we talked about that. I think they are going to ensure that this time. Lola the good dog just said that the juror in the first chair is the only one who hasn't taken any notes. I'm concerned. It's very similar type to the foreman from chair number 1 in the same chair. Were any fingerprints found on the glass or cup? Kitchen table juror wants to know. The answer to that is no. I think there weren't enough usable fingerprints. Did they dust it for prints and they couldn't find it? Or am I thinking of the interior of the car? But no, they were not found. Was the glass tested for fingerprints? You guys refresh my recollection. I just know that none were found. Won't Higgins plead the fifth, says Lenita Davison. Well, he'd have to come into court to do it. And so we would know about that. And so he's already testified. I don't know what he would plead the fifth to if he's got anything to be worried about. There were some rumors before the first trial that he had taken a federal proffer deal, but we don't know if that ever panned out. And so he'd have to come into court if he's going to plead the fifth. Shout out to the North Slope, Alaska engineers who are watching today. Kaylee says that her husband is one of them, and that all the guys watched the dummy video on break and they all jumped up and cheered like it was a football game. That's awesome. Boston D's Kelly Dever was working the overnight shift when Higgins came to the Canton PD, wasn't she? Did she see him? Was she asked if she saw Higgins? I think she said that she didn't take the desk until the morning. I think that she said she was on patrol for the overnight shift and she didn't come into the desk until the morning. I could be wrong about that, but the chat will correct me if I'm wrong. Could you briefly explain the reason for the mistrial the first time, specifically the jury instructions? Leroy, that would take like an entire show, but it was a mistrial because the jury could not agree. The jury could not agree on their verdict. They were told, as part of the jury instructions, there were three separate verdict sheets, one for murder in the second degree. Second one for manslaughter, OUI. Third one was for leaving the scene of an accident, causing personal injury or death. 3 separate verdict sheets. The judge told them, do not fill out any of the sheets until you have all come to a consensus on all of the charges. So that's what they did. They didn't fill out any of the sheets. They came back, said they couldn't agree. And then the next day they started calling and saying, wait a second, we actually acquitted her on murder too. And the third count, it went all the way to the U.S. Supreme Court. U.S. Supreme Court refused to hear it. I've got playlist upon playlist upon playlist of all of these issues. And if you're interested in the deep dive, just go to my playlist and you'll find it easily by the title. Thanks for asking. Red's daughter said ARCCA couldn't mention the media, but the media coverage gave Dever false memories. Yes, 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 it did. And, Brennan brought it up with Lucky. Can the defense insist to see the numbers? Asked Lena. Thank you. I think we addressed that earlier. Alice says, Melanie, my husband also loves CCBB. Can you explain why no one has asked for an accident report? What is CCBB? No one has asked for a motor vehicle accident report when one does not exist. They have not called any. Well, one, Yuri Buchanan was one of the only MSP trooper, I think. Right? That was called. And I don't know why. I do not know why. No, Cherry, I don't drink, but thanks for your comment. I think this entire day was laughable. That is why. I don't know why they were not asked on any sort of cross-examination. I've been screaming into a closet for a year and a half that in no way any of the claims adjusters in my chat would have ever paid on this case without a car accident report, a motor vehicle accident report. Legal onlooker to counter signal. AJ, can AJ ask if his phone or in-person communications with lawyers or clients are typically recorded, memorialized to prove what's discussed? I think he covered that, and I think he covered it well. And Dr. Wolfe just said, listen, the case was over. I deleted the messages. Like, what do you want me to do? Sue O'Connell just posted that Jackson was a jet fighter mechanic when he was in the armed forces. That is true. Thank you, Tony. And Legal Onlooker, this was your second same super chat about Lori Vallow. Devin, lifelong Norfolk County resident here. The Aperture 400K could have gone toward our public services, schools, and roads. Shameful. Yeah, it is. Are you outraged if you guys live in Norfolk County and or the Commonwealth? I know. I noticed that too, Anita. I can't get mentioning 26% like it's a discount. I know. I kept thinking that too. Sydney, is Welcher allowed to watch or review this testimony and or data? He has been given the report and maybe the PowerPoint. He's not supposed to watch the testimony under the rules of this judge, but he is conducting further testing to be able to come back on rebuttal. That's a great question. Ferry Raven said, and this was way earlier, this was at noon, today has given me the most hope for Karen in the last few years. Thank you, Ferry Raven from Ireland. Susie wants to know, why is defense spending so much time on this when they believe there was no collision? Well, because they've got to rebut the Commonwealth witnesses. They can't just leave that out there uncontested, right? And so it'll be interesting to see what you guys think. And his testimony is not over yet, so I really don't think we could really take a poll until his testimony is over. But if you guys want a poll, I'll allow it. Captain, where did the fragments of taillight land? Well, nobody really knows where the body was, where the car was, where the impact was. And so we know that the fragments allegedly were found on the lawn near allegedly where the body was. Aaron Carter says they need to bring in Brian Higgins. I really, really would like to see Higgins too, because all the sus behavior, the text messages that he brought in, so many things I would like to hear from Higgins. How is no taillight embedded in the arm of the shirt? Well, they say it was. They say it was in the shirt debris, but there was none in the arm. You're right, Sydney. Chloe Albert's Revenge said it's no coincidence this is happening on D-Day. The defense team is storming the beaches of blasphemy in 2025. Randy was hit by a car, and a car did hit Randy. Well done, Hank's little bulger. The truth shall set her free. Not possible. Pieces of taillight poked through a sweatshirt, caused injuries in a pattern similar to dog bite, claw marks, all while John O'Keefe did ballet moves and flew through the air. Common sense, I know. But here's what worries me. It's about some of the jurors in the first trial thought, well, Karen was there, John was there, she was drunk, and therefore she must have hit him. So I don't know that I would bet on common sense anymore. What's common sense to you and me may not be common sense to somebody else, right? Let's rehome the aperture payments to ARCCA, said Criminal Med. Piney Woods. Also, my hair is on fire with Bev sustaining every objection from Hank. I hope someone is counting. Hank was right to be scared of ARCCA. Go, Team Read. Dr. Russell's gasps. Today is my birthday. Happy birthday! All the way to Norway, right? Are you no? Wait. This maybe is a different Dr. Russell's gasps because we had one. Dr. Russell is a goat. She's from Norway. Happy birthday to you. Crash Daddy Day. Allie Not McCabe says, Hank Brennan, objection. He's telling them everything. Circa Bev and the DA's of office, the DA's office, something a full investigation into their motives to railroad Karen Read and stop justice for John O'Keefe. Yeah, a lot of people feel that way. You're not alone, Circa. Chloe Albert's revenge. I really want Jackson to ask him, does your test dummy have a name? And I want Dr. Wolfe to say Judson Welcher, no relation. But we found out that it's Randy. Amanda had a sneak peek on Aperture website slogan, we exist to shine light on the truth. Oh, that's funny. Eddie and I watching from Scotland. Hi, Amanda and her father, Eddie. Thanks for joining. Rescue Randy is here. Somebody already changed their name to Rescue Randy. It says, I quit. Thanks for hanging out with me for 9 months. Lisa, blue paint is awful expensive in Massachusetts. Check out Lawyer Lee's video last night regarding interaction with ChatGPT when showing its arm wounds. Everyone posts stuff that ChatGPT says, not Lawyer Lee. I don't know her personally. And I'm not speaking about that specifically, but people send me emails and they're like, I asked this of ChatGPT and here's the answer. And I don't know, are we really agreeing right now that what ChatGPT says or is 100% accurate? I don't know. Because when I get like the AI overview and I go into Google and it's not always accurate. So I don't know. All right, hold on a second. Yeah, do not forget that Randy was supposed to be John O'Keefe. Okay, Jacqueline, if you'd like to go watch another creator, you're welcome to do that. And I'm just going to make it that much easier for you. Block Island is so lovely this time of year. Enjoy. See some boarding passes for Jacqueline, everyone. Becky, when Karen's acquitted, Bev and Hank should retire into the sunset together and live their snide lives. Just me, yet Dr. Welcher had no problem giving medical opinions. That's true. He didn't. And the last trial, in trial number 1, anybody who was not a medical doctor, according to Judge Kim Jong Kanone, Lady Bev, under Lady McBev, under her eye, Aunt Lydia, said that no one but a medical doctor would be allowed to opine about cause of injuries. And this time, Dr. Welcher was allowed to. So this time, Dr. Rentschler will be allowed to. And so that is that. Donnie, it makes no sense that John's back would be turned to the Lexus with his right arm extended. Was he hitchhiking and didn't hear the Lexus coming? Yeah, like he wouldn't jump out of the way? I don't know. None of this makes any sense to me. Oh, Tina Lucille says, I actually proved that Google AI is wrong. I know, it's interesting, but I can't take it as 100% truth, right? Grok, all that stuff. People put it out there and they post it like it's truth. And I like receipts. Time to back up and go home, Hanky, says Dr. Wolfe's cute dimples from, I think, is that Ireland? I can't see the colors on that flag, or Italy. I'm not sure. Rescue Randy is going to work for Aperture. I hear they just hug us. Yeah, they do. They hug it out at Aperture and then they drop you on the floor. Led Zeppelin fan said, I guess we know where Aperture got money for the bar event. Also, it's not unusual, first of all. Aperture did sponsor the Commonwealth of Massachusetts Bar Association dinner. Look, most of their clients are municipalities, so it doesn't surprise me if they do that in other states too. That's how they get their business. Welcha, Mikey D's new mascot is a clown. Every special prosecutor objection and Bev sustained equals 1 minute added to the defense closing. Sticky note pass equals 5 minutes added to defense closing. We are well over an hour now. I wish they used that kind of math. Brian, is anyone else afraid to drop a friend off at a party now? Oh, here's another crazy story. This is out of North Carolina. Did you guys hear about this? These parents let their 7-year-old and their 10-year-old go to the store. Like that was right near their house. I think it was only like a block or two away. And on the way home, the little boy ran into the street and got killed by a car. And the parents are now being charged with manslaughter and are being held in jail on $1.5 million bail in North Carolina. And the driver of the vehicle that killed the child is not being charged. What kind of world are we living in right now? I don't know. Did you guys see that? I have to cover that on an off day. Doobie's Dragon, Welcher confused reconstruction and reenactment. That's kind of funny. Kat says the Commonwealth has been consistent with being inconsistent. Yeah, that's about the only consistency that I see. Yeah, Jessica, it's in North Carolina. And there hasn't been a lot of information about it. And I tried to find, right, like is a 10-year-old not old enough are parents not able to make the judgment that their 10-year-old and 7-year-old can walk home from the store? And then an intervening act happens that has nothing to do with the parents. And welcome to North Carolina. Yeah, I mean, I get it. I mean, I get it when it came to like the Crumbly thing. I even had issues with the mom being, but whatever, that's different. This is like kids crossing the street. I mean, how far are we? Slippery slope is what I said when I was covering Crumbly, and here we are. But back to Karen Read. Stacy, can the Commonwealth currently speak to and re-prep their experts who they are recalling? Or they're still considered under oath and they are sequestered? And no, they cannot. They cannot continue to prep them. Paul with his chain peg in Paul's mind. Yeah, I'm not doing that, Paul, but thanks for your super chat. Just don't read them. It works for him. Stephanie. Commonwealth had Tommy Boy in a nutshell as experts. Dawn says amazing. Thanks for your coverage. Thanks, Dawn. Kim, if no holes or punctures in the sweatshirt, then no fragments could be found in the sweatshirt planted by Proctor. Do you think it's important that the jury hears from Proctor? I want to know that from you guys too, especially if you were, I know I used to walk home in kindergarten too. It was a different time, I guess. Different world. A lot of parents need to work these days. A lot of families come from 2-parent working households. Not all the moms and or dads can stay home anymore. Chris Moore, now get a cop dog trainer to put a hoodie sleeve on the pad and compare it to John O'Keefe's. Yes, yes. Carrot Wing is coming to save the day. Brian, thank you for your $100 super chat. You are so generous. Is it sad that it's a divine comedy now? Death, betrayal, corruption, and YouTube. Yeah, well, that's the thing. It's Shakespearean in nature. That's why sometimes I call her Lady Macbeth. And, sometimes we had to laugh about Rescue Randy, because if we don't laugh, we're just going to cry. Like, this is where we are. Thank you so much. Brian. Truth Seeker, thanks for your 20. Camille, thanks for your 50. Super generous. Still behind, started crying when the Wolf Man, old radio host, displayed equations in relationship to the laws of physics. The math is mathin' due to the scientific method that any high school grad would understand instead of magical math. Yeah, this Common Core math is like, I don't understand it. Thank you, Camille. You're super generous. Jeff, Spanky's MO is to try and make the witness look incompetent because he has absolutely nothing else. Good luck with that approach when crossing ARCCA. Zach, Essex, UK. Wasn't the federal grand jury in the summer of 2023? And Dr. Wolfe said they did their initial testing in late 2023 to early 2024. So this information couldn't have been presented at the federal grand jury. I don't know if it was. And we still don't even know what the grand jury was convened to investigate. We don't know the results of that grand jury. We do know that some of the witnesses, the lay witnesses in this case, and the law enforcement witnesses were summoned to testify, but the ARCCA witnesses were not. And so I don't know how long that federal grand jury went. It could still be ongoing. Sometimes federal grand juries sit for, it could be a year or more. So we don't know. But that's a great question. But I think some people said they testified there in 2020. I mean, chat, help me out here. I'm conflating. My brain is mush. Has it been disbanded, the federal grand jury? I don't know if we even know. Kat says, I bet ARCCA did not charge Karen, but for their time. Well, he said only 50 grand. Zach, that's a great question. Hopefully we can get an answer to it. Glamasu says the first date of the federal grand jury that I'm aware of is early April of 2023. Right, but didn't it go through at least like January 2024? Loving Crash Daddy Friday. Thank you, Mel. Thank you, Sinbad. Bubba Hodge. Fun fact, Lexus stands for Toyota's Luxury Export to US. Oh, LEXUS. I had no idea. Thank you. See, we learn lots of things here. It's not just comedy and legalese and analysis, and we also learn fun facts like that. So you'll be really good at Trivial Pursuit too by the time this is all over. Yeah, look. Aaron H says my uncle was on a federal grand jury and it lasted for 2 years. There you go. Kat says, I don't care. AJ, ask him if he was hired by an insurance company. He did. In the end, he did get that in. So yay, yay. We all wanted that. We've been saying that for a long time, all day. I've been saying that, and mind meld. It got in, and he said no. How is the use of signal relevant to the test that he did? It's not. It's not. They just want, Hank Brennan was grasping at wet paper straws to try and show bias. According to Sue, jurors have their arms crossed, said Andrea Clark, and that was at 2:05. That's interesting. Michelle said during defense questioning, 46 objections, all 46 were sustained insanity. Thank you, Michelle, for keeping track. You're amazing. How does one get put on a grand jury? APB wants to know. APB, Bolo, Bev's grave concerns. You would get called in for federal jury duty, and you can get put on a grand jury, but that's a big commitment. Some grand juries like that meet like once a month for an ongoing period of time. So you wouldn't get put on it. You'd have to be called for jury duty and then selected. David James, Dr. Wolfe, I realize my experts like to play dress up, use paint, and have associate's degrees, but can we focus on signal? Yeah, exactly. Hang on. Let's take a look at some questions that came in through Venmo. I'm sorry, guys, these are from this morning, but it was Miranda. Thank you. What are the Yiddish words in your theme song? Fakakta and Mishigas, but the voice that says Mishigas pronounces it wrong. So that's what it is, Fakakta and Mishigas. Look it up. It's like a mess. It's like a mess. Fakakta is like all crazy, and a Mishigas is like a big mess. Marie says, did you tell your kids you're not a cupcake? You can't make everyone happy. Yes, that is my exact, I have like a sign over here that says it, a pink sign. It says, and it was my mantra when my kids were little, you're not a cupcake. You can't make everyone happy. That's where it comes from. That's why you guys are the cupcakes, because you make me happy. And hopefully I make you happy. So there's that. Thank you, Jessica, for thanking me. Jonas says he was going through withdrawals yesterday. Thank you so much. Michelle wants me to look at something. Thank you very much for your Venmo. Zargo, motion to ask everyone watching to donate even $1 to Karen's Defense Fund. Karen's team is doing incredibly important work, shining a light on the darkness we now know. The darkness we know is the Commonwealth. Thank you. Thank you, Zargo. And the Karen Read Defense Fund link is in the chat notes, the show notes below this video. You might have to close out your chat if you're on your phone. Thank you, Craig. What, if anything, are we going to do when this is over, if ever? Well, the civil suits will keep us busy for a long time after this. So don't worry. There's always content. There's always things to talk about. But I like the way you're thinking, that you want to stick around. And, it's going to depend on public. Whatever you guys want to cover next, I'm here for. Give the people what they want, as the Kinks used to say. Kathleen, thank you very much for loving my analysis. Oh, Juicing Recipes Instagram page that I mentioned earlier. Her name is Tracy, and her Juicing Recipes Instagram is, happy to shout her out. Let me see. It's just Juicing Recipes with a little check mark next to her name, and a pretty blonde girl. Her name's Tracy Sloan. in the profile pic. So thanks for asking, Tara, and thank you for thanking me. Thomas, if you threw the cocktail glass, it would have been found on the street, not next to his body. Joanne, thank you. Way to explain when needed. Melissa, thank you so much. Chris, very generous. Thank you so much. You do such a great job on the trial while staying classy. Great work, and ARCCA just gamed over this. No? I don't know. Mark didn't seem to agree with me, but I said all it takes is one juror to believe that that could have happened. And the way that Hank Brennan slowed down that video, all it takes is one juror to hang a jury. I don't think, based on the public division in this case, that people who think that John O'Keefe was not hit by a car, I don't think you're ever going to be able to convince them that he was. And people who hate Karen Read and want to see her stoned in town square may not ever change their minds either. And so that's the thing. It's so divisive, and all it takes is one juror to hang a jury either way. So I don't know what's going to happen here. I wouldn't put money on it. Thank you, Chris. That's very generous of you. As Donna, again, another very generous contribution to the channel. Your input is so appreciated. I couldn't make it through this mess of a persecution twice without you. Thank you. I know, twice. We're doing this twice. Right. None use your business. Another great username says, don't underestimate peer pressure. Had an impact the last time around. Allie, thank you. She says she enjoys watching the trial with me. Kathy and her husband love watching the trial here too. You guys are amazing. John says, is Randy an African or European swallow? Love the holy references. Thanks for making this week a pleasure. Thank you guys for watching, because without you, I'd be just sitting here screaming at my TV, throwing cocktail glasses at it. And it would probably smash it. And Leslie says, I went to Cancun with Randy. That's hilarious. Betsy, rescue Randy for the win. Rescue Randy. Andrea's in here saying, hashtag free Randy. Chrissy Young says, will you add George Michael's Freedom to your playlist if not already on? I got to wait until there's an acquittal. I think I do have George Michael's Faith on there, Chrissy, but I'm not putting the Freedom on there until we have the magic words read aloud in court, not guilty. Thank you. Thank you. She says she can almost taste freedom. Thank you, Lynn, for thanking me for the laughs today. Oh, that was very fun having Mark Bederow on here laughing with me. Some people seem to have been offended by that we were laughing at such things that should not be laughed at. But listen, sometimes you got to laugh or you're just going to cry all the time. And thanks for your matcha latte. Just had to watch Crash Daddy with you again. Hopefully there's not a third time, though. I agree. Massachusetts has been known to try people 3-4 times. Just so you know, for now, I'm going to just tell you, I'll be with Billy Bush on Monday on his 5 o'clock live show. David James, Dr. Wolfe, I realize my experts like to play dress up, use paint, and have associate's degrees, but can we focus on signal? Yes, I think I read that one already. Well done. Laughter is good medicine, right? What civil suit will happen, do you think? Well, Karen Read is being sued already by the O'Keefes. John O'Keefe, Sr., Peg O'Keefe, Paul O'Keefe, and the niece are suing Karen Read for wrongful death, and they are also suing the Waterfall and C.F. McCarthy's. I have that in a separate playlist below if you'd like to go over the papers on that. And also, that case is currently stayed pending the resolution of this criminal case. So Karen Read is not being forced to give a deposition. Nitka, 2 words, Shannon Burgess. I think you denied forever. Janet, it was refreshing to see on Wednesday that Karen connected socially to the pharmacist lady. Makes sense to me. They completely missed the drama going on with the rest of the crowd. Also, these are 2 women who work outside the home. And I think that they could not relate to some of those other women because they did not work outside the home. It's different. No shade. It's just different. Women who work and have careers don't have the same interests perhaps as the stay-at-home soccer moms. I don't know. Tell me if you think I'm wrong. Hannah, sorry, I know no super chats now. You don't have to read this, but Hank is arguing Wolfe should have used a human arm. Is he volunteering his arm? I don't think he said human arm. Didn't he say it just should have weighed the same amount as John O'Keefe's arm? Did I completely miss that point where he said you should have used a human arm? We know that Welcher used his own human arm, but only at 2 miles an hour. Nikki, potato gun was used during trial 1. I guess it was, but I just didn't know if it was a real thing or if it was like a made up thing. AJW says, boss ladies, if you know, you know. Yes, Peter Murphy does go to the buffer zone almost every morning. I know Peter Murphy. He's a great guy. Circa, please stop being a bev. Brian, Hank, Jenner, and Common Karen. This is a great podcast with a beautiful attorney explaining the depths. Well, thank you so very much. I appreciate you. Charlene, why is he allowed to continue to talk about the last trial? Didn't Jackson get in trouble for trying to with Jen? It's infuriating. Well, I mean, look, it's out there now. I think he's not really doing it intentionally, but the jurors are all from Norfolk County. And if they didn't know there's a first trial on Karen Read, they're living under a rock. And do you really want them on your jury anyway? And it was okay that they knew about the first trial. They were weeded out during jury selection. They just couldn't have any inherent bias or any feelings toward one side or another. They had to be able to keep an open mind. Rico said he's trying to confuse them, master manipulator. Looney Tunes, Crash Daddy's composure dealing with this. Sorry excuse of an attorney is impressive. Yeah, it was. He smiled through the whole entire thing. Did he get upset at all? Did he get upset at all, Dr. Wolfe, during this? I don't think he did. I didn't see it. Yeah, did Brennan tell his expert he should have used an 11-pound arm too? My job depends on this. Thinks that he's the biggest clown loser to ever enter a courtroom. Nico said it's a formula, not just math. Doesn't matter. I'm not an engineer or a scientist, so I'll defer to those of you. I know there's a lot of engineers that watch this channel, so I'm happy to hear from you guys. If a tree fell in a forest argument, says Misanthrope. Max Bang, Hank said one true thing today. I might be on an 8th grade level here. Yeah, I did hear that too. And we were trying to get through it, so I didn't want to stop. Yeah, the wife jab made me angry too when he started bringing in, that's right. I think that did make him a little bit angry too when he said something about his wife. When he said, don't you have any relatives that have feelings about this case or one side of this case? And Dr. Wolfe said, you mean my wife? And he kind of backed off about that, but he kept his composure. But that was the only thing, I think, right? Jess, how many judges would allow this to continue? Listen, the district attorney, many people say, never should have prosecuted. Many district attorneys never would have prosecuted. Not only did they prosecute, they upgraded her charges from DUI manslaughter to murder after she didn't take a plea because, she takes a plea, it's over. If not, it's a whole new episode. And boy, did we see a whole new, we're in the episode now. We're in season 2, episode 28. It's like the longest episodic season ever. I mean, even like Law and Order only had 23, 24 episodes a season. Jess, how many? So yeah, the answer is he's combative toward Wolfe. If this doesn't make him unlikable to the jury, I don't know what will. Put some, if you guys were following Twitter and the jury reactions, and you can put some of their tweets in the chat if you like, and I'll see if I see them. Veronica, truly in real life, you have to actually be in contact. I had to take a nerve pill. Marianne Young, I love when Hank tries to act all smart. He thinks he's all that. He isn't even all there. Kindergarten cop. Okay, this is a joke, so please don't report that I'm reporting this. Says, I can't even read it out loud. It's funny, but I can't read it out loud because people will be like, Melanie is reporting this, and I can't, but it's hilarious. Golden Fire says, Brennan reminds me of Templeton the rat from Charlotte's Web. Paul Lind. All right, can you create a rat for questioning like this? Oh, maybe. I'll see. Any word from the inside? How's the jury doing? That's what we were just asking, J.R. Cuber. What were Randy's educational qualifications? Amon says we need a pic to go in the corner of the girl who was in Poltergeist with her head spinning. Yeah, Carolyn. Chef's wifey, welcome. Correction, Exorcist. Yeah. I know who you're talking about. The Exorcist, that was Linda Blair, but the other one was Carol Ann. Come into the light. Daniel Wolfe's dimples. Thanks. So jealous. Is moving the goalposts in mid-trial good strategy for a prosecutor? No, they did it last time too. Season 1 in opening, they said the collision, the car accident was at 12:45, and then as the Evidence morphed, as did their theory, by closing. I think Lally said 12:30. So not good strategy, but the last jury was hung. Thank you, Kelly Mack. Does Randy come with insurance? Heartless Soul wants to know. I got questions. Thank you. Thanks, Mom of Klaus, for your super sticker. Veronica Truly, thank you. E.L. Carson, I don't know if Randy's wife posted a free Karen retweet. Are the jurists chuckling like you and Bederow? I don't know. I want to know. Did Larry have trouble keeping his composure? Larry, DUI guy, was there. Kristen, 2:24 a.m. Hosslong to freeze a dummy. Sweet Jane, Randy is not too dandy at the moment. Randy deserves a weekend at Bernie's. I think it's so fun. It's one of the funniest movies ever. Hank is obsessed with me, says Randy's suspended gravity. Thanks for tuning in from across the pond. Better with the Irish says free Randy. Stephanie Flynn, South Park, OMG, you killed Randy. Thank you, Sweet Jane. Randy has more brains than Hank, says Lindsay Heath. Thank you, Lindsay. Jack, next trial, Commonwealth charged the stunt driver with unaliving Randy in a drunken rage. You could see it all the way from down under. Justice for Karen and Randy, says Heartless Soul. Playlist Defying Gravity in honor of Randy. Thank you, Kelly. Thank you for your super sticker. Melanie's regenerating head for pop-offs. Well done. Thank you, Harry Potter's beard. Bev's Corruption Chronicles. Love watching and listening with you both. Love your take on the case. Much respect for you both. Absolutely love the humor today. Free Karen Read. We had to do it. We had to. Thank you for your super chat. Daniel Wolfe's dimples. It's sad that John's dad is not there today. I don't think he's been there much at all. Hank is asking all the questions so the jury thinks on this over the weekend, says Denise. But I think it was good that it ended in redirect, and he's still coming back on Monday, but it's out there that ARCCA was not hired by an insurance company. Hey, it's me. I'm afraid I have to hope. I'm afraid to have hope. I think the jury will be confused. Please talk me into hope again. Well, it ain't over till it's over, right? It ain't over till it's over. Hey, it's me. And so keep clinging to hope. I wouldn't put money on it, but my thoughts are hung jury. I just don't see how 12 people are ever going to agree to convict. If anything, an acquittal, but I just don't see 12 people agreeing on it. I don't know. I just don't know. I hope to God she's acquitted and this is over, because we know that if it's a hung jury, it's happening again. And it's insane. And I don't know if I can do this again. Can you? Thank you, Rescue Randy, for gifting a membership, changing your name. Randy needs Morgan & Morgan. What do you guys think? Let me know what you think in the comments and in the chat. Randy is the crash test dummy. Tell me you just got here without telling me you just got here. Mary, how many people have drug backwards at 24 miles an hour? Right. I think in order to close this loop on Dr. Wolfe's testimony today, we have to hear from Rentschler, because they go together. One is about the damage to the vehicle. The other one is about the damage to the body. Right? Tammy, aloha. Aloha, bear hugs to Karen and poor Randy. Set them free, Lord. At least you're holding up beautifully well. Her ohana is a big part of that, right? Tammy? Welcha, do not inhale the smoke. Brennan is exhausting. Will knock out valuable brain cells. More like nitrous at this point. We need a GoFundMe page for Randy, said M. Monge. The dusty truth. 9 or 12 pounds is insignificant regarding a collision with a 6,000-pound vehicle, right? And I think that also came out on redirect, and I think that was a good point. All things considered, that's not a 26% difference. Thank you, Dusty Truth. Are you an engineer? Or an accident reconstructionist? Marianne, we need to GoFundMe for Randy. Thank you. Brennan's dream date. Randy. Mama Shea, you changed your name. I love it. Thank you for your generous cash app the other day. She loves my laugh. It was funny. It was funny. Not funny like ha ha. It's funny like crazy that we're here. And then like, how do we even explain it? How would you even explain this to somebody that didn't know anything about this case? I had to do that the other day when I went on WPLR 99.1. Chaz and AJ in the morning show, and they said, can you do like a quick 30-second overview of the Karen Read case for anyone who's not familiar with it? I was like, I'm sorry, what? But I think I did a pretty good job. One of these days when we have some time, I'll play the segment because they actually sent me the segment. If you don't get 99.1, it was fun. Michelle, current on cross, 1 objection overruled, 6 sustained, 11, Bev allows it, 4, ask it differently, 4, can you answer, compared to 46 with the 46 sustained by Jackson. Wow. Wow. Thank you, Michelle, for being our resident statistician. Even if you don't want that job, you have now been anointed and you're doing a fine job. Dawn, someone needs to order Randy a Cancun t-shirt. Oh my God. I have a great, okay. All right. I think I still have that thing in the garage. We used to have one of those dummies that we would dress up for Halloween and put on the porch. And now I just have to find it and put it in my sweatshirt. Okay. I've got a great idea. Thank you. We're all mad here, says Wolf, and heads will roll by the yeahs for the playlist. Thank you. Randy's ex-girlfriend from 20 years ago was in the courtroom. What does it say on her necklace? Just an observer. What does it say on Randy's ex-girlfriend from 20 years ago? What does it say on her necklace? That's what I want to know. Catherine, Man Wolfe is trying so hard not to smile. Brennan is a first-class ass. Not enough words. Welcha, where's the hat? Everything else is in plexiglass. Where's the hat? They have not shown it in evidence. Did they not bring the hat into court? You know what they don't have is the socks. I'm still screaming about those socks. Where are the socks? How dare you, says, if Randy and Trooper Paul are brothers, I'm wondering if Hank is related to the brothers Grimm. Amy said, if he went into the house with the glass and attacked him, if he went into the house with the glass and they attacked him, the glass likely broke. They probably took it out to get rid of the evidence and planted outside, DNA. Also, if he did go into the house, whatever came in with him, if he brought it in with him, would have to go out with him, right? To say that he never went in the house. So that's just common sense, Amy. And I agree with you. Hannah says, Randy's wife's name is Debris Field. I'll allow it. That's hilarious. You might have won the chat today. Very funny, but there's too many good comments to even count. We got to make a Randy picture maybe for the screen corner. Yeah. Stephanie says, Randy looking for compensation due to unsafe working conditions. Will Mark Bederow represent? No, he's a criminal lawyer, but I see where you're going with that. Hannah, Randy is suing the Commonwealth and Brennan for defamation. Rescue Randy needs to GoFundMe, heads everywhere. Can Chloe bite Randy to check for scratches now? Roadkill Randy said. Kelly Mack wants to know, was Welcher formally introduced to Randy? Oh, yes. After formal introductions. I'm sorry, Crash Test Dummy. I did not catch your name. We haven't been formally introduced. Can you tell me your full name? Alessi's Cross Punch is here. Hi. Brian says, imagine accelerating that fast in reverse on purpose, mind you, within a small part of a front yard. I couldn't do it if I tried. I know. That was absolutely a stunt driver. Was that even pointed out? That whoever was driving that car, don't try this at home, kids, was a stunt driver. And Karen Read did not morph into Mario Andretti that night, did she? And also would have hit Higgins' Jeep. That's why I think they also need Higgins to put his Jeep there. Because if she went backwards 87 feet, I forget the math now, but I think it was like something like 50-something feet, hit him, and then continued another 37 feet. So whatever, 53 and 34 feet to, it was 87 feet in total. She would have hit his Jeep. Right? So the only one putting the Jeep there right now is, I think, Jennifer McCabe, right? The Jeep and his phone, right? And bringing in his text messages and bringing his lawyer's office, all that stuff. Hannah says Randy prefers life with Trooper Paul and pirouettes. Plot twist by Carrie. Randy is being called Monday to testify. Heartless Soul, what is Randy's rate of pay? Does he get hazard pay? Mark, forgotten public announcement. No Randys were harmed in the making of this presentation. Yeah, they forgot to do that. Roadkill Randy is here. Oh no, Randy did a pirouette. Does this mean it's case over for Karen? Did we just prove Trooper Paul right. I know, that's what I was saying earlier. Trooper Paul must feel just a little bit validated today. And really, when Trooper Paul's theory might have made a little bit more sense than Welcher and Shannon Burgess's, I don't know. You tell me what you think. Hannah, Randy's wife, Debris Fields, would respectfully ask Brennan to keep the name of their son, Deformation Fields, out of his mouth. Yeah. Hilarious. Nice spending the week with me. Thank you, Patricia. Rescue Randy's compound fracture. Mic drop testimony from Dr. Wolfe. ARCCA's thorough testing of the alleged vehicular accident sideswipe does not fit the Commonwealth's narrative of the hit. They must acquit. Thank you. I see you changed your name to Rescue Randy's compound fracture. Well done. Grace, motion to add Short People by Randy Newman in honor of Sir Randy and the itty bitty crash dummy arm. Thank you, Grace. Dennis the Menace, where's our favorite court officer? I didn't see Eugenia today. Did you see Eugenia today? We love Eugenia. Lena, I could feel and hear Hank's anger in just how he was turning his pages. Yes, you can. He's very emotive with his binder clicking as well. And he moves away from the mic when he knows that he's going to say something that he's probably wrong about. Something like his distance from the mic is directly correlated to blank. You tell me. He's one angry elf with Dr. Wolfe. Nick Sorrow is here. Hi, Nick. Let's play Brennan's game and add 25% of weight to everything. Dr. Wolfe, as Brennan suggested, please make the Lexus an 8,000-pound SUV. Brennan, objection. Bev, sustained. I know. This is like insanity. What are we doing here? What are we doing here? The link on how to join is, I think, also Kindergarten Cop in the show notes below. If you're on, so you can click on that link. But if you're on an iPhone, you have to go into Safari and go into YouTube through Safari. It's like a whole thing. Christine, come on, Hank. They will give Randy back to you in one piece. Don't be a sissy. Thank you. Terry, can defendant consult with ARCCA about rebuttal testimony? No, they're still under oath. Lieutenant Pez dispenser Tully super sticker. Although, wait a second. I have to wait. I have to retract that, I think, because if the prosecution witnesses, Welcher has been given extra time to do extra testing and then render his report. So that report would be turned over to ARCCA to do their rebuttal for their rebuttal testimony. Now it's unclear to me whether or not they'd be able to prep them again. My gut says no, but they'd be given the report. You know, again, we're in uncharted waters with a lot of things here. Lieutenant Pez dispenser Tully. Siobhan says, I can't believe he brought Dr. Wolfe's wife up. Purple Wave, when she's found not guilty, can you add I'm afraid by violent femmes to the playlist? Yeah, we have a whole bunch of songs for after the acquittal. We're just piling them up. Are alternates present to watch the entire trial? Yes, they have to be. Roadkill Randy, do we know how many drinks Randy had? He looked a little loose and unsteady on his feet. Pamela, I'm a little behind. R.I.P. Randy. Oh, poor Randy. When do you go over jury instructions, please? And thank you. I have the proposed jury instructions. I don't have time to do it today. I don't think I'll have time over the weekend because I have the things I have to do. We will go over the proposed jury instructions sometime before the charge conference. The charge conference will not be until before closings. So we have plenty of time. Thank you, Rico. Hatley Howard, insurance would totally pay this claim just under the homeowner's policy as a dog bite claim. Yeah, but that would be the Alberts homeowner's claim. And the dog bites didn't kill him. Something else killed him, right? So maybe they didn't want an insurance claim. That's why they didn't call 911. I don't know, but that's a good point. I'm smarter than Brennan, by the way, says Roadkill Randy. TG from SB. Can Dever be called back for lying? She absolutely is related to Matt McKay. I can't give any of this legs to any of this stuff because I am a fact-based channel. I'm a lawyer. I need to stick with the facts. There's Twitter rumors out there. She also went to school with Chris Albert and Berkowitz. She lied in hostile. There are receipts. I don't know. The answer is, if they can prove it, they could call her back. I mean, the fact that she was called into the Boston police commissioner's office at a very young age by herself and told to do the right thing with a wink and a nod is sus as hell to me. But I can't comment on any potential relationships to anybody because I just don't know the truth of it. I don't like to spread rumors that I can't prove. Pierre, I've been watching and listening all day. Thank you for covering this. If they can do this to Karen, they can do this to you. It's so important. I know. I've been saying that. Karen Read is you. Karen Read is me. Karen Read is your sister, my sister, your wife, your girlfriend. Karen Read has had the money to defend herself and had donations from kind people like you to support her defense fund. But if Karen Read didn't have money and 401ks to liquidate and a house to sell and savings, she would have been sitting in the Norfolk County pokey since January of 2022, and she'd still be there if she couldn't make the cash bail. So think about that. James, in my opinion, the defense has come closer to proving their side beyond a reasonable doubt than the Commonwealth. I have a pretty complete story from the defense. Thank you, James. Hubert, why no accident report? Why no photos of the car? Why no investigation that morning before the storm hit? Right. Well, they did some. They didn't find any giant pieces of red taillight. That's the thing, right? Why no crime scene set up? Because the original law enforcement pals for decades, disgraceful. Thanks, Mel. Enjoy the weekend. Right, Hubert. And I know that you're local. And that is another reason why I really, really think that they should call Lenk. Because Lenk had close family ties to the Albert family. He was their Ray Donovan. He was their fixer for decades. And he was one of the first on the scene that was allowed in the house, right? I don't know. I feel like there's some more dots that need to be connected here more dots than the experts can connect. Tell me what you think. Lenka's deep ties. Judd Welcher crash test dummy. Proctor testified at the federal grand jury in February of 2024. Right. Okay. So yeah, it was going into 2024. I'm not crazy, right? Thank you. Rescue Randy's compound fracture. Aperture is like the cops from Cheech and Chong's Up in Smoke. We do have Cheech and Chong's Framed on the playlist. Thank you for reminding me. And that's a very funny comment. Argument, assassin, Alessi. It's not important to keep hammering that polycarbonate is highly impact resistant. Won't crack easily, not shatter if hit by a human arm cocktail glass. Thank you. Christine, best chat ever. I needed the chuckles. Rescue Randy for Canton Mayor. Can defense ask same stupid questions to Welcher on cross? Casey, thanks as always for your coverage. Thank you, Casey. Monique, I'm beyond grateful for your heart and your time. Please take some time for yourself and have a wonderful weekend. Big hugs and love to you. I know I got to get off soon because I haven't eaten like all day. I tried to eat like a protein bar and I've been talking all day, so I'm getting dizzy. So we're going to need to wrap shortly, but I want to thank everyone personally. Chloe Albert's revenge. Hank gets so caught up in winning the argument, he turns into Daffy Duck. Thank you so much. Bang, bang. Tabby, do you think Brennan is creating more reasonable doubt for the jury with his crazy questions? Maybe. Hi, Mom. Love you, says Tabby. Mr. Reed's paint tape. Alan was making a great point about the shards and speed they flew, and none went into his clothing, scratched him, and flew out. Correct. Lady Gem, for my birthday, everyone give Melanie a big thank you for her excellent coverage and dedication to the gallery. Happy birthday, Lady Gem. Happy birthday. Second birthday in here so far today. Catherine, he's nasty. Defense witness is super intelligent. Out of his wheelhouse. Therefore, he needed to use that condescending tone. I think you were picking it up. Strong legs. The only thing hypothermia in this case are the ARCCA taillights. Go road rash Randy. Taillight bites. It's almost like none of Hank's magical hypotheticals work because the collision didn't happen. Thank you, Arden, for your 10. Nick Starro, cough. Yours truly is a labor and employment jurist. I will represent Randy. Awesome. Awesome, Nick. Nick has stepped up. He's going to represent Randy. What's his name? Rescue Randy? Randy to the rescue? When Brennan says over here, it makes me livid. I know. Over here. Eyes over here. I know. Gross. Thank you, Hannah. Rescue Randy's Twitter account is anti-due process troll. I'm heartbroken and going to change my identity now, says Rescue Randy's YouTube name. It's been good, fam. And I love you, to Brieffield. Well done. Well done. Everyone smashed the like button. We had over 24,000 people in here for most of the day. And it's, it's a nice and kind thing to do. Tammy, thank you. I'm wondering how long Brennan was going to use Randy to try and confuse the jury with his Blankety blank repetitive questions that Dr. Wolfe answered respectfully. Yes, he was very respectful. He kept his cool like so many people might not have. And so, you know, there's that. And that is a good thing. 7,000 of you at least have sent me emails that I will read. I do not respond to all of them. I just can't be your pen pal. Yeah, you didn't like that question either? Yeah, WTF is that? Thank you, Kara, for your matcha latte. Says recently discovered your channel. Thanks to a friend newish to the case. Thank you. Thank you for taking an interest in this case because a lot more people are paying attention to this case than were during season 1. And so I'm glad the world is watching even more so, I think, for season 2. And it's important because it needs to get out there. You know what I'm saying? Picking up what I'm laying down. Okay, I gotta wrap. I'm getting dizzy from lack of food. So thank you, M. Munch, for the final super chat of the day. It's like waiting for the Super Bowl. Now I have to watch the Red Sox. Thank you, mods, because you guys are amazing. And we've been here for 8 hours, 3 minutes, and 58 seconds. This is the full-on commitment. This is no joke what we do here. You know, we go way back, says Blackbird. But why not celebrate a milestone? Happy 1 month anniversary to you too. Blackbird singing in the dead of night. One of my favorite Beatles tunes. All right. Thank you to the moderators, because without the moderators, I mean, this is a very hard job, and you guys are freaking amazing, and I love you with all of my heart. I don't see you soon. I'm gonna die. But I will. I'll see you Monday morning. And maybe I'll land somewhere tonight. Who knows? Is Bederow going anywhere tonight? Anybody want to stay cool, stay kind, stay classy? Please do all the things that YouTube likes. Hit the all the things, all the buttons, all the things and stuff. I'm getting really loopy now. Stay cool, stay kind. I love you all. I love you all with all my heart. And I love so much spending my day with you. And I'm so grateful for each and every one of you that chooses to spend your day with me. Please comment respectfully and let me know what you think about today's testimony. Understanding, of course, that Dr. Wolfe is not yet done. He will be back on Monday. Praise be under her eye. I'll see you soon. Good night.